Hello friends, and thank you for visiting the SEDM website and watching this video training on citizenship and sovereignty. Citizenship is the most important legal subject you can learn as an American, so we encourage you to please pay close attention to this presentation. This presentation is brought to you by Sovereignty Education and Defense Ministry. You can visit our website on the web at http://sedm.org. Here's our logo. This course summarizes the content of the following documents, which you should read if you want to study the subjects it covers in greater detail. Why you are a national, state national, and constitutional but not statutory citizen. Form 05.006, which you can download from our forms page, and Know Your Rights and Citizenship Status, Form 10.009, also available on our forms page. If you want a copy of this presentation after viewing the course, you can download it from the SEDM forms page as Form 12.001 or our Liberty University as Item 2.2 at the website location indicated. And now an important disclaimer. Information appearing in this presentation is educational in nature. Everything presented is based on thousands of hours of scriptural and legal research, review and use of the resulting research by over 1 million people who have visited and are currently using the SEDM website and the Family Guardian website, and continuous feedback from our several readers that have improved the quality of the information over time. If you find anything inaccurate in this presentation, our member agreement, Form 01.001, makes it a duty of all members to promptly bring the error to our attention with supporting evidence so that we may continually improve our materials. Your evidence must be completely consistent with our presentation below. Reasonable belief about income tax liability, Form 05.007, available on our forms page. The application of this information to your specific legal circumstances is entirely your choice and responsibility, and the information presented is copyrighted and subject to the copyright restrictions found on our disclaimer page. And this disclaimer is the same disclaimer as the U.S. government uses. See Section 4.10.7.2.8 of the Internal Revenue Manual. What this course and we are not. We do not claim or advocate that we are any of the following: sovereign citizens. Being sovereign and being a statutory citizen at the same time is an oxymoron used mainly by morons. We don't claim that we are sovereigns. God is the only sovereign. We don't claim that we are sovereign. God is the only sovereign. And any other label or stereotype you may want to put on us that would allow you to evade discussing, learning, obeying, or enforcing the law, which is our main goal in this presentation. If you simply can't resist giving us a name or a label so you don't really have to think, learn, or exercise responsible citizenship, then you are a terrorist who needs to be prosecuted for hate crimes. Minds, like parachutes, only work when they are open. Bigots deserve to be government slaves and slaves of their own ignorance and the bigotry that perpetuates it. For more information on this subject, see Rebutted Arguments about this website, Form 08.011, Sections 5 and 7.1 through 7.3, available on our forms page. So let's begin our presentation. There is much confusion in the freedom community about citizenship and sovereignty. We need to be clear about the terms we used to clear up this confusion before we can move forward as a community, because the government loves to keep us confused and fractured so that we don't become a threat to their feudal tax system. We aim to clear up most of that confusion in this course and show you how to apply this information to real life. And you will never learn what we are going to talk about in public schools because the government doesn't want you to know. Understanding these concepts is essential in your progress toward being a free and sovereign ambassador of God, who is the only sovereign, and will save you literally thousands of hours of tedious research, and will prevent lots of arguments with your freedom-loving friends, and will allow you and your friends to focus on much more important issues like getting your families educated and protecting your assets and your constitutional rights. And here is an outline of what we're going to talk about. We'll talk about sovereignty, introduction, origins of sovereignty, sovereignty and delegated powers, how you lose your sovereignty, and sovereignty and jurisdiction. Next, we'll talk about words of art, and then what is a state, natural order, rights, which includes introduction and rights versus privileges. We'll talk about law, the two classes of law, public law, equal protection, private law, deception by confusing private law with public law. Next, we'll talk about consent, government, the separation of powers, the Constitution, the USA is a republic and not a democracy, the two political models, the federal zone, police powers, extraterritorial or long-arm jurisdiction, residence, domicile, federalism, sovereign immunity, taxes, citizenship, flawed arguments about citizenship, stateless person, and how can we apply what we have just learned? And we will discuss these things in the order presented. So let's begin with sovereignty. What is sovereignty? And here's the legal definition from Black's Law Dictionary, 4th edition. The supreme, absolute, and uncontrollable power by which an independent state is governed, supreme political authority, paramount control of the constitution and frame of government and its administration, self-sufficient source of political power from which all specific political powers are derived, the international independence of a state, combined with the right and power of regulating its internal affairs without foreign dictation, also a political society or state which is sovereign and independent. So notice sovereignty can imply a society or group as much as it can imply a government. And we would also add that in the United States of America, our government, as declared by the Supreme Court, is a government of delegated powers. And a government cannot possess sovereignty unless the people from whom its power was delegated also have that sovereignty. The requirement for consent is the foundation of all of our sovereignty as human beings. And this is proven in our document entitled Requirement for Consent, Form 05.003, available on our forms page. Being sovereign means no one can compel you in a civil court of law without your consent, and the only way you can lose rights are to injure the equal rights of other sovereigns and thereby commit a crime. That is the basis for the criminal law. Sovereignty and dependency are mutually exclusive. The more you want or need, the more the world can hurt you, is what Confucius, a famous Chinese philosopher, said on this subject. We would also add that sovereignty implies equality in relation to every other sovereign. So if you are equal to another sovereign, then that sovereign cannot impose duties upon you, and likewise, you cannot impose or enforce duties upon them. So sovereignty does not imply being superior in any way to anyone else or being a member of any elite group. It simply means that you're equal in every respect to every other sovereign under the law, meaning that the government treats all sovereigns equally and treats itself as being equal to you. Sovereign people can only remain free if they are educated. They must learn to trust their own judgment and intellect above and beyond what the government or others, especially those in the legal profession, tell them. And they must take 100% personal responsibility for every aspect of their choices and actions and lives. And they are skeptical about what people in government tell them because they are jealous for their liberties, as Thomas Jefferson said they should be. And they do not depend on any government for any kind of handouts. And we show this in government-instituted slavery using franchises, Form 05.030. Sovereigns do not submit or sign government forms without defining all the terms on the form to prevent being victimized by the self-serving presumptions of others, and they do not depend on or allow others to determine or declare or presume their civil status or their rights, whether it be their citizenship status or their tax status. And we show why this is in your exclusive right to declare or establish your civil status, Form 13.008 on our website. Finally, please don't ask us to make determinations about your legal status, because if you do, you're admitting that you aren't sovereign and you're giving control of your life to us. We don't want to be your master. We want you to be your own master. You own your life, and we want you to make sure that no one takes that ownership away from you. Ownership, after all, implies the right to exclude, so you should have the ability to exclude anyone and everyone else from using or benefiting from the use of you, your labor, or any of your property. And if anyone else is able to civilly control the use of that property, then you are no longer the owner, based on the definition of ownership in the legal dictionary. Origins of sovereignty. In our country, the people and not the government are the sovereigns, and the government exercises sovereign powers explicitly delegated to it by the people through a written constitution. And here are some of the things that the U.S. Supreme Court said on this subject. Juilliard versus Greenman, 110 U.S. 421. There is no such thing as the power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not, by their Constitution, entrusted to it. All else is withheld. And Perry versus United States, 294 U.S. 330. In the United States, sovereignty resides in the people. The Congress cannot invoke sovereign power of the people to override their will as thus declared. And Yickwo versus Hopkins, 118 U.S. 356. Sovereignty itself is, of course, not subject to law, for it is the author and the source of law. While sovereign powers are delegated to the government, sovereignty itself remains with the people. In America, we the people, and not the government that serves them, are the, quote, state, unquote. They are the people owed allegiance, not the government or public servants. In every political system, the state is the origin of all sovereignty. And here is the definition of state in America. Now, this is not the definition in other countries, but it is the definition in America. And notice what it says. State, a people, and we put in brackets not a government, but a people, permanently occupying a fixed territory bound together by common law habits and custom into one body politic, exercising through the medium of an organized government independent sovereignty and control over all persons and things within its boundaries, capable of making war and peace and of entering into international relations with other communities of the globe. United States versus Cush. The organization of social life which exercises sovereign power in behalf of the people. In its largest sense, a state is a body politic or a society of men. Beagle versus Motor Vehicle. Okay, so a body of people occupying a definite territory and politically organized under one government. State ex re Maisano versus Mitchell. A territorial unit with a distinct general body of law. So, moving on, it says the people of a state in their collective capacity considered as the party wronged by a criminal deed, the public, as in the title of a cause. Now, the first thing we notice about this definition is that you need three things to create a government. You need people, you need laws, and you need territory. And all three of those things must go together. A state cannot reach outside of its territory except through its right to contract. It cannot make laws for people outside of its territory. And even people inside of its territory who are not domiciled on that territory are not a member of the state and therefore are not the subject of any of the laws passed by that state that are civil in nature. Because after all, the civil laws are merely a collection of rules that apply to members of the quote club unquote. We call the state here the club. And if you're not a member of the club, then they can't enforce those rules against you. That is not to say that you're lawless. It simply means that you are not subject to the club rules. And you can still be subject to laws without being subject to the civil statutory laws. For instance, you could be subject to the common law and or the Constitution and protected by both without being a member of the society or a member of the state or the club. And that is the position that we advocate in our ministry. In a monarchy, the state is the king or queen and not the people, who instead are subjects and not sovereigns. And in an oligarchy, a small group of political leaders are the state and not the people under them, who instead are subjects and not sovereigns. A government based on the equality in the Declaration of Independence and of delegated powers is a government that derives its powers from a natural source, meaning you as a human being. And it has no more rights or authority than the people it serves as human beings, meaning it's equal to them, and not superior to them in any way. And it must operate in equity against other sovereigns as co-equals, which we said earlier. And it may not assert superior rights of its own or impute inferior rights to you. And it may not force you into a franchise court where you have inferior rights. If you end up in such a court, they have to dismiss the case and may not presume they have jurisdiction if you are not a franchisee. And by franchisee here, we mean a public officer within the government. And they may not lawfully change your civil status without your consent or infer a status within a franchise agreement that you do not have or cannot lawfully have. Only you can choose your status, that is your civil status, because that status is how you contract with and associate with others. Governments are established to protect your private right to contract and associate. And we prove this in our document entitled Your Exclusive Right to Declare or Establish Your Civil Status, Form 13.008. And a government of delegated powers may not convert your private property or your labor to a public use, a public purpose, or a public office without your express consent or at least compensation. Another way of saying this is that their job is to protect mainly private rights by keeping what is private separate from what is public. All governments are established mainly to protect private rights, in fact. The first step in that protection is to keep them from being converted to public rights without the consent of the owner. Because after all, the Declaration of Independence says that all just powers of government derive from consent, and therefore anything that does not derive directly and demonstrably with evidence from your consent is inherently unjust. You own yourself and your property. That's what we want to emphasize here. A government based on delegated powers cannot have any more powers from the sovereign people from whom it was delegated authority. And here are a few common law maxims of law that prove this. What is mine, that is sovereignty in this case, cannot be taken away without my consent. And the power, that is sovereign immunity in this case, which is derived, cannot be greater than that from which it was derived. Bouvier's Law Dictionary Unabridged, 8th edition. And no one can do that indirectly which he cannot do directly, or which cannot be done directly. And what I cannot do in person, I cannot do through the agency of another. And for instance, if you are not allowed and you are prohibited by law, and it's a crime to go next to your neighbor's house and hold him up or stick him up or demand property from him, then you can't delegate that authority to the government either by proxy, either through voting or by asking somebody to do it or any number of other things. You cannot delegate what you don't have. So And implicit in that is that anything the government can do, you can also do. Anything, any method of acquiring rights over others that they exercise, they have to enforce on your part as well. If you'd like to read these maxims of law yourself, you can visit the following link on our website, Bouvier's Maxims of Law, 1856. On the subject of delegated powers and equity, God says in the Bible the following: Arise, O Lord, do not let man, that is, or governments made up of men, prevail. Let the nations be judged and disciplined in your sight. Put them in fear, O Lord, that the nations may know themselves to be but men. So God regards men and governments as completely equal to each other. And that equality is the essence of your sovereignty. And the minute you surrender that equality and become unequal or inferior or a subject is the minute you cease to be sovereign and commence being a slave of some man. And you should never consent to be a slave. You should always consent only to worship God and to serve only Him and not to serve anyone else. And Isaiah 40:15 says, Behold, the nations, and we put in brackets, and the governments and politicians of the nations, close brackets, are as a drop in the bucket and are counted as small dust on the scales. And Isaiah 40:17, all nations, and we put in brackets, and governments, close brackets, are before Him, that is God, are nothing, and they are counted by Him as less than nothing and worthless. However, God also says in the scriptures that His followers and His people are not worthless and that they are very precious. So do you think God wants us to be subject to and a servant of that which is less than nothing and worthless? And the answer is no. Moving on, Isaiah 40:23. He, that is God, brings the princes, meaning the kings and the presidents, to nothing. He makes the judges of the earth useless. Now, how does He make those judges useless? Because they can only enforce the civil laws that you consent to by choosing a domicile in their jurisdiction. If you never consent, they have nothing to do, so they're useless. And God doesn't allow you to consent to those civil laws or to choose a domicile in Caesar's jurisdiction, because you cannot serve two masters. As long as you're acting as an agent of God, you cannot also act as an agent of Caesar or a public officer of Caesar. And every statute and every status in every civil statute implies a status that forces you to exercise the duties of an office in the government, such as citizen, resident, taxpayer, spouse, driver, and so on. Moving on, Isaiah 41:29, indeed, they, that is the governments and the men who make them up in relation to God, are all worthless. Their works are nothing. Their molten images, and we put in brackets, and their bureaus and agencies and usurious codes that are not positive law, close brackets, are wind, and we put in brackets, and vanity, close brackets, and confusion. So that is what God says in the Bible about delegated powers and sovereignty and your status in relation to the government, and how you're not allowed to surrender your equality in relation to every government and every civil ruler. Any government that asserts any right or authority or power that is superior to a single human being is a government that derives its authority from a supernatural source, meaning a source that has superior powers to you as a human being who is the natural. And it is operating as a religion and demanding worship, that is obedience, because that's what worship is defined as, obedience to the laws and dictates of a superior power. And it is establishing a religion in violation of the First Amendment, and it is establishing itself as a pagan god. A god is anything or anyone that has supernatural powers which claims your allegiance and obedience in the form of worship. And if it demands money, is demanding tithes to a state-sponsored church. Religion is legally defined as the worship, meaning obedience towards superior beings who have supernatural powers. And here is the definition from Black's Law Dictionary, 6th edition, page 1292. Religion, man's relation to divinity, to reverence, to worship, obedience, and the submission to mandates and precepts of supernatural or superior beings. In its broadest sense, it includes all forms of belief in the existence of superior beings, exercising power over human beings by volition, imposing rules of conduct, and we put in brackets franchises in this case, with future rewards and punishments, bond uniting man to God, and a virtue whose purpose is to render God worship, that is obedience, due him, and we put in brackets the pagan judge or civil ruler, close brackets, if you're worshiping a man, as source of all being and principle of all government of things. So indirectly, what they just admitted here is that government is a religion. If religion is the basis of all government of all things, and the government claims to be a government, then basically they're claiming to be a church and a religion. And if their First Amendment forbids the establishment of religion, then we have a problem, Houston. A huge problem. For details on this subject, see Government Establishment of Religion, Form 05.038 on our Forms page, and Socialism, the New American Civil Religion, Form 05.016 on our Forms page, and Our Government Has Become Idolatry and a False Religion. We prove that the modern day government is an unconstitutional religion that violates the First Amendment in all these documents. The above sort of state-sponsored religion is impossible if Christians take the approach that Jesus mandated towards government. In Matthew 20:24 through 28, quote, "And when the 10 heard it, they were greatly displeased with the 2 brothers. But Jesus called them to himself and said, You know that the rulers of the Gentiles lord it," that is, parens patriae or king, "over them, and those who are great exercise authority over them." And notice that word over, meaning they're superior. They have supernatural powers. They're above the natural. It says, "Yet it shall not be so among you. But whoever desires to become great among you, let him be your servant." And that's why they call them public servants, by the way. "And whoever desires to be first among you, let him be your slave. Just as the Son of Man did not come to be served, but to serve, and to give his life a ransom for many." So, Jesus forbids the government or anyone in the government from having superior or supernatural powers in relation to any Christian, any believer, if you believe in the Bible. So that relationship between the government and the governed is the biblical definition of government. And if that definition is violated, we don't have a government anymore, according to Jesus. And by the way, when Jesus was born, the New Testament says that the government shall be upon his shoulders. And so anything that claims to be a government must be consistent, must act consistent with what Jesus said in the Bible. And if it doesn't, then it's not a government by Jesus' own definition. And the only type of government that God permits is one that serves him and the people, and not the other way around. And on that subject, we like to refer back to Judge Andrew Napolitano on Fox News, where he always used to precede his Freedom Watch videos with the question, does the government work for us or do we work for the government? You should always be asking that question. Who serves who? And if we really do have a government, the answer is that people in government work for us and not the other way around. And if that in fact is the case, then we are not allowed to act as public officers within the government and serve anyone else as a citizen or a resident. We can only serve God because we have to be free to choose him and not serve others. Because remember, the first 4 commandments of the 10 commandments state that you shall have no other gods before me and that you shall not serve those other gods. And acting as a public officer or obeying the civil statutes of such a government that we didn't consent to would be an act of worship and obedience and therefore service, and therefore would violate the 10 commandments. And that is not to say that we shouldn't respect and protect the rights of our neighbor, but we don't need the civil statutory laws to do that. We can do that through the common law and the Constitution only. Any government that establishes itself as a religion in this way is destroying the foundation of the Constitution, which is equal protection and equal treatment. And here's what the Supreme Court said on this subject in Gulf CNS FR Company versus Ellis. No duty rests more imperatively upon the courts than the enforcement of those constitutional provisions intended to secure that equality of rights, which is the foundation of free government. So all of your rights come directly from equality in relation to every other human being and in relation to the government. If the government has superior powers to you, or if the people in the government do not work for you but force you to work for them, then we have a problem, Houston. And you're no longer free either. And a government that establishes itself as a religion in this way is also firing God as our protector and substituting a man, a king, or a parent's patriarch in its place, which the Bible forbids. And in 1 Samuel 12 and 19, it says the following on this subject. And when you saw that Nahash, the king of the Ammonites, came against you, you said to me, No, but a king shall reign over us when the Lord your God was your king. And all the people said to Samuel, Pray for your servants to the Lord your God, that we may not die, for we have added to our sins the evil of asking a king, that is a political ruler above us, for ourselves. So you cannot have anybody in the government being above you, having superior or supernatural rights, or you're practicing an unconstitutional religion, and you're violating the first 4 commandments of the 10 commandments if you're a Christian. And a government that establishes itself as a religion in this way is also causing Christians to commit the worst sin in the Bible, which is idolatry, the first 4 commandments, like we just said. And it's violating its delegation of authority order from God, which is the Bible, and should be avoided and resisted. And we prove this in Delegation of Authority Order from God to Christians 13.007. And we do it with scriptures right out of the Bible. We prove that God does not want you to worship any man or government of men, or obey any man or government of men under the civil statutory laws, and that you cannot choose a domicile within the civil statutory jurisdiction of any government, and that you can only be subject to the common laws because the common laws protect absolute equality of all, whereas the civil laws create an unequal relationship between the government and those governed. So you cannot consent to any system of law that creates inequality or enforces inequality of any kind. And that would especially include franchises. And the civil statutory law is a protection franchise. And you're not obligated to consent to it. And the way you consent to it is by choosing a domicile within the jurisdiction that it protects. And you don't have to choose a domicile, but if you do, then you're subject. And at that point, you're committing idolatry. And that's why God said in the Bible that the Israelites were not allowed to elect a king to be above them, and that he was their king. So how do you lose your sovereignty? Our Declaration of Independence says we are all born equal under the law in America. And we show this in the requirement for equal protection and equal treatment, Form 05.033 on our forms page. The only way we can become unequal or inferior in relation to any political ruler or public servant or an entire government is by our consent. And we show this in Requirement for Consent, Form 05.003 on our forms page. The main method for procuring your consent to become inferior and to give up your sovereignty is mainly through franchises in America, as we said earlier. And we show this in Government-Instituted Slavery Using Franchises, Form 05.030. Moving on, how do we lose our sovereignty? If any public servant asserts that they are entitled to your services or property under the civil statutory law, the burden of proof remains on them to produce legal evidence that you consented in writing in a manner that you and not they define, and you had the legal capacity to consent at the time you consented, which means you are of legal age, and that you are not alienating a right that was unalienable, meaning that you were not territory within a state protected by the Constitution, but instead were on federal territory, or else you're not allowed to alienate an unalienable right, and that you were either domiciled within the exclusive jurisdiction of the government in question at the time you consented or acted, or you were representing an entity that was so domiciled under Federal Rule 17b. If you were not, then you cannot, even with your consent, you cannot become the subject of the civil statutory laws. You can still be subject to the common laws by mere physical presence on the territory of that government, but you cannot be subject to civil statutory laws because they are a compact or agreement or social compact, as the Supreme Court calls them, that can only acquire the force of law with your consent to choose a domicile and thereby be subject to them. And they have to produce legal evidence that you expressly consented to the civil status to which the obligation attaches, e.g. taxpayer, citizen, resident, driver, etc. And we show this in your exclusive right to declare or establish your civil status, Form 13.008 on our website. If they cannot meet the above burden of proof, they are engaging in a bill of attainder and a violation of the Fifth Amendment Takings Clause. So if they're doing the enforcement, then they have the burden of proof to show that you consented to be subject to the civil statutory laws that they are enforcing. And if they don't meet that burden of proof, they're taking property from you, because the rights described in the Bill of Rights are property as legally defined. And a bill of attainder is a case where a person is being penalized without a court trial, and that penalty could be administrative. It could be done in a franchise court, which is not a real court. So that would be a bill of attainder against a person if they are not a public officer in the government, or they did not consent to become a public officer in the government. And it would be a taking of property without the consent of the owner. An example of representing an entity domiciled on federal territory would be public officers who represent the government of the United States. The United States is a federal corporation, and that's indicated in 28 USC 3002-15A, and they are officers of said corporation, and they are therefore the only, quote, persons, unquote, statutory persons under 26 USC 6671B and 26 USC 7343, and they are acting in a representative capacity on behalf of the public trust under the Federal Rules of Civil Procedure 17B. More methods for how you lose your sovereignty. Methods that the de facto government abuses to illegally recruit new public officers in violation of 18 USC 912. All tax forms which are franchises that implement excise taxes. The activity is called a trade or business, which is defined in 26 USC 7701A26 as, quote, the functions of a public office. Also, all licenses are abused to create new public offices, such as marriage licenses, driver's licenses, professional licenses, and business licenses, and federal, quote, benefit, unquote, applications such as Social Security Form SS4 and SS5. All benefits are franchises, and any government form that asks for a Social Security number or taxpayer identification number. 26 CFR 301.6109-1 says these numbers may only be used for those engaged in a trade or business, meaning a public office, in the U.S. and not state government. And any form that asks if you are a statutory U.S. citizen or resident, that is alien, both of which are privileged franchises of the United States government. And we prove this in why you are a national, state national, and constitutional but not statutory citizen. Form 05.006 on our website. In short, an SSN or TIN acts as a de facto license to represent a public office in the United States government. Welcome to the Matrix, Neo. But there is hope. Don't worry. Why is there hope? How can we escape the Matrix? And the answer is, you're not a statutory U.S. citizen or U.S. resident. That is an alien. and you can't lawfully apply for or participate in federal franchises without a domicile and a physical presence on federal territory, which most people do not have. And people domiciled in a state of the Union are not domiciled on federal territory, and therefore they would not be subject to the civil statutory laws of that foreign jurisdiction in the federal territory. And it is illegal to engage in a public office outside the District of Columbia, pursuant to 4 U.S.C. Section 72. And the government has the burden of proving that you are lawfully exercising the office outside of the District of Columbia if they're enforcing it outside the District of Columbia. And it is illegal to establish or enforce federal franchises within states of the Union and outside of federal territory, as held by the U.S. Supreme Court in the license tax cases. And the definitions in federal law consistently agree with all of the above information. The above facts are explained in our other training materials. Right now, we are just going to focus on getting you to the point where you can prove all of the above. Please be patient and learn. That's how you are going to get free. Sovereignty and jurisdiction. The purpose of defining sovereignty is to identify exclusive responsibility and authority over something. Sovereignty defines and circumscribes legal jurisdiction. And there are 3 types of legal jurisdiction. In personam jurisdiction, which is jurisdiction over the person, it's conferred by service on persons physically present in the forum state and who have a domicile within that state and who consent or by their consent or appearance in the action. In rem jurisdiction is jurisdiction over the property that is determined by whether the property is within the territorial limits of the sovereign, regardless of where the owners are domiciled, and subject matter, which is the court is empowered to hear your case by the Constitution and laws. This can be a complicated matter with several criteria. If you want to know the rules for how sovereigns interact from a jurisdictional standpoint, see the power to create is the power to tax. There's lots of rules there that we extracted from several different authorities. Words of art in the law. Most corruption and injustice within the legal field is done using deliberately deceptive definitions engineered to confuse or mislead you. And these definitions are called words of art, the words that are used within the definitions. And we should always read the definitions before we read the rest of the law, and this will keep you from being deceived. The definitions in the Internal Revenue Code are at the end, not the beginning of the code, because the government, quite frankly, doesn't want you paying attention to them. And you should trust your own judgment when you read the law and don't rely on an expert. The Supreme Court says the laws are supposed to be understandable by the common man and not just the experts. And to the extent that that requirement is not met, the law itself becomes void for vagueness and unenforceable. After the government obfuscates the law using tricky definitions, they will try to convince you that you can't trust your own judgment when reading the law. This, in turn, forces you to rely on a corrupt judge or lawyer. It puts your liberty in the hands of someone else instead of you. And it makes the judge or lawyer into a witch doctor or a satanic priest, and the government into a religion, because now you have to trust them or a man instead of your own understanding. And the video link provided here explains how this is done. But the bottom line is that the Supreme Court said in Marbury versus Madison that we are a government of laws and not men. So if you have to trust a man instead of just your own reading of the law, then we don't have a government by definition. All we have is just a group of men who are engaging in a protection racket and who want you to bribe them to protect you. So definitions are important, very important. If a word is defined in the law, then you can safely conclude that you cannot rely on the common definition or the definition found in the dictionary, or it wouldn't have been defined in the law to begin with. This is very important, and it's very frequently abused. And here's what the U.S. Supreme Court said on this subject in Stenberg versus Carhart, 530 U.S. 914 in 2000. When a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. Meese versus Keene. It is axiomatic that the statutory definition of the term excludes unstated meanings of the term. And Cloudy versus Franklin. As a rule, a definition which declares what a term means excludes any meaning that is not stated. And that is to say, the statute read as a whole leads the reader to a definition. That definition does not include the Attorney General's restriction, the child up to the head. Its words, substantial portion, indicate the contrary. And Meese versus Keene, at the bottom, it is axiomatic that the statutory definition of the term excludes unstated meanings of the term, Cloudy versus Franklin. Congress's use of the term propaganda in this statute, as indeed in other legislation, has no pejorative connotation. As judges, it is our duty to construe legislation as it is written and not as it might be read by a layman or as it might be understood by someone who has not even read it. This is important because if you read publications by the government, such as IRS publications, they will very frequently use words of art in those publications. So they will use words in their legal context in their publication. And you may read those words and think that they are used in their ordinary context, but they are not. And an example of some of those words might be employer, employee, income, taxpayer, person, citizen, resident, and so on. All of those terms have a very unique meaning that is in complete contradiction to what most people would ordinarily think they mean. A citizen in the Internal Revenue Code, to be precise, is a public office in the national government, and it is domiciled on federal territory, and it does not include anybody in a state. The people in the state are non-residents, and they are not even persons in the Internal Revenue Code, because the government cannot regulate private rights or private conduct, and hence a person can only include public entities. If you would like an exhaustive free analysis of how corrupt governments employees abuse language to exceed their definition and steal from you, please read Meaning of the Words Includes and Including, Form 05.014. So let's move on to probably the most important word of art that gets abused in government publications and by the courts. The Supreme Court, which is the United States, the term United States, quote unquote. And this word has multiple contexts that it can be used. In a geographical context, it can be used in a legal sense as describing the United States as a legal person. It can also be used in a geographical sense to imply a specific territory. The Supreme Court has declared that there are three geographical definitions of the term United States. In Hooven and Allison versus Evatt in 1945, they stated the following. The term United States may be used in any one of several senses. Definition 1, it may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. And definition 2, it may designate the territory over which the sovereignty of the United States extends. And by sovereignty, they mean the exclusive jurisdiction or general jurisdiction, not the subject matter jurisdiction. And definition 3, it may be the collective name of the states which are united by and under the Constitution. Which of the above three geographical definitions of the United States provided by the Supreme Court applies in a particular case depends on the context. So we took all these definitions and we enumerated them. So the first one they talked about was United States, and throughout all of our publications we follow that first definition with an asterisk, a single asterisk, and we imply that it's a geographical meaning, context, and that it implies the country, United States, and that would include all the federal territories and all the states of the Union combined. Okay, that is the United States star. The second definition they provided up here was United States, and we put two asterisks after that to distinguish it, and that refers exclusively to federal territory in a geographical sense, when used in a geographical sense. And then the third definition is United States with three asterisks, or star, 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 and in a geographical context, that means the states of the Union. and, and excludes federal territory. So the first definition up here includes the sum of the second two contexts here. So this is the largest geographical context, United States star. Now, as far as federal legislation, all federal legislation implies the second context, meaning federal territory, and excludes states of the Union. The states are legislatively foreign for the purposes of federal civil law and criminal law. And that is a product of the separation of powers that was designed into the Constitution. It has existed from the beginning of our republic. However, in addition to the three geographical United States we just talked about, the term is also used in connection with United States government as a legal person. Context 4 below is the context for most federal law, including the Internal Revenue Code. And we prove this in the non-resident alien position, Form 05.020, sections 10 and 11. And so to the previous chart or table, we added a fourth definition, which is United States with 4 asterisks, or star, 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 star. And that is the legal context rather than the geographical context, and implies the government of the United States. Now, we hope that you understand that just like an ordinary person, you can, sure, you can legislate for yourself. You can command yourself. There's nothing wrong with that. You can command your own agents if you have a company. If you have a company and you call that company, United States star, 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 like they've done, and it's a corporation like they've done, then anybody who works within that corporation as an employee is within the United States star, 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 star. In other words, they're within the government. And if they're public officers within that government and they're representing that corporation, then they are officers of a corporation. And an officer of the corporation is legally, quote, within, unquote, the United States, because you can be legally within the legal person, United States, as a public officer without being geographically on any land that government owns. So that is the sense that most tax laws and most regulation applies to, is people within the government, agents and officers of the government. And the Supreme Court explained why that was in Osborne versus Bank of the United States. So here's the context for various laws of each of the geographical terms we just discussed. The federal Constitution, the author is the Union States, or we the people, and the application of the applicable definition is United States with 3 stars, meaning states of the Union only. For federal statutes, the applicable jurisdiction is United States star star, which means federal territory. For federal regulations, it also means federal territory and not any part of the states of the Union. For state constitutions, United States star 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 is implied, which means states of the Union. And for state statutes, the context is United States star star, which means federal territory. And for state regulations, it is United States star star, which means federal territory. And why is that? Because if indeed the Constitution protects private rights and the ability to regulate private rights is repugnant to the Constitution, then the only place they can regulate is on federal territory, whether they're a state or a national government. Otherwise, they can't reach you. So you have to consent to be treated as if you are domiciled or present on federal territory before they can regulate your conduct, because doing so is how they make it public conduct instead of private conduct. Everything within the constitutional states is private. Everything on federal territory is public. That's how they do it. And so we call the federal territory the plunder zone, because that's the only way they can reach you and plunder you and regulate you. So what is a state? We talked about this earlier. It's a people permanently occupying a fixed territory bound together by common law, habits, and custom into one body politic, exercising through the medium of an organized government independent sovereignty and control over all persons and things within its boundaries. The organization of social life which exercises sovereign power in behalf of the people. In its largest sense, a state is a body politic or society of men, a body of people occupying a definite territory and politically organized under one government, territorial unit with a distinct general body of law. The term may refer either to the body politic of a nation or to an individual government unit of such a nation. In our de jure Republican form of government, the state is the people and not the government or anyone in the government. The people are the sovereigns according to the Supreme Court, and the government is their agent and their servant, not their master. In a de jure non-Republican forms of government, such as monarchies and democracies, the state is the government or the people in the government, because the rulers/government and not individuals making up the body politic is the sovereign. In de facto governments, the state is the body corporate and there is no body politic because everyone is a public officer in the government corporation. See de facto government scam form 05.043 on our forms page. Natural order. Natural order is based on the sequence that things are created. And the sequence of creation defines the hierarchy of sovereignty and authority. This sequence is God, who created man, and man then created families, contracts, trusts, elections, petit juries, grand juries, and organized churches. And those organizations and people then created states and state constitutions. The states then created state statutes, state regulations, state corporations, and together the states got together and then created the federal constitution, and the federal government then created independent branches of the government in that constitution, federal statutes, federal regulations, federal corporations, and federal territories. And we might add that those corporations and territories are franchises of the national government. And here's a diagram of what that sequence of creation is and how it relates to the hierarchy of sovereignty. So the most sovereign entities are on the top and the least sovereign are on the bottom. And everybody below an entity above it is basically a servant of that which is above. So God created the earth, the heaven and the earth, and according to the Bible, he owns the heaven and the earth. Therefore, he is the landlord. And God then created his law. In the book of James in the Bible, it says, in the beginning was the Word, and the Word was with God, and the Word was God. So God, the essence of who God is the Word, meaning the law, because that's what the Bible is. It's law. So law is who God is. And so anybody who avoids God, or indirectly, is avoiding the law and is lawless. And we show all the authorities on the right here at each level, so you can see in the Bible the authorities for what they are. God created the physical world and the universe, and that's described in those scriptures here. And you can see we have the hierarchy of sovereignty on the right over here. The least sovereign is at the bottom, and the most sovereign is at the top. So after he created the universe, then he created man and woman. And man and woman then created communities and organizations like families and churches and cities and towns and villages. And those organizations, those communities then created grand juries, elections, organized churches, and trial by jury. And those juries then act upon other men and women, but only when they're injured. So if somebody gets injured, they can act against, a man can act against another man through the agency of the jury. And that agency is delegated by men and women through written constitutions and laws and rules of societies. The elections then create constitutions, and the constitutions then create executive, judicial, and legislative branches of the government. And the executive branch then creates regulations, and the legislative branch creates statutes. And the statutes are used to create the regulations by the executive branch. And the statutes are enforced by the judicial branch, as are the regulations. That's why we have little arrows going into there. And the statutes then are used to create or authorize corporations to be created. And they also create U.S. citizens. Statutory U.S. citizens, which are not the same as constitutional citizens. Constitutional citizens are way up here. Statutory citizens are way down here. Everything at the bottom are franchises. Corporations are franchises. Statutory U.S. citizens are franchises. and offices within the government, you don't ever want to be a statutory citizen. You can be a constitutional citizen without being a statutory citizen. We'll talk about that later. So natural order, delegated authority. American government is one of delegated authority. Sovereignty flows downhill from its source, the sovereign people, we the people, as individuals and not as collective. And some people would say, oh, well, the collective is the sovereign in our system of government, which is absolutely wrong, because that collective had to get its authority from somewhere. And if it didn't get it from an identifiable source, then it has supernatural or superior beings, because you can't identify the source. And that source has to be natural. And the only thing that's natural is you and I, people. So either it came from the people individually, and the people individually consented to give it that authority, or it came from a supernatural source, and we have a religion problem in violation of the First Amendment. Those are the only two options. Collectivism inevitably leads to communism and socialism, which are the antithesis of a republican form of government. And the collectivism implies that the collective can have more rights than a single individual. And of course, that breaks the chain of delegated authority, because the authority has to go through a chain. It has to come from a natural source. So the first step in created delegated authority, is to identify the natural source. And that would be you and I, and can only be you and I. And so we get together as a collective, and we delegate that authority to the government. And you cannot delegate, as we showed earlier, you cannot delegate what you don't have. And so whatever rights or privileges the government claims that it has must have come from you, and therefore you have it too. And by delegating that authority to them, you didn't give it away. You simply authorized them to use a portion of it. The sovereignty resides in the people. And by, quote, the people, unquote, we don't mean the collective. We mean the individuals. Our system of republican government is based on individual rights and individual sovereignty. And the minute you deviate from that requirement is the minute you create a civil religion, and the minute that you make the government into a religion, and the minute you force people to worship that religion and to pay tithes to that religion called taxes. The people are the masters, and government is their servant. Abraham Lincoln, a government of the people, for the people, and by the people is what he called it in the Gettysburg Address. So the people are the masters. No servant can serve two masters, Luke 16:13, and therefore the people cannot simultaneously serve God and government. And the people must be sovereign over government at all times, and this is the authority the Constitution bestows upon us as individuals. All authority derived from the sovereign people is delegated to the government by our state and federal constitutions, and the legislative branch then delegates its authority to the executive branch using the statutes and codes that it enacts into positive law. And the executive branch writes implementing regulations that describe how it interprets the statutes written by the legislative branch. And the judicial branch interprets or reconciles the implementing regulations against the statutes to determine how they affect the rights of the people. And if it isn't specifically authorized in writing in the Constitution, then the government can't do it, and you can sue them if they do, especially if they hurt you. So now let's talk about rights. And the term right is a point of a lot of confusion. When people use rights, they can actually mean one of two things. They can mean public rights or private rights. And most people don't even know what that means. Some judges don't even know what that means. But the distinction is that a public right is something created and granted only by the government and not the people, whereas a private right is something created only by God and granted only by God. And the idea is that you cannot take away that which you didn't create. So if God created all of your rights and the Bill of Rights instead of the government, then they cannot take away that which they did not create. And the creator of a thing is the owner of a thing. So this is just a generic definition of rights generally. But it can mean either a public right, which means a privilege, or it can mean a private right, which means an absolute unalienable right. So as a noun and taken in an abstract sense means justice, ethical correctness, or consonance with the rules of law or the principles of morals. And if you look at that definition of justice, what it means is the right to be left alone by the government first and by everybody else after the government. So if you hire a government to protect you, it's protecting justice, and the purpose of government is justice. That's what the founders said in the Federalist Papers. In this signification, it answers to one meaning of the Latin jus and serves to indicate law in the abstract, considered as the foundation of all rights, or the complex of underlying moral principles which impart the character of justice to all positive law, or give it an ethical content. As a noun, and taken in a concrete sense, a power, privilege, faculty, or demand inherent in one person and incident upon another. Rights are defined generally as powers of free action, and the primal rights pertaining to men are enjoyed by human beings purely as such, being grounded on personality and existing antecedently to their recognition by positive law. But leaving the abstract moral sphere and giving to the term a juristic content, a right is well defined as a capacity residing in one man of controlling, with the assent and assistance of the state, the actions of others. So where do rights come from? And the answer is only God. And by these kind of rights, we mean private rights. Private rights were created by God. They're recognized but not created by the Bill of Rights. They're recognized but not created by the government. And because the government didn't create them, they can't take them away. And here's what the Declaration of Independence says on this subject. All men are created equal and endowed by their Creator with certain unalienable rights. And if you look up that definition of unalienable, it means that which cannot be sold, bargained away, or transferred. And if it can't be sold, bargained away, or transferred, then you're not allowed to consent to even give it up. So if you can't give it up in relation to a real government, then anybody who tries to make a business out of causing you to give it up or surrender it inherently is not a government and is a private company. Because you can alienate rights to other private and equal people through your right to contract. That's the basis of the right to contract. But you cannot do it in relation to a real government. That's very important. So let's compare rights versus privileges. We said earlier that a right is a private right and a privilege is a public right. Rights are unalienable. That means and by that we mean private rights. That means you are not allowed by law to consent to give them away. Examples: life, liberty, and property rights, recognized in the Constitution. The definition of unalienable: unalienable, inalienable, incapable of being aliened, that is sold and transferred. And we might add that the main method for selling and transferring rights is franchises, government franchises, okay, when you're dealing with the government. So by implication, if you can't alienate a right, you're not allowed to even consent to give it away, then you're not even allowed to participate in government franchises. And therefore, the only place they can offer those franchises physically and geographically is in a place not protected by the Constitution where those rights don't exist. And that would only be on federal territory. Privileges, which we said were public rights, can be taken away at any time at the whim of the government. Why? Because they created those, and they created them in the statutes. Government handouts such as Social Security, Medicare, and TANF are examples of public rights, meaning franchises. Rights can only lawfully be possessed by private persons, such as human beings. Privileges can only be possessed by public persons engaged in public offices. Why? Because private people are not allowed to use public property for their personal benefit. That would be conversion. That would be theft. If you want to use uncle's property, or you want to borrow his property, then you have to consent to conditions of using it. And those conditions are documented in franchise agreements. And since they can't offer those franchises in constitutional states, then they have to entice you to go into the federal zone and sign up for the franchise when you do it, where there aren't any rights. Because those public rights, the private rights, your constitutional rights attach to land, whereas public rights attached to statuses, such as citizen, resident, and inhabitant, statutory statuses. All governments are created only to protect private rights. The first step in that protection is to prevent those rights from being converted into privileges or public rights by covetous public servants. And a government that does not recognize or protect private rights is a de facto government. And a de facto government always protects only itself and only protects public property and doesn't even recognize private property. In other words, a de facto government is one that wants to implement socialism in which it either owns or controls everything, because then it can make everyone dependent on itself and create the ultimate religion where everybody is compelled at gunpoint to worship them, because everybody has to borrow their property, the government property, to even exist. Politicians and governments do not produce anything, so they have to steal money from one group of people to bribe another group to vote in favor of them. Here is why the Supreme Court thinks this is wrong. Loan Association versus Topeka. To lay with one hand the power of the government on the property of the citizen, and with the other to bestow it upon favored individuals to aid private enterprises and build up private fortunes, is nonetheless a robbery because it is done under the forms of law and is called taxation. This is not legislation. It is a decree under legislative forms. So what they just said here is that if the government uses its or abuses its taxing power to transfer wealth from one private group of people to another private group of people, this is not taxation, and whatever it is that accomplishes that is not law. And if it's not law, then what is it? It's an employment agreement that you have to consent to. You have to consent to go to work for Uncle and work for the government before they can transfer wealth between you and another worker in the government. Otherwise, they're stealing from one private group to give to another private group, and that's not an authorized use of their taxing power. So they first have to entice you into the government as a franchisee and a public officer before they can legislate at all for you. And that is what we would call a public right. They have to make you public before they can enforce public rights. Only small governments with limited jurisdiction and revenue can provide us the greatest rights and the most liberty. And Woodrow Wilson, President of the United States, said on this subject, the history of liberty is the history of the limitation of governmental power, not the increase of it. So how are rights illegally converted into privileges? In other words, how do they convert private rights into public rights? Covetous, criminal, de facto governments intent on expanding their power in violation of the Constitution and in violation of the purpose of their creation, which is to protect private rights, will attempt to fool you into exchanging your private rights for taxable public privileges and thereby diminish those rights. The method of fooling you into exchanging your private rights for taxable public privileges involves bribing constituents with money stolen from someone in the name of taxation. Voters and jurists presiding over tax trials are told that the defendant refuses to, quote, pay his fair share, unquote, which really pisses them off, that their benefits go down and the cost of those benefits goes up. It's a crime to preside over any dispute as a voter or a jurist in which one has a financial interest. 18 U.S.C. 208. So if you hear a U.S. attorney or a judge accusing you of refusing to pay your fair share and telling somebody who collects revenues from that fair share is engaging in a conspiracy against your rights and engaging in the crime of a criminal financial conflict of interest. And they have to be recused, they have to be put in jail, and the jury has to be dismissed at that point because there isn't a jury anymore. There's just a lynch mob of angry people who are operating entirely out of self-interest and not as agents of the law. President Clinton and the Democrats euphemistically call this, quote, investing in America, unquote. But it's basically just stealing and the abuse of the taxing powers of the government to steal from otherwise private people. As we said, and as the Supreme Court said in Loan Association versus Topeka, the government, it is an abuse of the government's taxing powers to transfer wealth between one group of private people and another group. Public monies or benefits paid to voters or jurists has always been called criminal bribery. For this reason, it is a crime to register to vote or to serve on jury duty if one receives anything financial or any benefit or entitlement from the government one is serving on behalf of. And this is especially true if the issue before that you're voting on as a jurist or a voter will directly affect your own financial benefit from the government. For instance, if you preside over a tax trial as a jurist, and you also receive government benefits as that same jurist, then you have a complete financial conflict of interest, and you're committing a crime. Everybody on the jury who fits that description is committing a crime. And the judge, if he tries to protect that crime by refusing to dismiss the jurist, himself is a criminal. And that jurist needs to be dismissed during the voir dire process and not after. Law. The purpose of law is to protect everyone, not just citizens or residents, but non-residents as well. And laws define and limit government jurisdiction. And laws eliminate injustice, but they do not promote justice. Okay? What we mean by that is justice is the right to be left alone. So by definition, injustice is when people bother you when you don't want to be bothered. And the purpose of law is to prevent injustice, meaning to prevent people from refusing to leave you alone, or to keep people from bothering you, in other words. And they can bother you in a lot of ways. They can steal your stuff, they can take your time, they can withhold on pay that's not public pay as a public officer. That's stealing. You have to be a public officer for any kind of withholding or reporting in the tax system, and so on. And that's covered in other courses on this site, like federal and state taxation of individuals. In other words, in the words of Calvin Coolidge, former President of the United States, quote, "Men do not make laws, they but discover them. Laws must be justified by something more than the will of the majority. They must rest on the eternal foundation of righteousness. That state is most fortunate in its form of government, which has the aptest instruments for the discovery of law." And all law enforces equality of all. And by equality of all, we mean equality between the governed and the governors, as well as just between the governed. So if it doesn't enforce equality, then it's not law. It's just a state-sponsored religion. Because equality, as the Supreme Court said, is the foundation of all of your freedom. And there is no such thing as a government of limited jurisdiction that is described with words in the law that have an unlimited, unclear, subjective, or ambiguous definition. As we said, the purpose of all law is to define and limit the government jurisdiction. That is what the Supreme Court said, in fact, in United States versus Cruikshank. So if the IRS tells you that the word includes makes the definition of employee or trade or business unlimited, or if they even say that they can put whatever they want in the definition, then they are blowing smoke and trying to expand their jurisdiction beyond the clear bounds of the law. And at that point, it's no longer law. If it doesn't limit them, or if they can rewrite it on the fly, or if they can put whatever they want in the definition, or if they can presume whatever they want to be included in the definition, then it's not law anymore. And they're not acting under the authority of law anymore. They're simply implementing a society of men and not law. And that is a criminal abuse of their delegated authority and results in a conspiracy against your rights. And they'll play all kind of word games to try and rationalize why they're allowed to do that, but they aren't, because it violates the rules of statutory construction. Two classes of law. Law can only be created through the consent of the sovereign, which is you, and is enacted to protect the sovereign. As we said, the state is the people occupying a territory. It is not the government that serves them. So the purpose of law is to protect the sovereign, meaning you as a human being and not a statutory person. That is the purpose of all law. And here's the definition of law from Black's Law Dictionary, 6th edition, page 884. Law, that which is laid down, ordained, and established. And notice that word ordained. That's a religious word. Okay, and the Constitution uses that word as well. So apparently they seem to understand that they are creating a religion when they're ordaining priests called judges and attorneys to administer this religion where you worship the state, the collective or whatever, and that's not what law is supposed to be. Okay, they're trying to create the appearance that's what it does, but it cannot exist as a religion. That's prohibited by the First Amendment. A rule or method according to which phenomena or actions coexist or follow each other. Law in its generic sense is a body of rules of action, conduct, or conduct prescribed by controlling authority, that is the sovereign, and having binding legal force. That which must be obeyed and followed by citizens, subject to sanctions or legal consequences, is a law. Law is a solemn expression of the will of the supreme power of the state. And there's that word again, supreme. Well, how can it be supreme if you didn't consent to it? And how can it be above you without violating the requirement for equal protection and equal treatment? If you really are equal to the state, then how can it ever be supreme? It can't. And that's the whole point. So if in order to be unequal, in order to become a subject, you have to consent to the civil statutory laws, and you do that by choosing a domicile, and you're not obligated to choose a domicile or residence, but you can. And if you do, at that point, and only at that point, does the civil law become, quote, supreme, unquote. And the law of a state is to be found in its statutory and constitutional enactments as interpreted by its courts, and in the absence of statute law in the rulings of the courts. And those in that scenario where there is no statute law and it's just the rulings of the court, that's called the common law. That's what they're talking about here. The other important thing about this definition of law is that the concept of delegated authority. If you can't control your neighbor, if you can't order and boss him around, then you can't create a group of men and call it a government and have them boss him around either. So the whole notion of law that is supreme and above other people without their consent is just fraud. The important thing to remember here is that all civil societies are based on compact. A compact is a contract or agreement. So everybody who is the subject of those so-called laws, unquote, those civil laws, really has to consent to it. And the way they consent to it is with the domicile. If you didn't consent, then you're not a member of the club. And if you're not a member of the club, then the civil statutory laws don't apply. But that doesn't mean you're lawless. It simply means that the only thing you can invoke to protect yourself is the common law and not the civil law. That's all it means. And the common law enforces equality. So you don't lose your equality by being subject to the common law. The civil law does enforce inequality between you and the government because they're the only one in the relationship that can extract fees and penalties, whereas under the common law they can't. So essentially, by invoking the common law to protect yourself, you and the other people you contract with or deal with, if they both consent to invoke the common law instead of the statute law, essentially are contracting the government out of their relationship. And if your right to contract means anything, it has to mean the right to contract the government out of the relationship. And a jury is the only participant in settling disputes under the common law. So the government isn't involved and you don't have to pay them anything. And all they can do is get the hell out of the way because that's what justice is defined as, is the right to be left alone. And if you want to be left alone by the government, then you better choose the common law instead of the statute law to protect yourself. Most law passed by government is private law that only applies to those who individually consent in some way. And we already showed one of the ways you consent is to choose the domicile. In that way, governments are acting as a business instead of a government because they're offering, quote, protection services, unquote. And if you don't want their protection and you want to fire the bastards, then you can. And that means that the common law still applies and you don't have to consent to the common law. So you can't interfere with that, but you do have to consent to the statutory civil law because all statutory civil law is law for government. That's what we prove on the memorandum of law on our website entitled Why Statutory Civil Law is Law for Government and Not Private Persons. Public law. Definition. A general classification of law consisting generally of constitutional, administrative, criminal, and international law concerned with the organization of the state, the relations between the state and the people who compose it, the responsibilities of public officers to the state and to each other, and to the private persons, and the relations of states to one another. An act which relates to the public as a whole, it may be that is general, that is applying to all persons within the jurisdiction, or local, applying to a geographical area, or 3, special, relating to an organization which is charged with a public interest. Black's Law Dictionary. An example of public law would be the Constitution, the Criminal Code, and Title V of the U.S. Code, which applies only to those who accept federal employment. All public law must apply equally to all persons and things who are its object in order to meet the constitutional requirement for equal protection, because laws which are unequal are discriminatory and are unjust and will therefore cause civil unrest. So let's talk about equal protection. We keep harping on this subject. An example of equal protection of the law in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. And examples of equal protection in the Constitution include Article 4, Section 2. The citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. And that establishes equality between the citizens of one state and all other states. And so that if those citizens go into other states through their travels, they will not be treated unequally to the other citizens. Another example is the Constitution, 14th Amendment, Section 1. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So in other words, they can't choose who they want to enforce the laws against and who they don't, because that's a violation of equal protection. And we might add that Obama has done that all the time with his Obamacare. You know, he's decided that he doesn't want to enforce certain provisions of it against certain people. You know, he's delayed the individual mandate, and he's decided that certain employers are not required to obey it, even though he had never changed the law. So just simply by what we call selective enforcement, he is depriving everybody of equal protection. And he is acting lawlessly. He is an anarchist at that point. And Constitution, Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. So in other words, the acts and records in one state will apply in all the states, and they become legal evidence everywhere, not just in that one state where they were created. For exhaustive details on equal protection, see our pamphlet, Memorandum of Law, entitled Requirement for Equal Protection and Equal Treatment, Form 05.033 on our Forms page. Another type of law is private law. And here's the legal definition from Black's Law Dictionary, 6th edition, page 1196. That portion of the law which defines, regulates, enforces, and administers relationships among or between individuals, associations, and corporations. And we might add, by the way, that all governments are corporations. As used in contradistinction to public law, the term means all that part of the law which is administered between the citizen and the citizen, or which is concerned with the definition, regulation, and enforcement of rights in cases where both the person in whom the right inheres and the person upon whom the obligation is incident are private individuals. Black's Law Dictionary, 6th edition, page 1196. Examples, all private law is created by individual consent in some form, and examples of private law include government franchises, the Social Security Act, the State Family Code, or Family Law, State Vehicle Code, the Internal Revenue Code, Subtitle A, contracts, trusts, and wills. All of those are private law. And why do we say those first few, these government franchises up here, are private law? Because they don't acquire the force of law without your consent. Consent is the basis of all law, in fact. And All franchises are contracts between the grantor and the grantee, and to be the subject of a contract, you have to consent to it. And whether you want to call that a contract or agreement or comity or any number of other different legal terms, the concept is the same. So don't play word games with us. So what lawful form does consent take that makes us subject to private law? And here are some examples. Simultaneously having a domicile on federal territory and serving in a public office in connection with a specific regulated activity on federal territory. And by that we mean the Social Security Act applies on federal territory to those people who are domiciled on federal territory. If you're not domiciled there, then under Federal Rule 17, the Social Security Act is unenforceable. So it's unenforceable in a state of the Union. It's unenforceable against those who are not public officers in the government. Why? Because it pays benefits, and those, quote, benefits, unquote, are derived from taxes, and the government cannot pay taxes to private people. That's an abuse of their taxing power, so they can only pay it to public officers in the connection with their official duties and as compensation for performing those duties. And while they're performing those duties, they only perform them on federal territory and not elsewhere, as described in 4 USC Section 72. So here are some examples. So the Social Security Act, signing and submitting the SS4 or the SS5 form and consensually using the SSN in connection with a specific transaction or specific otherwise private property on the federal territory. The State Family Code would be invoked as private law by getting a marriage license, that is consenting to have a marriage license, and invoking the privileges, benefits, and protections of the family court as a public officer. Why? Because you cannot use public property for a private use or a private purpose or to benefit a private party. And the family court is a agency of the national government, and you cannot procure its services without working for the government. Otherwise, they're paying public monies and public property to private people, aren't they? And they can't do that. Other examples, State Vehicle Code, applying for a driver's license and using the roadways for hire as such a public officer. And the Internal Revenue Code Subtitle A, serving in an elected or appointed public office and consensually using a government SSN or TIN in connection with specific otherwise private transactions or private property. The number is a de facto license to represent a public office. Other examples include contracts, trusts, or wills. So, when the United States government engages in contracts and private law, it lowers to the same level as any other private human. And here's an example from the Supreme Court. Clearfield Trust Company versus United States, 318 U.S. 363. The United States does business on business terms. And what they're saying here is they're equal to every other business. And they're not superior to every other business if they enter the commercial marketplace and compete with private companies. Perry versus United States, 294 U.S. 330. When the United States with constitutional authority makes contracts, it has rights and incurs responsibilities similar to those of individuals who are parties to such instruments. There is no difference, except the United States cannot be sued without its consent. Now that last provision, except the United States cannot be sued without its consent, only implies a statutory context. So if they have to, the consent manifests itself in the form of a statute. You have to produce a statute when you want to sue the government for an obligation. And if you can't produce the statute, then they have not waived sovereign immunity, and therefore they are immune from the suit. Okay. However, remember that the civil statutes, only regulate public conduct of public officers on official business. So if you're not the subject of the statutes, any of the statutes, because you're private, then you don't have to produce any statute. All you have to prove is that they invaded your sovereign immunity, and that you never waived it, and that they cannot, if they can't produce evidence that you never waived it, then they stole from you. Just like they would accuse you of stealing from them if you tried to sue them and they didn't waive sovereign immunity, because we're all equal, right? If they have sovereign immunity and they're a government of delegated powers, then you must have it too, because you can't delegate what you don't have. So if you have it, then they have the burden of proof as the moving party if they want to enforce an obligation on you, and that proof has to come in the form of written consent, just like with them, in the form of a statute. The statutes are the method of providing that consent, in fact, but only among the community of people who are public officers on official business, because that's what the statutes regulate. That's what the only thing they regulate if they're civil statutes. United States versus Bostwick, 94 U.S. 53. The United States, when they contract with others, with their citizens, are controlled by the same laws that govern the citizen in that behalf. So in other words, the United States and the citizen are equal. And Cook versus United States, 91 U.S. 389, explaining that when the United States comes down from its position of sovereignty and enters the domain of commerce, it submits itself to the same laws that govern individuals there. And once again, they're simply emphasizing here that you are equal to the government in every respect. And the only way you can become unequal is to consent to it. And if you're not on federal territory, if you're within the state and you're protected by the Constitution, then you're not allowed to consent. So you cannot lose that equality. For further information on this subject of consent in the context of private law, see the free pamphlet on our forms page entitled Requirement for Consent, Form 05.003. So now let's talk about deception by confusing private law with public law. Those in government intent on usurping power will pass a private law that only applies or requires the force of law to people who expressly consent, and then they will write the law and the definitions in that law so that it is so vague that it is difficult for the average person to discern whether it is a public law or a private law. And then they will lie to the people by pretending that it is public law that everyone must obey, and they usually do this in the courtroom. They don't typically do it in their publications, even though it really only applies to people who are individually consent. And then they will prosecute people who lawfully don't consent to participate by violating the law in question in order to scare the rest of the people into obeying. So in other words, it's like somebody will shove a contract, because the public law, the civil statutory laws are like they're a compact, is what the Supreme Court said, a social compact. And so let's bring this down to something you can understand. If you and another person are sitting at a table and they write a contract and they put 2 lines for signatures at the end and they sign the contract and then they shove it in front of you and you haven't signed it yet, then is that contract law for you? And the answer is no, not until you sign it, or not until you at least act like you consented to it. Okay, that's called implied consent. Now, however, a corrupt government will shove that contract in front of you, which is the civil statutory law in this case. They'll shove it in front of you, and then they'll call it law for you, even though it isn't, because you haven't consented yet. And then they'll refuse to satisfy the burden of proving that you did consent. And then they'll throw you in jail for violations of that law without ever proving that you were a party to it. That's theft. That's slavery, and that's fraud. And you ought to forcefully oppose all that sort of abuse. And the starting point for opposing that abuse is Federal Rule of Civil Procedure 17, which says the capacity to sue or be sued shall be determined by the law of the party's domicile. So if you don't have a domicile in their jurisdiction, then they cannot enforce that statute, that civil statute, against you, ever. And if they do, they're doing kidnapping, identity theft, and what we call theft by presumption. They're presuming that you're subject to it without ever having to prove it. In other words, they want you to join their religion, their system of beliefs that are not supported by any evidence. That's what it is. And they want you to join their little church as a parishioner and worship their little pagan deity, which is the judge and all the licensed attorneys in the courtroom. And they want you to bow down and worship at his throne, which is the judge's chair, which is high above everybody else. That's what it is. It's religion. That's why he wears a robe. That's why he chants in Latin like a Catholic priest does. That's why he uses Latin phrases to conceal the nature of what he's doing so he can steal from you. It's a religion in every particular. And if you walk up there and you obey him, you're performing a human sacrifice, and you're the sacrifice. You're sacrificing your rights, your private rights, your property, your time to this pagan deity, this priest called the judge. So here's another example. Internal Revenue Code Subtitle A. It's private law for those who individually consent to lawfully occupy a public office in the government, and no one else. And filling out and submitting the following forms constitutes prima facie evidence of consent to lawfully occupy and exercise a public office. W4, 1040, and SS5. All of those are resident forms or employee forms that are only applied to employees within the national government. And why do we say that? Because the Supreme Court said the ability to regulate private rights and private conduct is repugnant to the Constitution. So those forms cannot pertain to private parties. And we might add that the purpose of establishing governments is to protect private rights. And the very first step in protecting it is to prevent it from being converted to public rights or public offices. And yet that's what these forms do. They are being abused to illegally convert private people into public officers and volunteers in the government. They can't do that. That's a crime. 18 U.S.C. 912. And the main parties who are the subject to the Internal Revenue Code are those who have income or gross income connected with the trade or business franchise, which is a public office franchise, and it's an excise taxable activity within the franchise agreement, which is the Internal Revenue Code, subtitles A and C. That's a franchise. And it's just like the McDonald's franchise. If you don't have earnings connected with the trade or business franchise, then you can't have a tax liability. And why do we say that? Because the information returns are the method of reporting those earnings. And those information returns, like the W-2 and the 1099 and the 1098, cannot lawfully be filed unless you are lawfully engaged in a, quote, trade or business, unquote, which is defined as a word of art in the statutes as, quote, the functions of a public office. So anybody that files those against you is creating legal evidence that you are lawfully engaged in a public office. And in most cases, that evidence is false and fraudulent. And in most cases, the filers should be criminally prosecuted for filing false returns, because those information returns are returns. And so everybody who files those against a private party ought to be in jail. And if that were done, the whole tax system would instantly shut down, and Uncle would dry up like he should. Now, those who don't have earnings connected to the trade or business are sometimes lied about, as we said, by ignorant third parties who file these information returns. The government sometimes prosecutes and enforces against people who are the subject of the false and illegal reports in order to terrorize them and others who are not engaged in the trade or business in order to improve, quote, voluntary compliance. So in other words, they facilitate, the IRS encourages and facilitates the filing of knowingly false reports, the information returns against those who are not public officers on official business. And by doing so, they are terrorizing and stealing from people in states of the Union, and they are conducting what we call a commercial invasion of the states, which are legislatively foreign jurisdiction. And that is a violation of Article 4, Section 4 of the United States Constitution. Law, in a common law or constitutional or classical sense, applies equally to all because all are equal. But the Internal Revenue Code only applies to public officers, so obviously it's not law because it doesn't apply equally to everybody. It is what the Supreme Court called in Pollock, quote, class legislation, unquote. And the class of people that it applies to are people in the government. And why is that? Because they can't regulate private conduct. And the Supreme Court said in Hale versus Henkel that the private man owes nothing to the government. However, the public office or the public person, instead of the private man, is a creation of the government and owes everything, its entire existence, to the government and has to do whatever the government says. Completely different concept. And we also add that a compact or franchise, which are agreements or contracts, only acquires the, quote, force of law, unquote, and becomes, quote, law, unquote, binding on the parties after they consent and not before. And it is the duty of anybody asserting to enforce that compact or franchise to produce evidence of consent on the record of the proceedings. Instead of just saying, I challenge jurisdiction of the court, you say, I challenge the prosecutor to produce legal evidence on the record that I, first of all, have a domicile on federal territory and therefore am subject to the civil laws of Congress, and that I consented to the specific status under those laws called taxpayer before you can enforce those laws. Otherwise, they have no force of law. And you can play all the games you want and call them law, but technically they're private law at that point, and you never signed the contract. And as we said, the Declaration of Independence, the origin of all just powers of government is the consent. So consent ought to be at the forefront of every dispute in court. Your consent. Otherwise, the court and the judge are acting unjustly. And many judges are called justices. So their first duty is to make sure that you are left alone by the government, unless you waive that right by signing up for a franchise and also having a domicile on territory to be eligible to sign up. So before someone consents to a compact or franchise, it is not law for them, and it has no force of law, and is nothing more than a proposed relationship requiring consent to acquire the, quote, force of law. Examples of franchises include the civil portions of the following: the family code, the vehicle code, and the tax code. In truth, compacts and franchises are private law, but not law as defined here. Why? Because it has to apply equally to everybody. And if it only applies to people that consent, it doesn't apply equally, does it? Because society can be divided into two groups of people for everything. The people that consent to the franchise and the people that don't consent. And for everybody else that don't consent, they are considered foreign, alien, and non-resident, and not parties to that so-called, quote, law. So in a sense, they're not parties to the compact or franchise. They're not contractors. They're not contractors of the government if the government is offering the compact or franchise. Because every time you contract with somebody, you are creating agency. You're recognizing agency. And the agency, if you sign a contract with some other guy and you promise to deliver something, then you become an agent of that guy. And you're an agent, at least from the perspective of your obligation to deliver the consideration called for under that, or performance called for under that contract, aren't you? So at that point, you're an agent of the other party. And if you violate that agency and step outside the bounds of that agency and refuse to do what you're obligated to do, then you breached the contract and you stole property, and you should be prosecuted and maybe even jailed for it because you stole the property. Those who call compacts or franchises law without adding private in front of them are deceiving you. And this happens all day, every day. It happens at the IRS. It happens even out of the mouths of federal judges. It happens out of the mouths of federal prosecutors. They're all liars unless they recognize the civil statutory laws as compacts and franchises and private law that doesn't necessarily apply equally to everyone. Very important subject. And on the next page, here is a quote from a book about the history and system of common law written by a Harvard law professor called Roscoe Pound. And here's what he says about this subject, this division between private law and, quote, law. He says, municipal law, thus understood, is properly defined to be a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. It is also called a rule to distinguish it from a compact. And we said all franchises are compacts, and even the civil statutory law is a compact. Or agreement. For a compact is a promise proceeding from us, meaning a contract. All compacts are contracts. Law is a command directed to us. The language of a compact is, I will or will not do this. That of a law is, thou shalt or thou shalt not do it. It is true that there is an obligation, by which they mean here the force of law, which a compact carries with it equal in point of conscience to that of a law. But then the original of the obligation is different. In compacts, we ourselves determine and promise what shall be done before we are obliged to do it. In laws, we are obliged to act without ourselves determining or promising anything at all. Upon these accounts, law is defined to be a rule. So if a U.S. attorney drags you into court to enforce a franchise like the Social Security Act or the tax code or the vehicle code or some other stupid or Obamacare or any number of other things, every single one of those are franchises. Why? Because the 13th Amendment prohibits involuntary servitude and the 5th Amendment prohibits unlawful takings of property. And all of those franchises do both of those things to people if they're enforced against people who are not party to them. Okay? So you have to consent to participate first. And you can't even consent unless you're on physical territory at the time you consent. If you're on land protected by the Constitution, your rights are unalienable, as we keep saying, and therefore you're not even allowed to consent to give them away. So they can only be offered to people on federal territory, domiciled on federal territory. And you're not domiciled on federal territory if you're domiciled in a constitutional state. And if you look in all the definitions of the Social Security Act, in 42 U.S.C. 1300 series, you'll see that the definitions very consistently describe a state as a territory of the national government and not a constitutional state, because they can't offer franchises in a constitutional state. That's what the Supreme Court said in the license tax cases after the Civil War. So, how do we withdraw consent to private law or franchises? How do we remove our consent? For contracts or trusts, it's governed by the contract, whether you can quit or not. For the Social Security Act, it's governed by signing and submitting the resignation of compelled Social Security trustee, Form 06.002 on our website. It's also accomplished by IRS Form 4029 and also the Social Security Form 521, which is available on our website as Form 06.005 on the Forms page. For the State Family Code, we remove our consent by getting a divorce and replacing the marriage license with a private contract. For the State Vehicle Code, it's done by rescinding your driver's license and replacing it with either an international license or a letter of disqualification issued by the DMV. And we show how to do that in our book, Defending Your Right to Travel. So if you don't want to be party to any contracts with the government, and you want to restore your equality and freedom, your absolute equality and freedom, then you have to do all these things. And as a matter of fact, if you want to be a member, as a bare minimum, you have to quit the Social Security system, because that is the worst threat to your freedom and your sovereignty. For the Internal Revenue Code Subtitle A, you have to close all financial accounts that are enumerated and reopen them with an amended W-8BEN form or a substitute for it. And you have to open those accounts without SSNs or EINs or TINs, because, as we said, the SSN or TIN create a prima facie presumption that you are lawfully occupying and exercising the functions of a public office. And you're not allowed to do that in most cases, because you can't alienate your rights. You have to be serving in the District of Columbia physically or in a place expressly authorized by Congress. And you need all the proper paperwork indicated under Title V of the U.S. Code to lawfully serve in that office. And most taxpayers never do that, and therefore they are serving unlawfully. And that would probably include you if you're the listener. So they cannot use Social Security numbers for anything ever again. See About SSNs and TINs on Government Forms and Correspondence, Form 05.012, and the Social Security Policy Manual, Form 06.013. And under the Internal Revenue Code, to withdraw their consent, they must submit the IRS Form W-8 to control withholding instead of the IRS Form W-4. For further detailed information on how to control withholding, see About IRS Form W-8BEN on our Forms page, available as Form 04.202. And we have a complete book on the subject of withholding and reporting entitled Federal and State Tax Withholding Options for Private Employers, Form 04.101, available on our Forms page. And this particular document, New Hire Paperwork Attachment, Form 04.203. And this New Hire Paperwork Attachment would be submitted to a company that you want to work with or for and it would be done to correctly describe your status as a person not subject to the franchise and not consenting to the franchise. So essentially you're withdrawing your consent to work for Uncle as a public officer. Notice we didn't say an employee or an employer. We just said a public officer because there's lots of different kinds of public officers, not just employees and employers. If you file Form 1040-NR, if you file, then you have to file Form 1040-R or a substitute, a non-resident form, basically, because a resident is just a public office in the government. That's what it says in the regulations, the earlier regulations. Otherwise, you're electing to be treated as a, quote, statutory person, unquote, with a domicile on federal territory, which is false and illegal in most cases. And 26 USC 6013 G and H say that the only statutory non-resident aliens who can elect to be treated as resident aliens and file a Form 1040 are those married to statutory U.S. citizens domiciled on federal territory. Very few people meet this requirement. And to withdraw consent to the Internal Revenue Code Subtitle A franchise, we must correct all false information returns indicating trade or business earnings, such as the W-2, the 1098, and the 1099. And we provide lots of different forms to help you do that. The first one is Correcting Erroneous Information Returns, Form 04.001, on our forms page. And this shows you all the various ways that you're illegally connected to and falsely connected to a public office in the government. We also have one for correcting a letter, Corrected Information Return Attachment Letter, Form 04.002, that allows you to send correspondence to correct the false information returns. We have Correcting Erroneous IRS Form 1042S's, Form 04.003. We have Correcting Erroneous IRS Form 1098s, which are mortgage forms, Form 04.004 on our forms page. We have Correcting Erroneous IRS Form 1099s, which are independent contractor type workers, Form 04.005. And we have Correcting Erroneous IRS Form W-2s, which is Form 04.006. And finally, to withdraw consent and protect our status as a private party, we must educate financial institutions and companies we deal with about what the law requires so that they quit filing false information returns against you in the future. It's very important. Words of art. So let's talk about, and we call this lawyer deception using definitions. That's what it is. It's designed to deceive the reader. That's the only purpose for it. And to sanction identity theft and theft on the part of judges and government prosecutors. That's the main purpose for the abuse of these words of art. And there are lots of these words. And as we said, you need to read the definitions first before you read the rest of the code or the regulations. And these are the most common words of art that you're going to see in the tax codes, at least. The first one is, and we put it in quotes here to emphasize that this is a word of art. If it's not in quotes, then it's a common use of the word instead. Quote, trade or business, unquote. It means it's defined in 7701, 26 USC 7701A26 as the functions of a public office. And we emphasize here that you cannot perform, quote, the functions of a public office, unquote, without being a public officer. It's a legal impossibility. So automatically, if anybody files a piece of paper connecting you with a trade or business, effectively they are electing you, unlawfully usually, into a public office in the national government. So in other words, all these information returns that people are filing, the W-2s, the 1098s, the 1099s, and the 1042S's, all of those information returns are being used as, quote, federal election devices, unquote. And they are used essentially unlawfully to elect you unilaterally into a public office. That is fraud, and it's a crime. And because they are information returns and because they're therefore returns, then they are false returns. And everybody who files those should be criminally prosecuted. Another word of art is personal services, quote unquote, which is defined as work performed by an individual in connection with a, quote, trade or business, unquote, 26 CFR 1.469-9B4. And the word individual is also a public office. So it's work performed by a public office in connection with a trade or business or public office. That's what a trade or business is. So if you're a private human being and you're not a public officer, then it's impossible to perform personal services. Another one, quote, employee, unquote, which is a privileged, elected, or appointed officer of the United States government. And that's found in 26 USC 3401C and 26 CFR 31.3401C-1. That's the regulations. CFR is the regulations. Quote, employer, unquote, which means someone who has employees, unquote. Technically, this means the federal government only in the context of taxes. See 26 USC 3401D and the Internal Revenue Code. Quote, United States, unquote, which means the District of Columbia, federal territories, or enclaves within the states of the Union. So that would be effectively the United States **, which we talked about earlier, the second definition or geographical definition of the United States, which means it doesn't apply inside of a state of the Union. And the rules of statutory construction forbid adding anything to those definitions. State, quote unquote, is legally defined as a federal territory or the District of Columbia. See 4 USC section 110D and 26 USC 7701A10. And quote, state, unquote, lowercase means a state of the Union. And why the difference between an uppercase state and a lowercase state? Because the rules of statutory construction and capitalization say that when the word state is capitalized, it is within the sovereign who is writing that particular law. And when it's lowercase, it means a foreign sovereign, a sovereign outside of the sovereignty that's writing that particular law. Quote, tax, unquote, means a pecuniary sum extracted under the authority of law and used only for the support of the government and not the citizens. And if it is used to pay citizens, or generally, or it's used for wealth transfer, as we said earlier, then the Supreme Court said that is not, quote, taxes, unquote, and that it is robbery under the guise of legislation, but it is not even law if it accomplishes that. And, quote, U.S. citizen, unquote, also called a statutory citizen in this presentation, which is a person domiciled in a territory or the District of Columbia, federal territory, under 8 USC 1401, which includes the District of Columbia, Guam, Puerto Rico, or the Virgin Islands. So you're not a citizen under federal law or national law unless you occupy those areas. If you're domiciled in a state, then you're not a U.S. citizen under federal statutory law. Yes, you're a citizen under the Constitution. Yes, you're a 14th Amendment citizen of the United States. Yes, you're a capital C citizen under the Constitution, but you're not a statutory citizen. Because why? Because there are two contexts for all legal terms. There is the constitutional context and the statutory context. The constitutional context applies to states of the Union and excludes federal territory, whereas the statutory context applies to federal territory and in most cases excludes states of the Union. They're completely mutually exclusive. And this switcheroo of context that they do between the constitutional and the statutory is the origin of all the usurpations that we oppose. So you need to be very, very aware of it. Quote, wages, unquote, which is monies earned by a person who has a voluntary W-4 withholding agreement in place with the U.S. government. And by the way, you can't even volunteer to earn wages if you're not already a public officer before you fill out the W-4. Okay, because you cannot use a W-4 to effectively, quote, elect, unquote, yourself into a public office. That's a crime, 18 U.S.C. 912. And if you commit that crime, another crime follows, which is bribery to procure an appointed or elected public office, which is also a crime under Title 18. Because the withholdings upon your pay at that point become a bribe for uncle to treat you as a public officer, and they can't do that. That's a violation of the separation between the private and the public. And it's an abuse of private property to procure public benefits. It's theft. It's fraud. Quote, income, unquote, which means corporate profit only. The Internal Revenue Code does not define this term, and the Supreme Court says it can't. In Eisner versus Macomber, they said that. They cannot define income to mean anything other than that. Moving on. Laws are void if they are vague. And this concept is called the void for vagueness doctrine that was created by the Supreme Court, the U.S. Supreme Court. If you have to guess what the law really requires or what is, quote, included, unquote, in the definitions, or you have to rely on an expert or a computer to understand or interpret it, the meaning or implication of that law, then it's an unconstitutional law. And your due process has been violated under the 5th and 6th and 14th Amendments. And the government is trying to replace our society of laws with a society of men and thereby corrupt it. The, quote, men, unquote, who become the agents of corruption in that case are lawyers and judges and the people who write the laws. See Marbury versus Madison, 5 U.S.C. 137. And here are some authorities on this subject. Men of common intelligence cannot be required to guess at the meaning of penal enactments. Winters versus People of the State of New York. And, quote, law fails to meet requirement of due process clause if it is so vague and standardless that it leaves the public uncertain as to conduct it prohibits or leaves judges or the jurors free to decide without any legally fixed standards what is prohibited and what is not in each particular case. And this concept, and that's Giacchio versus State of Pennsylvania. And this concept applies equally well to the definitions. The definitions, as we said, based on the rules of statutory construction, are designed to describe everything or class of thing that is expressly included in the meaning. And anything not purposefully included in those definitions is safely presumed to be excluded under the rules of statutory construction, and that's called the exclusio rule. For more information on the requirement for reasonable notice of what the law demands, see the requirement for reasonable notice, Form 05.002, and the meaning of the words includes and including, Form 05.014. And those two documents go into excruciating detail about the fact that the law, due process is violated if they don't give you notice of what's included. And the law must contain everything that's included, and they can't add whatever they want to the meaning after the fact or in an IRS meeting or in a jury box. They're not allowed because jurors cannot act as legislators. So they cannot add to the definition or the things included in the definition. And if they do, they're usurping the authority delegated exclusively to the legislative branch. So, what is government? The purpose of government is to protect private rights of everyone, not just citizens. And rights include the right to life, liberty, and property. And if you look carefully into the meaning of the phrase life, liberty, and pursuit of happiness, the phrase pursuit of happiness and property are the same thing. They are synonymous. So anybody that tries to deprive you of property is indirectly trying to deprive you of happiness. They are maliciously destroying your happiness. Any of the following are not, quote, government, unquote, functions, but anti-government functions. They refuse to recognize private property or private rights. Why? Because that makes you unhappy. It prohibits you from having private property, right? If you can't have property, then you're unhappy because pursuit of happiness is property, the property right. Or they interfere with efforts to invoke or enforce the common law, which protects only private rights. And or they convert private property to public property without the express consent of the owner. And they do it in a lot of ways. They'll do it by describing things with words of art. They create the appearance that the property is public. Like they'll call you a, quote, person, unquote, or a, quote, taxpayer, unquote, or a, quote, driver, unquote, and thereby create a false presumption that you're subject to private laws that only apply to public officers and franchisees, of which you are not. So we call it theft by presumption or eminent domain by presumption. They just presumptuously use the words, and if you don't challenge those presumptuous uses, then you consent to them. And that's called sub silentio, consent through silence. Another thing they try to do is convert private property to public property in a constitutional state. Inalienable rights cannot be bargained away or sold, or even with your consent. You cannot consent to give away private property to a government unless you're on federal territory. Otherwise, your rights would not be unalienable, would they? which means you cannot consent to a franchise, which converts private property to public property without being physically on federal territory at the time you consent, and without the property itself being on physically on federal territory that they want to enforce against. Another thing they do to act in a non-governmental format and perform anti-governmental functions is to make a profitable business or franchise out, or compact for that matter, out of alienating private rights or selling them to the highest bidder. Because after all, what is a public officer? A public officer is somebody who's in charge of protecting private rights. And that's his first duty. And if he doesn't do that duty, he is breaching his fiduciary duty as a public officer. And it's even worse if he breaches that fiduciary duty by converting your private rights to public rights or public property by abusing words of art and then auctioning off the property to other people by transferring it. That's theft. Another way they do it is to enforce the civil statutory law against those not domiciled where the said laws apply. If you're not domiciled on federal territory, then federal civil law doesn't apply. And it's an unconstitutional eminent domain, as we say here, and a conversion of private rights to public rights without the consent of the owner. So when they go outside of their territory, because remember we said a government consists of three things: people, law, and territory. And all three of those things go together. When you go outside that territory, there's no law. They cannot extend their jurisdiction outside their own territory without at least exercising their right to contract, and if they don't respect that limitation, then they're engaging in international terrorism against foreign states, and they're violating the laws of nations and international law at that point. They're invading a foreign state and a foreign country, and states of the Union are legislatively foreign under the civil laws of Congress. They're not foreign under the Constitution, obviously, but they're foreign under the civil statutory enactments of Congress because of the separation of powers. And what they try to play all kind of games by pretending like you're a citizen, on federal territory, even though you're in a state, or they'll use all these crazy words of art to try and deceive you into thinking that you owe them an obligation or you owe them property, because they're basically just thieves. And most people are so ignorant that they get away with it most of the time. And the purpose of this presentation is to prevent that abuse. All governments are corporations, as held by the U.S. Supreme Court. And they said this in Proprietors of Charles River Bridge versus Proprietors of Warren Bridge. Corporations are also of all grades and made for varied objects. All governments are corporations, created by usage and common consent, or grants and charters, which create a body politic for prescribed purposes, but whether they are private, local, or general in their objects, for the enjoyment of property or the exercise of power, they are all governed by the same rules of law as to the construction and the obligation of the instrument by which the incorporation is made. One universal rule of law protects persons and property. It is a fundamental principle of the common law of England that the term free men of the kingdom includes all persons, ecclesiastical and temporal, incorporate, politique, or natural. It is a part of their Magna Charta, and it is incorporated into their institutions. The persons of the members of the corporation are on the same footing of protection as other persons, and their corporate property secured by the same laws, which protect that of individuals. No man shall be taken, no man shall be diseased without due process of law is a principle taken from the Magna Charta, infused into all our state constitutions, and is made inviolable by the federal government by the amendments to the Constitution. God and government are competitors in providing protection to the people. People flock to government mostly out of fear or covetousness because they want benefits, and people flock to God mostly out of love and protection, eternal protection. Governments expand their jurisdiction by maximizing fear in the people, or covetousness, by the way. God says not to fear, Matthew 6:25-34, and the result of excessive fear by people eventually is a totalitarian government and tyranny. Recent abuses resulting from terrorism, such as the USA Patriot Act, have demonstrated this practical result. Churches expand their influence by proclaiming God's love. When fear and love are in balance and in their proper proportions, then church and state separation are balanced, and liberty is maximized. Governments and taxation. The only legitimate purpose of government, or a purpose of taxes, is to support government, not the people or the constituents. And here's what the Supreme Court said on this right around the time that the Social Security Act was enacted in 1935. This was just after that act. U.S. versus Butler. A tax, in the general understanding of the term and as used in the Constitution, signifies an exaction for the support of the government. The word has never thought to connote the expropriation of money from one group for the benefit of another. Therefore, the government cannot pay benefits and cannot pay monies derived from taxes under the meaning of the Constitution to a private citizen or a private person. The only thing they can pay it to is a public official or a public officer on official business exercising the sovereign functions of the government. Otherwise, they're abusing their taxing power. When taxes are used for bribery and wealth redistribution instead of supporting the government only, then all governments, judiciaries, and tax collection systems invariably become corrupt. Governments invariably grow out of control because of their thirst for money and power, and the liberties of the people are eliminated one by one as taxes are increased, and the tax code becomes a means of political control. In essence, a government of this type replaces a citizen with an employee. So everybody in this sort of a government is an employee who works for the government, and the, quote, benefits, unquote, paid by the government are their employment compensation. And if everybody does that, there is no republic, and there is no government. All you end up with is a giant corporate monopoly that violates the Sherman Antitrust Act and eventually collapses, like our present government is doing by spending more than half the federal budget on borrowed money. To pay the benefits, we might add. Taxes, in theory, are supposed to pay for government protection. Here is how one congressman ably described it during the 16th Amendment debates. And this was the income tax amendment. So when they're trying to enact the income tax, this is what the congressional debates said. M. Thiers, the great French statesman, says, a tax paid by a citizen to his government is like a premium paid by the insured to the insurance company, and should be in proportion to the amount of property insured in one case and the amount of property protected or defended by the government. That's volume 44 of the Congressional Record, page 4959 in 1909. In fact, what we pay to the present de facto government is, quote, protection money, unquote, paid to a criminal protection racket. And it's a protection racket because they won't give you the choice about whether you want to be an employee who receives benefits or a private human who is not an employee. They never offer you that option. They force you at gunpoint to become an employee eligible for benefits and therefore no longer a citizen within the meaning of the Constitution, or a government that you're working for being a government either. It's just a de facto government at that point. The tax is used to bribe government into illegally treating us as public officers and receiving the benefits of an office you cannot and do not lawfully occupy, and is what we pay is stolen money laundered to constituents. The only way it wouldn't be stolen is if they protected your right to not procure their protection. Anything not voluntary is theft. The only difference between a theft and a donation is consent. And as the Declaration of Independence says, all just powers of the government derive from consent. If you don't consent to be taxed, if you don't consent to be a taxpayer, if you don't consent to be a citizen, if you don't consent to be a member of the club called the state, the only thing they can do is leave you alone, because government only has two purposes: to govern those who consent and to otherwise protect your right to be left alone. That's it. And that right to be left alone is what justice is defined as. So They can only civilly govern people who consent, and otherwise they have to leave you alone. If you don't join the club, then the rules don't apply. The civil rules, statutory rules. Separation of powers. The purpose is to limit the size of government, to prevent concentration of power, and to limit government corruption. The greater the separation, the greater the protection. The founders originally gave us the following types of separation of powers. Separation of marriage and state, because the marriages were unlicensed. Separation of family and state, because the family was considered sovereign, and spouses, for instance, could not be required to testify against each other because it destroys the family. Separation of school and state, because originally schools were private. All schools were private through local townships, and the government tried to, through the property tax scam, tried to force people to pay for public schools. That's a scam too, because the whole idea of property tax is an oxymoron. Property is the right to exclude all others from using or benefiting from the use. So by definition, you cannot tax that which is property. And it's not yours if they can take any portion of it. They're just thieves. That's not to say that you couldn't sign up for a public school or that you shouldn't have the right to do it, or something suggesting that you shouldn't be forced to pay through property taxes, which is an oxymoron. Separation of retirement and state, because people saved in gold coins and private banks. Separation of church and state, because the church was essentially not a civil person under the laws of the government, so they could not be regulated by the government. Separation of money and state, because the money was a commodity, gold or silver, and since the government couldn't print silver, then they couldn't make unlimited amounts of money, and therefore they could only raise money by borrowing it from others. And separation of the states and the national or federal government. Each was a separate foreign power with respect to the other. So the civil laws and the criminal laws of the national government don't apply in the state, and likewise the other direction. The above types of separation of powers have been constantly eroded over the years, mostly by government, in order to expand its power. For further details on the separation of powers, see our detailed treatment in The Government Conspiracy to Destroy the Separation of Powers, Form 05.023 on our website. The Constitution. The United States is a federal corporation. 28 USC 3002 15A. The United States, quote unquote, meaning a word of art, means a federal corporation. The reason we keep having Enron scandals is because companies are simply emulating the criminal mafia behavior of the mother corporation, the U.S. government. That U.S. government is what creates all these other corporations. And we might add that corporations, by their very nature, are considered instrumentalities of the government that authorize their creation. And that a state corporation and a federal corporation are different. And that you cannot be both. You're one or the other. You're a state chartered corporation or you're a federal chartered corporation, but not both. And what the corrupt people in the district of criminals, as Mark Twain calls it, what they try to do is they try to make you be both at the same time by forcing you to apply for an EIN, employer identification number, so you're subject to the laws of both. But that causes you to serve three masters, God, and then two different governments, the state government and the federal government. And you should never, ever consent to serve more than one master at a time. So you cannot, if you're a federal corporation, you should never consent to be a state corporation. If you're a state corporation, you should never consent to be a federal corporation. And if you're a private human, you should never consent to be anything public, whether it's a public officer or a public corporation or a public entity of any kind. That is how you maintain the separation between public and private and the separation of powers, and keep the government in the 10-mile square box, the District of Columbia, that the founders put them there. The Constitution is the corporate charter of this corporation, US Inc., and it is written by we the people in the states. The states authorized it and voted on it. And it is a sacred contract between the people and their government officials, and it creates a fiduciary relationship between the people as masters and their elected or appointed officials as servants. It creates a servant-master relationship. You are the master, not them. We don't work for the government. They work for us. And what they want to do is try to turn that relationship around by bribing you with benefits to unlawfully occupy a public office. The U.S. Constitution does not bind citizens, but only government officials. It is a document of limitation on government power, and it prescribes both what governments can and cannot do. All powers not delegated to the federal government are reserved to the states or the people under the 10th Amendment. The USA is a republic and not a democracy. Black's Law Dictionary, 7th edition, defines republic as follows: a system of government in which the people, that is, as individuals, hold sovereign power and elect representatives who exercise that power. It contrasts, on the one hand, with a pure democracy in which the people or community as an organized whole wield the sovereign power of the government, and on the other, with the rule of one person, such as a king, emperor, czar, or sultan. The entity that holds the sovereign power defines what type of government a country has as follows. If it's a single individual, such as a king or a monarch, then it's a monarchy. If it's the people as a collective and not as individuals, then it's democracy or socialism. And if it's the people individually, then it's a republic. So by definition, unless the only sovereign is the people as individuals, then you don't have a republic. If the collective is made superior to the individual, then you end up with socialism and collectivism, and we already described that that doesn't work, and that it creates an unconstitutional civil religion, in fact, that is based on inequality between the governed and the governors. And the minute you lose your equality is the minute the people ruling you cease to be government. The founders believed that democracy was to be avoided in favor of a republic based on individual rather than collective rights. And here's what James Madison said in the Federalist Paper number 10 on this subject. Hence, it is that such democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. And what he's describing there is the mechanism by which the taxing power of the government is abused to transfer wealth. And that is how all democracies self-destruct, is because the people will always vote the maximum benefits to themselves and the abuse of the taxing powers. And when the government becomes an agent of bribery and wealth transfer, then all property rights are destroyed and all incentive to work is destroyed, because at that point you don't own anything, because they can't tax it unless they own it or have an interest in it. And the whole foundation of property rights is the right to exclude everyone and anyone from using or benefiting from the use, including the taxation of private property. So all democracies self-destruct when you hand the central government the right to counterfeit money with a printing press, and the right of the people to abuse their voting powers in the ballot box to vote themselves benefits, or to even sign up for benefits. At that point, it's over. And that's what Social Security did, starting in 1935, and we're now feeling the long-term effects of that, which eventually will sink the ship of state and destroy our republic. Any attempt to ignore or undermine the Bill of Rights in favor of the majority vote or the public good is an attempt to turn a republic into a pure democracy. In other words, any attempt to make the collective have greater or superior or supernatural powers above that of the personal individual will ultimately replace a republic with a democracy. All republics are based on individual rights. All democracies are based on collective rights with no individual rights. And all democracies are collective in nature, and they presume that the superiority of the collective above that of the individual. And all corruptions of government originate from collectivism, whether it's communism or socialism or fascism or Nazism or any other type of collective government. It ultimately, if the state is the origin of all rights and all those rights are revocable, and the collective decides what those rights are, it's over for personal rights or personal security or anything, or property ownership or happiness or anything. Because, as we said, the pursuit of happiness, as used in the Constitution, is synonymous with the right to exclusively and privately own property and exclude all others from using or benefiting from that property. To the extent that juries override this Bill of Rights in favor of the collective sovereignty and at the expense of individual rights is the extent to which they corrupt and undermine our republican system of government. And democracy is the first step in the continuum between a pure republic and a pure communism. And it's next after socialism. And along these lines, you can watch at this link here, if you click on it, you can play Red Skeleton's Pledge of Allegiance, which is really good and helps illustrate these points. We highly recommend it, but because of copyright considerations, we won't include it in this presentation. There are two political models at the national level of the American government. Our federal government legislates for two separate and distinct political communities or jurisdictions. The, quote, United States, unquote, which is the federal corporation consisting of the district of what Mark Twain calls the District of Criminals, and the territories and possessions, also called the District of Columbia, and, quote, the United States of America, unquote, consisting of the 50 states of the Union. That United States of America was created by the Articles of Confederation, and that United States at the top here was created by the United States Constitution that followed the Articles of Confederation. Each of these two political jurisdictions has its own unique set of governing laws, citizens, and territory. United States, the federal corporation, consists of the federal zone only and is the proper and only subject of most federal statutes and acts of Congress. And people born in the territories are called citizens and nationals of the United States under 8 USC 1401. And it is not covered by the Constitution or the Bill of Rights. The Constitution does not apply inside a federal territory. That's what the Supreme Court determined in Downs versus Bidwell. The United States of America is the 50 states, and it is only subject to federal jurisdiction in the context of foreign commerce or commerce between states under Article 1, Section 8, Clauses 1 and 3 of the Constitution, and slavery under the 13th Amendment. The national government also has jurisdiction over mail fraud under Article 1, Section 8, Clause 7, because it's interstate commerce. And it has jurisdiction over counterfeiting under Article 1, Section 8, Clause 5 of the Constitution. Persons born in states of the Union are called statutory non-citizen nationals, or simply nationals, under 8 U.S.C. 1101A21. And those in the constitutional states or the United States of America are protected by the Bill of Rights and the U.S. Constitution. And we emphasize they are not protected by any federal legislation. You cannot invoke any provision of the Internal Revenue Code, which is limited to federal territory. You cannot invoke any provision of the Social Security Act. And in many cases, even the vehicle code of most states. You cannot invoke those in a constitutional state. All of those franchises presume domicile on federal territory or that you are representing an office that is domiciled on federal territory. Otherwise, your rights are unalienable, which means you're not allowed to consent to give them away, even if you want to get the goodies. The federal zone. The federal zone consists of the District of Columbia, enclaves within the states of the Union, and the territories and possessions of the United States. The federal zone, as a term, is recognized and even used by the U.S. Supreme Court. See U.S. versus Lopez in 1995. Each of these schools now has an invisible federal zone extending 1,000 feet beyond the boundaries of a school property. In some communities, no doubt it would be difficult to navigate without infringing on these zones. Yet throughout these areas, school officials would find their own programs for the prohibition of guns and danger of displacement by the federal authority unless the state chooses to enact a parallel rule. We could not find a reference to this term in any federal or state statute, and we use the term to describe the area over which the sovereignty of the United States is exclusive, general, and absolute under Article 1, Section 8, Clause 17 of the Constitution. We emphasize that the exclusive sovereignty of the United States under Article 1, Section 8, Clause 17 also extends to areas other than the federal zone, such as admiralty or maritime jurisdiction, which includes territorial waters of the United States. We sometimes refer to this federal zone area as the, quote, federal United States, unquote, throughout our publications. Next, we're going to talk about police powers. And here's the legal definition from Black's Law Dictionary. Police power, an authority conferred by the American constitutional system and the 10th Amendment, U.S. Constitution, upon individual states and in turn delegated to local governments through which they are enabled to establish a special department of police, adopt such laws and regulations as tend to prevent the commission of fraud and crime, and secure generally the comfort, safety, and morals, health, and prosperity of the citizens by preserving the public order, preventing a conflict of rights in the common intercourse of the citizens, and ensuring to each an uninterrupted enjoyment of all the privileges conferred upon him or her by the general laws. The power of the state to place restraints on the personal freedom and property rights of persons for the protection of public safety, health, and morals, or the promotion of the public convenience and general prosperity. The police power is subject to the limitations of the federal and state constitutions, and especially to the requirement of due process. Police power is the exercise of the sovereign right of a government to promote order, safety, security, health, morals, and general welfare within the constitutional limits, and is an essential attribute of government. Marshall versus Kansas City, Missouri. Now, we emphasize that the federal government has no police powers inside states of the Union, but it does have such powers in federal states, which include only territories such as Puerto Rico, Guam, and the Virgin Islands. Police powers are equivalent to legislative jurisdiction, and the Internal Revenue Code is legislation. The implication of no federal police powers in states of the Union is that the United States, quote unquote, means states of the Union in the U.S. Constitution, while United States equals the federal zone in all federal statutes and acts of Congress by default, unless clearly shown otherwise. And here is what the U.S. Supreme Court said on this subject in Schwartz versus Texas, 344 U.S. 199. If Congress is authorized to act in a field, it should manifest its intention clearly. It will not be presumed that a federal statute was intended to supersede the exercise of the police power of the state, unless there is a clear manifestation of intention to do so. The exercise of federal supremacy is not lightly to be presumed. Now, we emphasize here that the phrase clear manifestation of the intention to do so means that if they have a geographical definition in their code, then that code must expressly include a constitutional state, or it is presumed to not be included. Because when they do that, they're superseding the police power. And that applies especially in the Internal Revenue Code and most franchise statutes. And what they try to do is violate that requirement by subterfuge and words of art and exploiting the ignorance of the people they're talking to. And all of that is a conspiracy against a constitutional right. That's a crime. Quote, state, unquote, equals states of the Union in the Constitution, and quote, state, unquote, means federal territory or the District of Columbia in acts of Congress. So what we're trying to establish here is that there are two mutually exclusive jurisdictions, two contexts in which terms can be used, words of art. And the context is extremely important here. In the Constitution, United States means states of the Union and excludes federal territory, whereas in federal statutes, United States means federal territory and excludes states of the Union. They are mutually exclusive. Very important. So you can be a U.S. citizen under the Constitution and not a U.S. citizen under federal statutes at the very same time. And so it's very important to distinguish the context that you're using the term. And if you want to make sure that no confusion could ever result, you shouldn't use the term at all. You just ought to say you're a non-resident in relation to the national government. And that way you'll never be subject to their laws or their codes or their void for vagueness codes. So next we'll talk about extraterritorial or long-arm jurisdiction. That's what the Department of Justice website calls it. And the definition is jurisdiction outside the general or exclusive jurisdiction of the sovereign state or nation. Extraterritorial jurisdiction of a state of the Union is called long-arm jurisdiction. So in other words, if one state wants to reach outside itself into another state against another defendant in a judicial proceeding, then they have to demonstrate the authority to exercise extraterritorial jurisdiction. And that is done through long-arm statutes in the state codes. Every state of the Union has long-arm statutes that prescribe the conditions under which it may lawfully assert jurisdiction over a non-resident party. The usual conditions for asserting extraterritorial federal jurisdiction are as follows from Yahoo Inc. versus La Ligue contre le Racisme. The non-resident defendant must purposefully direct his activities or consummate some transaction with the forum or resident thereof, or perform some act by which he purposefully avails himself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of its laws. Now, they use the term privilege, and what they're implying here is franchise. Whenever you see the word privilege, you should always think franchise, because that's what it is. And in this case, it's the commercial privilege. And that commercial privilege is the jurisdiction over interstate commerce, the jurisdiction over commerce of people, between people of the state and people outside the state. That's usually the only source of extraterritorial jurisdiction. And that commerce could take many forms. It could take the form of a contract or the ownership of stock in a foreign corporation in another state, or any number of other things, or the will or a trust, or something like that. And the claim must be one which arises out of or relates to the defendant's forum-related activities, and only those activities, we might add. If all you're doing is selling, stuff on the internet to people in a specific state, and those people have to be residents or citizens to be even subject to the protection of that state. If they're not, then they're not, unless it's a common law issue. And so if you're doing mail order into another state, then in essence, you're purposefully availing yourself of commerce in that state. And you're doing so as a non-resident if you're domiciled in a different state. And so that would be the equivalent of foreign commerce. And so the long-arm statutes would apply outside the state, or to property or people outside the state. And it must involve the exercise of jurisdiction, must comport with fair play and substantial justice. And what they mean by fair is they mean equal. So the people at both ends of the transaction must be considered as equal, and the only restraint on that equality is what they personally agreed to in the context of their transaction or their contract that governs their transaction. The usual conditions for asserting a long-arm state jurisdiction are as follows. Number one, transacts any business within the state or contracts anywhere to supply goods or services in the state. This criteria is usually satisfied by addressing the following requirements of the courts in the state. Interest of the state in providing a forum for its residents. Notice they didn't say non-residents. They can't provide a forum for non-residents, only residents. So if you're not a resident, if you don't want to be a resident, if you don't consent to be a resident, then you're not a resident. And in most statutes, the term resident is defined as an alien, and most people are not aliens. So number two, the ease with which the one asserting jurisdiction could gain access to another forum. And number three, the amount, kind, and continuity of activities carried on by the person in the state. And number four, because remember the jurisdiction is limited to that specific activity only. It's not general jurisdiction. It's subject matter over that particular transaction. And number four, the significance of economic benefits accruing to the person as a result of the activities purposefully conducted in the state of Washington, and, for instance, and the foreseeability of injury resulting from the use of the person's product. And number two, commits a tortious act within the state except as to a cause of action for defamation of character arising from the act. So, for instance, if you're driving around and you're traveling between states and you're outside your own state, you're on the highway or you're on the local roads in this foreign state, and you run into somebody and you hurt them, you've committed a tortious act. And although you're not a resident or domiciliary of that state, you were physically present at the time of the injury, and therefore you fall within the jurisdiction of the courts of that state. And the courts can then assert jurisdiction over the injury if the other party, the party injured, is within that state, physically within that state. And the type of jurisdiction that they would assert depends on whether that party is a resident or domiciliary, the injured party, or whether they're merely a non-resident. If they're a non-resident, then the civil laws, the statutory laws would not apply and the common laws would. If they're a resident, then only the statutory laws would apply and the common laws wouldn't. So it depends on the status of the party who was injured, about the type of jurisdiction or the choice of law, so to speak, that they would pick in that dispute. And number 3, owns, uses, or possesses any real property situated in the state. And that term real property is rather deceptive because land is private by default. And it only becomes real property when the state has an interest in it. And in other words, it becomes real in the eyes, the legislative authority within the legislative jurisdiction, it becomes real within the statutes of that state if and only if the state has an interest, an equity interest, or even a title to the property. If the state is not an involved party to the ownership of the property, then it's not real anymore. It's unreal. It's private. And since they don't have jurisdiction over private property, then it's no longer real in their eyes under the civil statutory law. And if it's not real, then it's only protected by the common law. So, and because it's not real under the civil statutory laws, if it's private, then it would also not be subject to the Internal Revenue Code or any other type of tax, franchise tax, which, as we said, only applies to public property that is owned by the government or ownership which is shared with the government. Moving on our extraterritorial long-arm jurisdiction coverage, in the absence of subject matter jurisdiction from a long-arm statute, extraterritorial jurisdiction must originate from what they call comity, which means voluntary consent of the parties who are subject. And here's the definition of comity: courtesy, complaisance, respect, or willingness to grant a privilege, not as a matter of right, but out of deference and goodwill. Recognition that one sovereignty allows within its territory to the legislative, executive, and judicial act of another sovereignty, having due regard to the rights of its own citizens. Noel versus Noel. In general, principle of comity is that courts of one state or jurisdiction will give effect to laws and judicial decisions of another state or jurisdiction, not as a matter of obligation, but out of deference and mutual respect. Brown versus Babbitt Ford. That's in Black's Law Dictionary, page 267. And here's a definition by the Supreme Court of Ohio, Baltimore and Ohio Railroad Company versus Chambers, 73 Ohio State 16. Judge Story, in his treatise on the conflict of laws, lays down as the basis upon which all reasonings on the law of comity must necessarily rest the following maxims. First, that every nation possesses an exclusive sovereignty and jurisdiction within its own territory. Secondly, that no state or nation can by its laws directly affect or bind property out of its own territory or bind persons not resident therein, whether they are natural-born subjects or others. The learned judge then adds, from these two maxims or propositions there follows a third, and that is that whatever force and obligation the laws of one country have in another depends solely upon the laws and municipal regulation of the latter, that is to say, upon its own proper jurisdiction and polity, and upon its own express or tacit consent. So, if you are involved in a dispute in the state of California against a non-resident party in Arizona, and you file suit in the California courts because this Arizona party is selling stuff in California over the internet, and he doesn't deliver his goods, and you sue him in the California courts, if he has a business office in California, then you have something to collect on because he has property you can take. So you take him to court in the California courts because your rights were violated at that location in California, and he's a non-resident party, and you sue him civilly, and the order of the court becomes binding upon all property that foreign non-resident has in that state. And if there is no property, there's nothing to lien for the judge. And so the order becomes unenforceable. And that's why they say here that it cannot bind persons not resident therein. And that also includes physical property not resident therein. If there's no physical property, that this mail order person has in California, then that would be non-resident property of a non-resident person, because if their office is in Arizona, for instance. States of the Union are not territories of the United States, and consequently, the consent of the inhabitants, that is, domiciliaries of those constitutional states, is mandatory in connection with any federal enforcement actions. And here's the proof from the Corpus Legal Juris Secundum Legal Encyclopedia, Volume 86, under territories. Territories or territory, as including state or states. While the term territories of the United States may, under certain circumstances, include states of the Union, as used in the federal Constitution and in ordinary acts of Congress, territory does not include a foreign state. And that phrase foreign state is really important because they're referring to, in the context that they're using that here, is legislative, civil legislative jurisdiction and criminal legislative statutory jurisdiction. So, and that's a reflection of what we just read, where they talked about the laws of a jurisdiction cannot extend outside the physical boundaries of that jurisdiction. So anything outside those boundaries is what they call here a foreign state. As used in this title, the term territories generally refers to the political subdivisions created by Congress and not within the boundaries of any of the several states. So the several states, as used in the Constitution, or the several constitutional states, are not territories of the national government, and federal law does not extend into those constitutional states, and therefore federal law, as it says here, is foreign for the purposes of legislative jurisdiction. Now, some judges who want to confuse and cloud the issue will say, oh, well, it's not foreign. And then they won't define their context. They'll say, oh, yeah, but if you really get them on this, if you force them to define their terms, what they really mean is it's not foreign for the purposes of the constitutional context, but it is foreign for the purposes of legislative context or statutory context. And as we said before, the context is everything in the legal field, everything. You can be domestic for the purposes of the Constitution, but foreign for the purposes of all federal laws. Think about that. Consent or comity is manifested in the following forms. Constitutional grants of power by states to the federal government. The Constitution is a contract that grants extraterritorial jurisdiction. See Pardon versus Terminal Railroad Company, 377 U.S. 184. Another thing that constitutes consent or comity is private contract or private law. This includes contracts with the government, government employment contracts, corporate charters, which are contracts, and federal benefit programs such as Social Security, Medicare, and Medicaid, etc. But as we said, those federal benefit programs can only be offered to people who already work for the government as public officers. They cannot be used to create any new public offices in the government. And if they do, a crime is being committed. And if they can't create any public offices, then they cannot authorize the payment of benefits to people who were not lawfully serving in public offices at one time or another. Otherwise, the separation between public and private has been violated, and the government's taxing powers have been abused to perform wealth transfer, which is not authorized. The entire Internal Revenue Code, Subtitle A, is another example. See sections 9 through 9.6 of our document Requirement for Consent. Specific sources of federal extraterritorial jurisdiction in the case of income taxes. Being an agent or instrumentality of the federal government regardless of where situated pursuant to 26 U.S.C. 871B. All such instrumentalities are engaged in a trade or business which the IRC defines as a public office in 26 U.S.C. 7701A26. This includes federal employees, federal corporations, federal public officers, and federal benefit recipients. But as we said before, all of those instrumentalities must expressly be authorized in writing in a statute by Congress to be exercised where they're being exercised if it's outside the District of Columbia. And that's found in 4 U.S.C. Section 72. And if the government cannot produce evidence, legal evidence of the authority to exercise the office outside the District of Columbia, then there is no authority and there is no office and there is no office holder. And if there's no office holder, then there's no tax on the office holder. And all federal income taxes under subtitles A and C are taxes upon an office. The office itself is the taxpayer, and the officer filling the office is surety for the office by using government property such as a TIN or an SSN in connection with otherwise private activities. Federal payments not connected with a trade or business as defined in 26 U.S.C. 871A. This includes Social Security under 26 U.S.C. 871A3. Another example is the filing of an information return against a non-resident party outside the territorial jurisdiction of the federal government, such as IRS Forms W-2, 1042-S, 1098, 1099. That is proof of consent to the private law embodied in the IRC Subtitle A. If you don't ensure these forms are not filed against you and rebut those that are, then you are presumed to be a statutory resident alien taxpayer who consents to the entire IRC Subtitle A contract, franchise, or agreement and consents to become a public office or federal instrumentality. Oops. And this is proven in corrected erroneous information IRS Form W-2s, Form 04.006, and correcting erroneous IRS Form 1099, Form 04.005. For all the foregoing reasons, it is unwise and foolish to argue that the jurisdiction of the federal government is limited only to the federal zone or that the federal government has no extraterritorial jurisdiction. And, why is that? Because if you examine Federal Rule of Civil Procedure 17B, it says the capacity to sue or be sued shall be determined by the domicile of the party. And those exercising an office in the government, the effective domicile of the office is the District of Columbia, regardless of where the officer is physically located. However, as we said before, express authority must appear in statute to exercise that office outside the District of Columbia, and if there is none, there is no lawful office, and no officer, and no jurisdiction at all. And the government has the burden of proving that in every case where they seek to enforce federal statutory law extraterritorially within a constitutional state. Instead, you should do the following to protect the requirement for consent or comity on your part. Show that the law in question or the statute in question is private or contract law that only applies to those who explicitly or implicitly consent, and demonstrate that it is a private contract law by showing that there is no statute making you liable and that the law was never enacted into positive law. And we also might add that you have no domicile in that jurisdiction, and therefore under Federal Rule 17, those laws do not extend beyond the boundaries of that state. And you should also demand proof of informed consent on your part in order to enforce the private law against you. And that consent has to consist of consent to lawfully occupy, an elected or appointed office in the government. For further details on the requirement for consent and how to argue it in court, see Requirement for Consent, Form 05.003. And for further details on federal jurisdiction, please see our Memorandum of Law entitled Federal Jurisdiction, Form 05.018 on our Forms page. Residence. Black's Law Dictionary, 6th edition, page 1309, defines a resident as follows. Resident. Any person who occupies a dwelling within the state has a present intent to remain within the state for a period of time and manifest the genuineness of that intent by establishing an ongoing physical presence within the state, together with indicia that his presence within the state is something other than merely transitory in nature. The word resident, when used as a noun, means a dweller, habitant, or occupant, one who resides or dwells in a place for a period of time or less duration. It signifies one having a residence or one who resides or abides. The word resident has many meanings in law, largely determined by their statutory context in which it is used. Now, we want to emphasize here that that resident is often used as a civil status in civil statutory laws. And any attempt to enforce any obligation that attaches to that status of resident is an attempt to take property from you. So if they want to just presume that you're a resident without having to prove it, if they want to, then they're violating due process of law, and they're exercising eminent domain over your private property. The only way you can be a resident under most statutes is to be an alien. You must first be an alien before you can be a resident. And by alien, we mean a foreign national, somebody who is a national of another country, not another constitutional state. So in most cases, you cannot even be a resident, even if you want to be, if you're born in the country. So, and that's very important. And a person born in a foreign country is considered to be privileged while they're here until they're naturalized. And because they're privileged, then and only then can they be made into public officers subject to the legislation of Congress. Otherwise, they're foreign and alien and not subject to the laws. So if you're a national and you were born in this country, if you're a USA national, or you're born in the country and you're a constitutional citizen, then you cannot be a resident under most statutory laws, and because you're not an alien, you're not a constitutional alien. And by the way, we might add that residents within the Internal Revenue Code are public offices in the government. And the term resident, as used in the Internal Revenue Code and as described in the earlier regulations, not necessarily means somebody who is domiciled in the country or somebody who is not a naturalized citizen. Instead, it simply means that you're engaging in a trade or business. That's what it really means. A resident is a public officer because you cannot be a resident in the Internal Revenue Code without being engaged in a public office. And why do they do that? Because once again, they only have jurisdiction over public conduct, and a private person is not public and therefore is not subject to the jurisdiction. So they had to define resident as a public officer that they had jurisdiction over, and they have to presume that you're a resident to even reach you. And in most cases, that presumption is false. And that presumption represents a theft of your property. Definition of state from the above context. 26 U.S.C. Section 7701A10. The term state shall be construed to include the District of Columbia where such construction is necessary to carry out the provisions of this title. And because that definition does not include a constitutional state, then they can't add to it by any means. As we said earlier, the rules of statutory construction forbid adding anything to a definition or anything or class of things to a definition to expand its meaning. And we also said that the purpose of all law is to limit government authority, not expand it. And if they don't include everything that is within the meaning, then they're violating the reasonable notice requirements of the Constitution by failing to give you notice of what's expected. And they're violating due process of law because that presumption that something else is included that's not there leads to a theft of property. So a due process is intended to prevent those sort of government thefts. Also, in Title 8, Aliens and Nationality, Section 1101A36, the term state is described to include the District of Columbia, Puerto Rico, Guam, and the Virgin Islands of the United States. That's it. So if you're not in a federal territory, then you're not in a state for the purposes of Title 8 of the U.S. Code either. And why is that? Once again, federal law is limited to the federal zone or federal territory. That is the only place they have exclusive or general jurisdiction. They don't even have jurisdiction to call you a citizen if you're in a state, because state law is the only thing that can do that. So if they can't call you a citizen, then you can't even be a U.S. citizen under their laws. If you're not a U.S. citizen, then you're a non-resident. If you're non-resident, then you're not subject to their laws. 4 U.S.C. Section 110D, definitions, defines state as the term state includes any territory or possession of the United States. So all we're doing here is showing you that the state that they're talking about up there means those states in the federal context. And those states have absolutely nothing to do with a constitutional state. And why is that? Because of the separation of powers. There's a separation of legislative and enforcement powers between the state governments and the national government. And there can never be an overlap. And every time there is an overlap, we have a conflict of interest between the states and the national government. We force everybody to be a public officer of both the state and the national government, which is forbidden in most state constitutions. And there are lots of other problems that result if you add the states to any of those definitions, the constitutional states. So what does residence mean? You're making a big mistake to claim you are a resident of anything. Inhabitant or domicile are better words because they're less ambiguous. And residence from the Internal Revenue Code is defined as follows. Residence defined. Now notice the context here. Non-resident alien individuals. Okay, so they're trying to define who is a resident and who isn't. And everybody who's not a resident is has no residence. An alien actually present in the United States who is not a mere transient or sojourner is a resident of the United States. That's what we said earlier. All residents are aliens. Okay, for the purposes of the income tax. Whether he is a transient is determined by the intentions with regard to the length and nature of his stay. A mere floating intention, indefinite as to time, to return to another country is not sufficient to constitute him a transient. If he lives in the United States, and that United States, by the way, is the federal zone. It's not states of the Union. And has no definite intention as to his stay, he is a resident. One who comes to the United States for a definite purpose, which is in its nature, may be promptly accomplished, is a transient. But if his purpose is of such a nature that an extended stay may be necessary for its accomplishment, and to that end the alien makes his home temporarily in the United States, he becomes a resident, though it may be his intention at all times to return to his domicile abroad when the purpose for which he came has been consummated or abandoned. An alien whose stay in the United States is limited to a definite period by the immigration laws is not present a resident of the United States within the meaning of this section in the absence of exceptional circumstances. So, and this definition is very important because, first of all, notice that there is no use of the term citizen anywhere in the definition. So if you are a citizen of the United States, even if you're a statutory citizen, you cannot have a residence, period. And if you don't have a residence, then you can't be subject to the Internal Revenue Code. And that is completely consistent with the definition of individual and alien individual and non-resident alien individual found in 26 CFR 1.1421-1C3. The only taxpayers, all taxpayers, are aliens, all of them. And we might add that even though citizens are mentioned in 26 U.S.C. 911 as being subject to the taxes, they have to be abroad in a foreign country. They have to be domiciled in the federal zone at the time. And they must be aliens in relation to the country that they're in, the foreign country. And they must be availing themselves of the benefits of a treaty with that foreign country. And in relation to that treaty, they are aliens. In relation to the country they're in, they are aliens. So even they interface to the code through a treaty as aliens. So we have some critical and important facts about residence within the meaning of the Internal Revenue Code. Only statutory aliens can have a residence under the Internal Revenue Code. The term is not defined in the context of any other person in the IRC, including citizens. And the only place that statutory aliens can have a residence under the IRC is the federal zone or admiralty or maritime jurisdiction, and B, taxpayers, statutory taxpayers. And when a statutory alien has a civil domicile in the federal zone, then he or she becomes a resident under the Internal Revenue Code. So what is a resident? All statutory residents are aliens under the Internal Revenue Code. And here's the definition, 26 U.S.C. 7701 B1A, resident alien. Definition of resident alien and non-resident alien. In general, for the purposes of this title, resident alien is an alien individual shall be treated as a resident of the United States with respect to any calendar year if and only if such individual meets the requirements of clauses I, II, and III, lawfully admitted for permanent residence, substantial presence test, and first-year election. So if you don't satisfy, and by the way, there is no definition of resident citizen, only resident alien. So the only way you can be a resident is to be an alien under the Internal Revenue Code. And by alien, we don't mean a constitutional alien, meaning a foreign national, somebody born in a foreign country. We mean a statutory alien. And a statutory alien is someone who was born outside of the federal zone. That's what it is. So if you're born in a state, then you're a statutory alien for the purposes of the Internal Revenue Code. And you would become a resident alien if you changed your domicile to a place in the federal zone, even if you were a constitutional citizen. So as we said before, the context is everything, and you need to distinguish between whether you're talking about a statutory context or a constitutional context. And that a failure to do that is the source of all of the confusion in the freedom community over the meaning of what a U.S. citizen is. And there's lots of unnecessary and needless confusion. The terms resident, resident alien, and alien are all synonymous in the Internal Revenue Code. The definition of resident from the Law of Nations, which was used by the Founding Fathers to write the Constitution. So here they're talking about the constitutional and not the statutory context. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country. Being bound to the society by reason of their dwelling in it, they must defend it, although they do not enjoy all the rights of citizens. They have only certain privileges, meaning franchises, which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all of its advantages. Their children succeed to their status for the right of perpetual residence given them by the state passes to their children. And that's the Law of Nations, Emir de Vattel, Volume 3, 1916, page 87. Another term that is used to describe where a person is and what their legal status is under the civil statutory laws or the civil laws is domicile. This is a very important term. And here is the definition. A person's legal home. That place where a man has his true, fixed, and permanent home and principal establishment, and to which, whenever he is absent, he has the intention of returning. Smith versus Smith. Generally, physical presence within a state and the intention to make it one's home are the requisites of establishing a domicile therein. And by intention, they also mean consent. You cannot have an intention without consenting to have an intention. So they're really talking about an act of consenting to the local laws of a jurisdiction, the municipal laws of a jurisdiction. And because domicile is your source of civil protection. And when you choose a place to have a domicile, you're nominating a protector to protect you civilly. And it says here, the permanent residence of a person or the place to which he intends to return, even though he may actually reside elsewhere. A person may have more than one residence, but only one domicile. The legal domicile of a person is important, since it, rather than the actual residence, often controls the jurisdiction of the taxing authorities and determines where a person may exercise the privilege of voting and other legal rights and privileges. The established, fixed, permanent, or ordinary dwelling place or place of residence of a person is distinguished from his temporary and transient, though actual, place of residence. It is his legal residence as distinguished from his temporary place of abode, or his home as distinguished from a place to which business or pleasure may temporarily call him. Citizenship, habitancy, and residence are severally words which in particular cases may mean precisely the same as domicile, while in other uses may have different meanings. Residence signifies living in a particular locality, while domicile means living in that locality with the intent to make it a fixed and permanent home. For the purposes of federal diversity jurisdiction, citizenship and domicile are synonymous. So, the important thing to get out of this is that you cannot have a domicile without your consent, and it involves a choice. And that choice manifests an intention. Okay, and that intention has to be expressed somewhere. It has to be expressed on a government form. It has to be expressed in a communication with the government. If you never express that intention, then it doesn't exist. There's no evidence to suggest that it exists. And if it doesn't exist, then you don't have a domicile. And if you don't have a domicile, you're not subject to the civil statutory laws of that jurisdiction at all. And so you get to choose. Essentially, think of government as a protector. And think of it, now in olden times, before governments and tribes existed and people lived alone, then they defended themselves. And the weapon they used to defend themselves was their protection. And now what we've done is we have institutionalized the making of that weapon, and we've called it a government. And what they're saying here is you get to choose what weapon you want to defend yourself with. And that weapon is a combination of a bureaucracy and laws that implement the protection and courts that enforce the protection. So that is the weapon that you choose to civilly defend yourself within that locality. Okay? That doesn't mean you have to choose a civil statutory protector. You can choose to be entirely exempt from the civil statutory laws of a jurisdiction and never become a domiciliary or a resident. And at that point, the only thing that governs your conduct is the courts and the common law. And the only thing that governs the government at that point is the Constitution and not the statutory law. So at that point, the only thing you can invoke to protect yourself from the government is the Constitution. And the Constitution itself is law. It's law for the government and no one else. It's law for the government, and it protects you from abuses by the government and only the government. It doesn't protect you from anyone else except possibly the 13th Amendment, which protects everybody from involuntary servitude by anybody. But every other part of the Constitution governs only the relationship between the government and the citizens or the people within that jurisdiction. And that protection is only available to people who are standing on land that is within a constitutional state of the Union. If you're not on that kind of land, then you're not protected by the Constitution. And an example of people who would not be on that land would be people who are abroad in a foreign country, such as that described in 26 U.S.C. 911, or people who are on federal territory within the exterior limits of our country. So either way, you would not be subject to the protections of the Constitution. So if you were in Puerto Rico, you would not be protected by the Bill of Rights or the Constitution at that point, unless Congress, by legislation, irrevocably extended the protections of the Constitution and the Bill of Rights to those people. But if they never did that, then you would not be protected by the Constitution at that point. By default, one can only reside in the federal zone based on the definition of state earlier. And this applies to most income tax forms you will ever fill out. And that includes federal income tax forms and state income tax forms. And why do we say that? Because it's a prerequisite that the state government cannot collect a state liability unless you also have a federal liability. Income has the same definition within the Internal Revenue Code at the national level and the state revenue codes at the local level. It's the same definition, and it means a public office in the national government. And the reason the states can reach those federal officers through the state income tax code is because of a thing called the Public Salary Tax Act, which was enacted by Congress in 1939, whereby the states authorized, the federal government authorized the states, the statutory states, to collect income taxes of public officers in the national government within the boundaries of federal territories and not states of the Union. And so what's happening is these states of the Union are pretending to be federal states unlawfully, and they're instituting the Public Salary Tax Act as a way to reach the people who are federal taxpayers. And there's a whole section of statutes whereby ACTA agreements are forged between the national government and the federal territories to enforce the federal tax laws within the boundaries of a statutory state, which is a federal territory. But those agreements cannot be entered into by constitutional states. And if they are, there's a violation of the separation of powers doctrine. And at that point, everything is a usurpation beyond that point. So that is why the state income taxes are a fraud from the get-go, because they break down the separation between the federal and the state government. And they assume that you're a public officer in the state government and a federal government at the very same time. Because just like the federal government, the states can only regulate their own public officers. And so you have to be a state public officer and a federal public officer to be subject to the state income tax. And it's unconstitutional in just about every state, or it's a crime, to simultaneously serve in a federal public office and a state public office at the same time. So it's a fraud from the get-go for states of the Union to act like federal territories or to enforce the Internal Revenue Code within their boundaries. And that is precisely why the geographical definitions found in the Internal Revenue Code that we showed you earlier cannot include, ever, the states of the Union. Even if Congress consents to it, they can't include that because it would violate the separation of powers. Domicile, games with words. Facts about domicile. It is a person's legal home. It is the source of the civil statutory law and the permanent protection that you claim allegiance to. And it is based on the coincidence of intent to live somewhere and physical presence in that place, either now or at some time in the past. And you can have a domicile in a place you don't currently live in, as long as you were there at some time in the past. And only we can define and express our intent, and therefore only we can choose a domicile. A judge cannot choose it for you, because domicile is a First Amendment choice of political affiliation, and they cannot interfere with your right to affiliate or to not affiliate. And if they do, they're committing a tort. And the government cannot lawfully coerce us to declare places within its jurisdiction as our domicile, and hence they cannot coerce us to be subject to their civil statutory laws. And so in that sense, you could say that they're actually voluntary. And you could say that they are a compact instead of, quote, law or classical law, as we showed you earlier from that book on the common law. We showed that anything that is consensual or requires your consent in some form is not, quote, law, unquote, but a compact. And so in that sense, the civil statutory code is technically not law in a classical sense. It is a compact. To be more precise, it is what the Supreme Court calls a social compact. And all compacts are contracts, and all contracts activate only upon your consent. So you don't have to participate in their system. And if you don't join their club, then the only rules they can enforce are the common law. That's it. And that doesn't make you into an anarchist. It doesn't make you into an anti-government person. It simply makes you into somebody who reserves their rights and sacrifices or none of them, and who refuses to surrender their equality in relation to the government. And there's nothing wrong with being equal. They may not like people who are equal. They may not be able to enforce against people who are equal, their civil statutory compact or whatever. But they have to give you that authority because they have to respect your equality and sovereignty, because every sovereignty, including people as individuals, has the right to withhold their consent and their allegiance and to select their protector. And if the government doesn't protect you, then you don't have to consent to their laws and you don't have to choose a domicile. If they only protect themselves and not you, then they're technically not a government. And if they will only protect you if you pay them bribe money, then all they're running really is just a protection racket, and they're no longer protectors. They're just terrorists. They cannot call the compact voluntary and then refuse to recognize or enforce your right to not volunteer. It's an oxymoron. It's what George Orwell would call doublethink. And doublethink is just holding two contradictory ideas in your head at the same time and believing that they're both true. They can't be. They simply can't be. The truth cannot conflict with itself. And what we just said is either true or it isn't true. And the only way it could be true is if it didn't conflict with itself and it didn't conflict with a written law. And it's your job to verify whether it conflicts with itself and the written law. Caveat emptor. That's what sovereignty is about. You're in charge of your life. For Christians, the Lord and his sacred laws are the source of all of our permanent protection, and we may not rely on man's laws, and I would add statutory civil laws here, as a substitute or replacement for his divine protection. Isaiah 33:22 says on this subject, "For the Lord is our judge, the Lord is our lawgiver, the Lord is our king. He and only he and his law will save and protect us." The legal definition of permanent to prove our point. Here's the definition from Title 8 of the U.S. Code, because remember, the prerequisite for domicile was permanent. It said permanent residence, or permanent a consent or intent to dwell permanently in a place. Okay, so that word permanent is key, and here's their definition to prove just how much of a fraud they're dealing with to reach you through their civil statutory compact. The term permanent means a relationship of continuing or lasting nature as distinguished from temporary, but a relationship may be permanent even though it is one that may be dissolved eventually at the instance of either the United States or of the individual in accordance with law. So what are they saying here? Think carefully. What they're saying is, as long as both parties consent, as long as you consent to be protected, and as long as they offer the protection and enforce it, in other words, do what they're paid to do, which is protect you, then the relationship is permanent. Okay? In other words, the relationship is enforceable. That's all they really mean by permanent here. Okay? If you withdraw your consent, it's no longer permanent. Okay? So permanent is just a subterfuge. It's a disguise. It's a smokescreen to disguise the consensual nature of the relationship between the government as a civil protector and you as a customer of that protection. And just like any other business, they cannot force you to be a customer. And they happen to have a unique name for that customer. It's called a citizen or a resident. But if you don't want to be either, you don't have to be. And the only way they can force any of those statuses on you without your consent is if you're a foreign national from another country and you're temporarily here. And only in that condition can they force you into privileged status without your consent. But if you were born here, they can't do squat to you. They have to leave you alone, because that's the purpose of justice itself, is the right to be left alone, to enforce your right to be left alone. And we said that governments only have two purposes: to govern those who consent and to leave everybody else alone. Period. And if they won't leave you alone, then they have no right to govern anybody, because they're hypocrites. You don't hire somebody to protect you who turns into a terrorist and refuses to leave you alone, do you? That's crazy. It's insane. It's doublethink, as Orwell would call it. The only thing described as permanent in the Bible is God in heaven. The earth will be destroyed. See Isaiah 66:22. Therefore, we cannot literally make a temporary earth a permanent place of abode or a domicile without committing idolatry. Now, can we? And by the way, the notion of domicile implies a permanent connection to a physical territory, and a sovereignty or a jurisdiction or a government has no authority to protect territory that is not its own. And if you read the Bible carefully, you'll find out that the heaven and the earth are created by and therefore the property of God and God alone. If God owns the heaven and the earth and he created all of them, and he's the only one who can dictate their use, then technically, even if you have a domicile on land that the government claims belongs to them, that government isn't permanent either. God is the only permanent owner of anything. And so, in a sense, you can have land, domicile on land, and as long as it's owned by your sovereign, who is God, even if Caesar claims ownership over it, then technically you don't have a domicile within Caesar's jurisdiction. That's a pretty interesting point to think about. And another point to think about is that effectively what Caesar is doing is he's renting out God's property. That's what property taxes are. He's renting out God's property. And in a sense, he's hijacking God's sovereignty in the process. He's not allowed to do that. That's why property taxes are wrong, biblically wrong. That's why they violate the 10 commandments, because you're stealing from your neighbor when you do it. And in this case, you're stealing from God, because God's the owner. And we only own it. We only think we own it, but he's the real owner. The earth is presently controlled but not owned by Satan and not God. And here's the scripture on that, John 14:30-31. I, that is Jesus, will no longer walk much with you, for the ruler of this world, that is Satan, is coming, and he has nothing in me. But that the world may know that I love the Father, and as the Father gave me commandments, so I do. Arise, let us go from here. So what he's recognizing here is that Satan may control the world temporarily because he controls the rulers of the world, and therefore he controls the world indirectly. But he's only the temporary ruler, and he eventually will be killed and destroyed and committed to eventual permanent hell. Okay, but in the meantime, while he has any influence here on earth, because of our free choice, we allow him through our sin and our covetousness to be the ruler, and only through that mechanism. And that's why we cannot recognize any civil ruler who is above us. And that is why every ruler has to work for us. And that is why we have a duty to obey God and his commandments, so that those rulers must obey us and indirectly must obey God's commandments. Because they're not rulers unless they enforce the equal relationship between you and them. If they try to make themselves better than you, or bigger, higher than you, or impute supernatural powers to themselves, then all they're trying to do is substitute God, fire God as a protector, and make themselves into a lord of their own little micro kingdom. And we can't permit that because it's idolatry and it violates the first 4 commandments. Moving on, claiming our domicile to be any place but God's kingdom and heaven as a Christian amounts to idolatry. And we might add that we were created in heaven before we existed in the world. And it is a principle of law that the place that a person is born is the place of their domicile of origin, is what they call it. So your domicile of origin is the kingdom of heaven, because you existed spiritually before you came here physically. And so your domicile of origin is the kingdom of heaven. And that is the place you will return when you die. And the laws of domiciles state that in the absence of a choice, a recent choice of domicile, then your domicile reverts back to your domicile of origin, which means if you withhold your consent to become a domiciliary of any specific place on earth, then your domicile of origin kicks in and you become a citizen of heaven automatically. And if you're a citizen of heaven, the laws of heaven, the civil laws of heaven under the Bible, and the Bible, by the way, is also a protection franchise and a compact, because you have to consent to that too, to be subject to it and to be protected by it. So as long as you nominate God as your protector by believing in him and trusting him and following his laws, then you joined his club instead of Caesar's club. And at that point, you're a non-resident and with respect to Caesar, and you're a resident with respect to God. And those principles are very clearly explained in the Bible. That it says we are citizens of the kingdom of heaven in Philippians. And that's the only thing we can be. And as long as we're always citizens of the kingdom of heaven, we can never be Caesar's citizens or Caesar's residents or anything that Caesar has any power over at all. And hence Caesar has no power. And obviously that situation would make any ruler pissed off, wouldn't it? Because all he wants to do is steal from people and enslave them and control them. So he can pay bribes to his cronies. And that is why, the Bible says we cannot nominate a king and that it's a sin to have a king. And by selecting a domicile, you are nominating a king if you're a Christian, because your allegiance is shifting from God to Caesar when you select a domicile, a civil domicile, and you're not allowed to do that. That's not to say that you can't be protected. It just means that the common law is the only thing that can protect you at that point. And if you do anything else, if you select a domicile, you're committing idolatry. And those who do not select a domicile in Caesar's jurisdiction and keep their domicile of origin in the kingdom of heaven are called, under Caesar's law, they're called transient foreigners, non-residents, and not, quote, residents, unquote. All residents are aliens under the Internal Revenue Code, and they are nationals but not citizens. A person who is a national but not a citizen under the federal law is treated as a non-resident non-person under the Internal Revenue Code. In other words, you're not anything. You don't have an identity under their codes because you're not subject to their codes. And the reason is because you have to consent to be subject. You have to consent to a domicile before those codes even kick in, because all their enforcement authority has to be associated with domicile, because that's how they protect you and that's how they protect them. So if you never give them jurisdiction and you never waive your sovereign immunity, then they have to treat you as an equal, and you can't govern people who are equal, now can you? So in effect, you're firing Caesar when you refuse to select a domicile. And we like to describe it as creating a new option on every federal election. We kind of wish that every multiple choice question on a federal election form or a state election form ought to have an additional option that says none of the above. Okay? In other words, you don't have to vote for anybody, and you certainly don't have to pay tribute to anybody. And if you check the last box, which is none of the above, by not selecting a domicile, then you fire all the bastards, and they can go to hell. But anyway, so here's some biblical proof that God's law requires Christians to not select a domicile and to not have a king above them by selecting a domicile. Esther 3:8-9. Then Haman said to King Ahasuerus, there is a certain people, that is the Jews, which are now called Christians, scattered and dispersed among the people in all the provinces of your kingdom. And today provinces would be states. Their laws are different from other people's, and they do not keep the king's laws. Therefore it is not fitting for the king to let them remain. If it pleases the king, let a decree be written that they be destroyed, and I will pay 10,000 talents of silver into the hands of those who do the work to bring it into the king's treasuries. So what's going on here is that the Israelites, the early Israelites, refused to be governed by the king's laws. And and more specifically, they were subject to the criminal laws of the king, but they were not subject to the civil laws because they didn't select a domicile. And so they were not subject to the king's civil laws, and therefore they didn't owe the king any taxes because taxes are a civil liability. And this guy was pissed because they were not paying tribute to the king, and he wanted to put a reward on the street for them to be killed because they weren't paying him bribe money or tribute. And the other important thing here is it says their laws are different from other people's laws. Well, how could they be different? If they're physically on the territory the king owns, then how could they have different laws? And the answer is because they didn't have a domicile. And because they didn't have a domicile, for the purposes of civil legislative jurisdiction, they were considered, quote, foreign, unquote, and sovereign and equal to the king. And no king wants people that he can't govern who are equal, now does he? And so it pissed off the king. And that's why the king wanted to put a bounty on the heads of these people, these anarchists, so to speak. We call them religious anarchists because God's law mandates the anarchism. And that anarchism is selective. It's not anarchism towards God's laws. It's anarchism toward man's laws, in this case, the civil laws. So they were, in a sense, religious anarchists because, and there's three kinds of anarchists you can be. You can be a religious anarchist who reject man's laws but accept God's laws. There's the atheistic anarchists that reject both God and man's laws. And then there's the statist anarchists that reject the religious laws but not man's laws. So take your pick. You know, those are the three kinds of anarchists you can be. In this particular case, the Jews were the religious anarchists. And moving on, 1 Corinthians 5:9-12, for what have I to do with the judging those also who are outside? Do you not judge those who are inside? Okay, and what Paul is saying here is that he cannot judge people who are not members of his club, his religious group. Okay, in other words, if somebody never consented to become a Christian and pledged allegiance to God's laws and obedience to God's laws by becoming a Christian and demonstrating faith, then all of God's laws would be foreign and they would be transient foreigners in relation to those laws, wouldn't they? So they'd be outside of God's laws, outside the protections of God's laws. And the same principle applies to man's laws. If you never pick a domicile, then you're outside of those laws. Okay, and perhaps it's a misnomer to even call them laws at that point, because if you can withdraw your consent and they can't be enforced, then they're not technically law, because real law doesn't require your consent, does it? So technically they're just codes. And more particularly, that's why they call them codes instead of laws. That's why the Internal Revenue Code is called the code instead of the law, because it only acquires the force of law with your consent. And that consent is manifested by choosing a domicile within the jurisdiction of the national government and thereby nominating a protector and consenting to be protected and consenting to pay for the protection in the process. The world cannot judge us unless we join their club by becoming a citizen or a resident, which we do by choosing a domicile on the king's land. And we already said, the Bible says the heaven and the earth belongs to the Lord. So does the king own any land? And the answer is no. And what did Jesus say on this subject when he was asked whether people should pay taxes? He said, render to Caesar that which is Caesar's. Well, if the Bible says that the heaven and the earth belongs to the Lord, then what's left for Caesar to own? Hello? And we would argue that the answer to that question is closer to nothing than something. In Esther 3, 8 through 9 above, the Jews were criticized by the government because essentially they did not claim the king's land for their domicile and thereby participate in his corrupt system of tribute and taxation. The reason was because they did not want to commit idolatry. And so we challenge you, please prove us wrong, because we don't think you can. But the ability to do this and an understanding how to do this, how to disassociate civilly from a specific government by refusing to select a domicile in that government, that act of disassociation is an exercise of your personal sovereignty. And it cannot be interfered with because you own yourself. And the essence of ownership is the right to exclude all others from using or benefiting from the use of your property. And if you own yourself, you have a right in all your property, then you have a right to deny all others from using or benefiting from the use of that property. And the most important way to do that denial of their use or benefit is to withdraw yourself from the jurisdiction of their corrupt laws so they can't legislatively reach that property through their civil statutory franchise codes. All income taxes are based on domicile. One's domicile establishes what's called the situs, quote unquote, or place where paying tribute may be enforced under the authority of law. Definitions of situs from the Law Dictionary, Black's Law Dictionary, 6th edition, page 1387. Situs, situation, location or place of crime or business. Site, position, the place where a thing is considered, for example, with reference to jurisdiction over it or the right or power to tax it. It imports fixedness of location. Situs of property for tax purposes is determined by whether the taxing state has sufficient contact with the personal property sought to be taxed to justify in fairness the particular tax. Generally, personal property has its taxable situs in that state where owner of it is domiciled. So technically, if you don't have a domicile in the jurisdiction of a specific state, then your property can never have a situs in that state and therefore can never be the subject of tax. That's important. Taxation is the formal means of paying tribute for the protection that government affords. Why tribute must be voluntary and cannot be enforced. All government in America is based on consent of the governed according to the Declaration of Independence. If we don't consent to accept the protection afforded, that is the civil statutory protection, afforded by government, then we can't be compelled to pay for it. Another way of saying this is that you can only govern people who want to be governed, civilly that is. We're not suggesting that people without a domicile wouldn't be subject to some of the laws of a jurisdiction. Certainly they would be subject to the criminal laws because the criminal laws attach to territory and they do not require your consent. If you hold up a store or if you kill somebody, then you've committed a crime and you ought to be prosecuted and jailed for that crime regardless of whether you have a domicile or not. So these domicile concepts only apply to civil statutory laws and nothing else. They don't apply to the common law and they don't apply to the criminal laws. Keep that in mind. A lot of people confuse that concept. Our choice of domicile establishes whether we consent to the government that rules the place where we live. And we don't have to consent. And if we never consent, then we don't have to pay for that which we never consented to, now do we? It's just like a business, you know. If you don't want to buy their goodies or their product, then you don't have to, and you don't have to pay for it. And you certainly don't have to pay for something they never delivered. And that's the nature of being, you know, the sovereign people, is that you're the customer, and the customer is always right. And the only product that these so-called customers, quote unquote, buy called citizens or residents is protection. And the taxes they pay essentially are protection money. Okay? But the trouble with that analysis is that all contracts to be enforceable require mutual consent and mutual consideration. And that consideration has to be enforceable in court as an obligation on both parties. And the trouble is that government claims sovereign immunity for everything, and so they don't have an obligation to deliver protection, and yet they throw you in jail if you don't pay for the protection. And that's a fraud, and it certainly doesn't produce an enforceable contract. If they can throw you in jail for refusing to pay for the protection, then they ought to be in jail if they refuse to deliver it, right? Because if they don't deliver it, people get killed. If you call the police up and they don't show up, and then you ought to be able to sue them for not showing up, or for doing their job wrong, or for threatening your life while they're doing it. Because they're not protecting you at all at that point, are they? They're just injuring you. And anybody who does an injury, whether they're the government or not, ought to be responsible for it. Why? Because we're all equal, right? Hello? We cannot and should not be compelled to pay for protection that we don't want or don't need. To admit otherwise is to sanction a government that is a protection racket, that is involved in organized crime and racketeering, and has an illegal monopoly on protection in violation of the Sherman Antitrust Act, 15 U.S.C. Section 2. And by the way, we want to emphasize that the only difference between a lawful protector and a protection racket is consent. A protection racket does not ask for your consent. They just want you to pay them money. And in return for the money, they will leave you alone. And that's about all the kind of protection you buy, is protection from them. Okay? Whereas a lawful protector protects you not only from itself, but also from everyone else. So the way to distinguish between whether or not you're dealing with a lawful government or a de facto protection racket is who they're protecting you from. Okay? If they won't protect you from themselves, unless you pay them bribe money, and they don't care about whether they protect you from anyone else, or they're not accountable for protecting you from anyone else, then they're just a protection racket, and they're not a government, and you shouldn't subsidize them. Because that would be an abusive relationship. It would be an unequal relationship. Because you're accountable to pay for the protection, but they're not accountable for anything. And that does not form the basis for a lawful contract or compact. It's just terrorist activity is all it is. And it would fall under the RICO statutes at the federal level at that point. A government that forces you to pay for protection you don't want or don't need is described in Revelations 19:19 in the Bible as, quote, the beast, unquote. And here it is. And I saw the beast, the kings, that is political rulers of the earth, and their armies, that is not of non-believers under a totalitarian democratic form of government, gathered together to make war against him, that is God, who sat on the horse, and against his army. So the real beast talked about in the book of Revelations by the Apostle John, written while he was on the island of Patmos, that beast is governments and civil rulers. And that is why we're not allowed to contract with those governments or civil rulers, and we're not allowed to select them as protectors under the civil statutory laws. Because the only thing they're going to use that authority for is to steal and destroy, because that's what Satan does. That's the only thing he does. And that's what all corrupt rulers will do as well. Because they'll always look out for number one, and they'll refuse to look out for number two, and they're number one, always. And they'll never protect you from anybody else. And if you're smart, you'll never even go into one of their courtrooms because everybody wants a bribe of one kind or another, whether it's a penalty or a tax or a fee or something like that. And the Bible says you cannot contract with any government, because it'll be a snare to you. Why? Tribute must be voluntary and cannot be enforced. A government that does not respect the requirement for consent in all interactions with the public is a terrorist government. And this is right out of the beast's mouth, the government's mouth, the political ruler's mouth, in Title 28, Section 0.85, Organization of the Department of Justice. The exercise lead agency responsibility in investigating all crimes for which it is has primary or concurrent jurisdiction and which involve terrorist activities or acts in preparation of terrorist activities within the statutory jurisdiction of the United States, which, by the way, we said was the federal zone. Within the United States, this would include the collection, coordination, analysis, management, and dissemination of intelligence and criminal information as appropriate. If another federal agency identifies an individual who is engaged in terrorist activities or in acts in preparation of terrorist activities, that agency is requested to promptly notify the FBI. And here's their definition of terrorism, right out of the beast's mouth, the true terrorist's mouth. Terrorism includes the unlawful use of force and violence against persons or property to intimidate or coerce a government, the civilian population, or any segment thereof in furtherance of political or social objectives. Okay? Now, the key word here is property and political. Okay? The Internal Revenue Code, as we said, and all franchises for that matter, are law for government and public officers in the government. Okay? And those officers are political officers. So it is political law that only applies to officers within the government. And it doesn't apply to private humans because they don't have jurisdiction over private humans, only public officers. And if they can reach you, and if there's a status that they associate you with, then that status has to be public and it has to be an office in the government because they cannot regulate private conduct. So what they're doing is terrorism if they try to enforce a franchise against a non-participant. If they enforce the vehicle code, the civil provisions of the vehicle code against a non-resident and somebody who is not a, quote, driver, unquote, under any vehicle code, then in effect they're engaging in terrorism because they're taking property from you at that point. Your time, your labor, your car is private property. Okay, they're taking property from you and they're using violence because when they take it, they're arresting you, they're impounding the vehicle, and the theft of that property directly interferes with your right to support yourself, and therefore it directly affects your life, because if you can't eat, then you die. Okay, so, and that's what terrorist activity does, is it threatens your life. So they're engaging in, they're trying to, as they describe here, coerce somebody by stealing their property. And they'll do it, for instance, by trying to arrest you for driving without a license and refusing to recognize that licenses are only available to public offices in the government. Or they will refuse to discuss how they can force you into the role of a driver or into the role of a public office called a driver. That's eminent domain. If you didn't consent to it, they can't do it. Okay? I don't question whether they can regulate the use of the public roadways for hire, but if you're not using those roadways for hire, then you're not hurting anybody, and they can't regulate it, and they can't control it, and they certainly can't reach you as a human being to do it. And the criminal laws are quite sufficient to regulate the use of the public roadways for the private humans. You know, all they have to do is make it a crime to do whatever they don't want you to do. And at that point, they are able to regulate the roadways without regulating your civil conduct. They don't need to do it. And the only reason they do it is because they want civil jurisdiction so they can tax and extract unlawful revenues from the activity that they don't need and shouldn't have. By sending such a terrorist government our money, we are fornicating with the beast, as described in Revelation. Black's Law Dictionary defines commerce as intercourse. Here it is, Black's Law Dictionary, 6th edition, page 269. Commerce, intercourse, by way of trade and traffic between different peoples or states and the citizens or inhabitants thereof, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities, that is, governments and agencies by which it is promoted, and the means and appliances by which it is carried on. Now, if we apply this definition, this legal definition of commerce, which, by the way, is the only thing the government can regulate between states, the federal government, is commerce. In effect, they're regulating fornication between the states and fornication between the national government and the private humans in the states. Okay, the book of Revelations talks about Babylon the great harlot, And she's a harlot because she's accepting money and pleasure in exchange for her rights and her sovereignty. Okay? She's in effect having intercourse with the government or a civil ruler. Because the beast, it describes her as fornicating with the beast, and the beast, we just said, is the government. So the metaphor of the book of Revelations is that the harlot is people, and people, nations, and tongues, more precisely. And the beast that she's fornicating with is the government. And the fornication is described here as commerce. So if you engage in commerce with any government, if you contract with any government, you are among the group in the Bible, book of Revelations, that is defined as the harlot. And she is described as Mystery Babylon. And it's Mystery Babylon for her. It's mysterious because she hasn't studied the law and she doesn't even know she's contracting with the government. She's just accepting money for sex, or in this case, she's a harlot. That's why they call her a harlot. You know, the money is the money that she pays them, or they pay her, the commerce that goes between them. And the unlawful activity, or the fornication, is produced. And the children that are the product of that fornication are statutory persons who are public offices. So every time you contract with the government, you got to be an agent or officer of the government. And it is only through that mechanism that you can be within the civil reach of the government as far as regulating activities. So, and that's why the first 4 commandments of the 10 commandments forbid you to act as a servant, agent, officer, or public officer of any government. Because you're serving, if that government has unequal authority or superior rights to you. Okay? Because at that point, it's idolatry. And that's the worst sin in the Bible. And here's what the Bible says about the domicile scam that we've been talking about. The Apostle Paul in Colossians 2, 8 through 10 says, "Beware lest anyone cheat you through philosophy and empty deceit, according to the tradition of men," and we put in brackets, "including through man's deceptive laws written by scumbag lawyers," close brackets. And those deceptive laws are primarily implemented with words of art intended to deliberately deceive people. Moving on. "According to the basic principles of the world, and not according to Christ, for in him dwells all the fullness of the Godhead bodily, and you are complete in him who is the head of all principality and power." So the key word here is all. If Christ is the head of all principality and power, then is Christ equal to Caesar, or is Christ below Caesar? And the answer is Christ is above Caesar, and we are below Christ, and the government is below us. That is the only arrangement the Bible permits. And so all the people in the government at that point can only be servants. They cannot be masters. They cannot lord it over us. They cannot be superior to us. They cannot have supernatural or superior rights, because at that point they've erected a religion which competes with God's religion and God's worship, and they cannot do that. Caesar cannot compete with God for allegiance or obedience, and if he does, he's a thief, and he's poaching the sheep. "We cannot be a friend that is a domiciliary of the earth without being an enemy of God. This means we cannot be statutory citizens, residents, or inhabitants, or taxpayers, all of whom have in common an earthly rather than heavenly domicile." And here's the proof. Philippians 3:20. "For our citizenship is in heaven, from which we also eagerly wait for the Savior, the Lord Jesus Christ." And remember what we said earlier about citizenship. We said it was synonymous with domicile in the federal context. So if they're saying our citizenship is in heaven, they're also saying our domicile is in heaven, aren't they? And if our domicile is in heaven, and we can only have a domicile in one place at a time, then it can't be anywhere on earth, can it? Hello? Moving on. Hebrews 11:13. "These all died in faith, not having received the promises, but having seen them afar off, were assured of them, embraced them, and confessed that they were strangers and pilgrims on the earth." Now, that word stranger is important. Okay? It's saying that true Christians, true followers of God and Christ, are strangers and pilgrims. And a stranger and a pilgrim in legal jargon would be called a foreigner, or an alien, or a non-resident alien. Okay? Oh, and now you don't have to be all three of those at once. You could be a non-resident without being an alien. And you could be a non-resident citizen, for instance, under the laws of heaven. Okay? You could be a non-resident and a constitutional citizen, but not a statutory citizen at any given time. So the key to this disassociating with the government and not contracting and fornicating with the beast is to understand what kind of stranger you are and to avoid all privileged arrangements between you and the beast that would create inequality and make you worship them. And the next scripture is 1 Peter 2:1. Beloved, I beg you as sojourners and pilgrims, temporarily occupying the world, abstain from fleshly lusts which war against the soul. Okay, so a sojourner and a pilgrim is equivalent to a transient foreigner and a non-resident. If you're a non-resident in the place, that simply means you don't have a domicile in that place. And it means you have a domicile somewhere else, because you can never be without a domicile. And in the case of Christians, that other domicile would be in the kingdom of heaven. It would be associated with land that is owned by God and not Caesar. When we say owned, we mean permanently owned. God is the only one who can permanently own anything. Caesar is just a loan to Caesar. And just to show you how ridiculous this sort of thinking is, think about the Roman Empire. You know, if you're domiciled on land, permanently domiciled on land that was owned by the real Julius Caesar at one time or another, and the Roman Empire, and you called that domicile permanent, is Julius Caesar still around, or is the Roman government still around? And the answer is no. So, you know, could you ever really be anything but a sojourner, temporarily on land that was stolen by Caesar? No, you can't. You're a transient foreigner at that point, and you're not subject. But, you know, if you're born in the country that you're a transient foreigner in, but you don't have a domicile there, then you're a national, but not a citizen under the laws of that country, the statutory laws. And as a national who is not a statutory citizen, then you are not in a privileged state. And that's the only way that you can ever be in a non-privileged state, because we just established earlier that residents are foreign nationals, that is constitutional aliens who are in a privileged state by virtue of being in a country other than the one they were born in. James 4:4 is another good scripture on this subject. Do you not know that friendship, that is citizenship, which we said was synonymous with domicile in the federal courts, with the world is enmity with God? Whoever therefore wants to be a friend, that is a citizen, resident, or taxpayer of the world, makes himself an enemy of God. Why? Because you cannot serve two masters. You cannot have allegiance to two masters. You cannot have divided allegiance. And that's why you can only have a domicile in one place at a time, because you'd have divided allegiance. Okay? And Romans 12:2, and do not be conformed to this world, but be transformed by the renewing of your mind, that you may prove what is that good and acceptable and perfect will of God. And when they say conform to this world, they really mean having a status under the laws of Caesar. You cannot consent to any status under the laws of Caesar. And franchises are the method of conveying that status. So you cannot consent to any franchise. You cannot contract. You cannot fornicate. You cannot conduct commerce with the beast. Period. And the minute you do is the minute you join the government and become a public officer. And then you're toast, because they can do whatever they want to their employment agreement, now can't they? Or their public officer arrangement, because they created the office and it's their property. And they have the right to control all who use or benefit from the use of that property, called an office. They can only regulate what they created, and the only thing they can create are fiat currency and fake offices. And what they're doing is they're engaging in what's called a property rental business. They are renting a status called citizen and resident, and you are a temporary user of that status. We call it a rent-ident service. Okay, they're renting an identity under their laws, a status under their laws that carries with it rights and obligations that are enforceable in court. And you're a fool if you carry Caesar's property around in your back pocket, because you're always going to be working for Caesar, because the Bible says that the borrower is always servant to the lender. And if you use their stuff, whether it's a status under their codes called citizen, resident, taxpayer, driver, spouse, under the family code or whatever. If you use any of their statuses, you're toast because you're a borrower at that point. You borrowed their property. You borrowed the rights associated with that property. And they have a right to control that property because they lend it to you, and it's still theirs after they give it to you. And they can retract that property. They can insist on the return of that property at any time at all. And if you doubt us, look at the back of your Social Security card. It says this card belongs to the Social Security Administration and must be returned upon request. So what they're doing is loaning you that property, and that's how they made you a servant, their servant. And that servant is called a taxpayer. Okay? If you don't want to be a servant, you can't use their property in connection with any of your private property or any of your transactions or any of your relationships. And if you're compelled to do it, then you're committing a crime. 42 USC 408A8 is where that crime is located. And not only that, you're also impersonating a public officer to have or to use their property, because only public officers can be in custody or control of public property, period. So you're incriminating, you're illegally impersonating a public officer if you walk around with Caesar's property in your pocket or you use it in connection with a transaction. Moving on. Therefore, the only thing we can be without blaspheming God as Christians are transient foreigners and non-residents. And here's a definition of transient foreigner. One who visits the country without the intention of remaining. And why do we not intend to remain? Because the Bible says that the earth will be destroyed and replaced with a new earth. And it will be burned with fire. Okay? So why would you want to permanently remain on a place that's going to be burned by fire? And if you don't intend to remain here permanently, then can you have a residence there? No, you can't. Can you have a domicile there? No, you can't. Okay? And where will you go after you die? You're going to go to heaven. And once you're in heaven, then you're going to go to the new earth and not the old earth, but only after the old earth is destroyed. So you'll never return to this miserable place, this ball of dirt, this prison that will be burned with fire by God. If we can't have an earthly domicile, then we also can't owe allegiance to an earthly protector, because that allegiance is permanent. That's what we saw in Title 8 of the U.S. Code. We even showed you the definition of permanent. All protectors must be servants and not kings or Caesars. And here's Matthew 20, 25 through 28, as we read you earlier. You know that the rulers of the Gentiles lord it over them. Notice that word over them, meaning they're above. They have supernatural powers. They're being worshipped as a pagan deity. Okay? Otherwise, they'd be equal and they would not be over, right? And it says, and those who are great exercise authority over them. Yet it shall not be so among you. In other words, they cannot be above you. They have to be below you or equal to you. It says, but whoever desires to become great among you, that is a public servant, let him be your servant. And whoever desires to be first among you, let him be your slave. Just as the Son of Man did not come to be served, but to serve and to give his life a ransom for many. So in other words, if Christians create a government, that government must be a servant and not a master, and we must be sovereigns and not subjects. Okay? And as a bare minimum, we must at least be equal. Okay? And if we're not equal, then we must be above our public servants, but not below them, ever. Because then we're practicing idolatry and violating the first 4 commandments of the 10 commandments. The next subject we're going to cover is federalism. Federalism is defined in Black's Law Dictionary, page 612, as the term which includes interrelationships among the states and relationships between the states and the federal government. Federalism is discussed in the following executive orders of the President of the United States. Executive Order 13083, Federalism, and Executive Order 12612, Federalism. The legal implications of federalism. The Constitution creates separation of legislative power between the state and the federal government and between individual states. The purpose of this separation of legislative jurisdiction is to protect the constitutional rights of everyone. And here is a description in from the Supreme Court in New York versus United States, 505 U.S. 144 in 1992. To the contrary, the Constitution divides authority between federal and state governments for the purposes of individuals, a protection of individuals. Notice they didn't say for the protection of the government or protection of public servants or protection of corporations, but for protection of individuals. And why is that? Because all sovereignty is in the hands of individuals and not the collective and not the government in our system of government. And if it isn't, then it's not a republic. State sovereignty is not just an end in itself, rather federalism secures to citizens the liberties that derive from the diffusion of sovereign power. Just as the separation and independence of the coordinate branches of the federal government serve to prevent accumulation of excessive power in any one branch, a healthy balance of power between the states and the federal government reduce the risk of tyranny and abuse from either front. Now, what they're talking about here is the separation of powers that we keep harping on. And they're saying that the purpose of this separation is only to protect private, personal, individual rights. And okay, so if they break that separation down, then they're engaging in a conspiracy and a criminal activity to destroy your constitutional rights, which are irrevocable and unalienable. The federal and state governments are foreign and sovereign with respect to each other for the purposes of legislative jurisdiction. And as we said before, they can be foreign. The state and the national government can be foreign for the purposes of legislative jurisdiction without being foreign for the purposes of constitutional jurisdiction. So anybody that argues with us on this point has an obligation to prove which of those two jurisdictions that they're talking about when they say it's not foreign. And the minute that they address that issue is the minute they prove that they're lying to you. The state governments are foreign and sovereign with respect to each other for the purposes of legislative jurisdiction. And if the federal government invades the exclusive jurisdiction of a state, and it cannot produce a provision in the Constitution as a warrant for its authority, it must pursue express consent or comity of the state in some form. Now, that comity is an important subject because just nobody can contract for you unless you consent to let them contract. So even if a state enters into a consensual relationship with the national government, they cannot contract for you or on your behalf. They cannot alienate your rights. They can only alienate their own rights in the process of that contract. So they cannot consent to an interstate compact that surrenders any right that you personally have. And furthermore, you can only be a subject of that compact if you consent to join that state as a public officer. Otherwise, they're invading your right to contract and forcing you to contract by forcing you to become a party to that compact. They can't do that because governments are created. Why? To protect your right to contract and not contract. And so they can't force you to contract. And that's why they can't force you to be a citizen or a resident. That's why they can't force you to be a franchisee called a taxpayer or a driver. That's why you have to consent to all franchises by making an application for a license of some kind, or a driver license, or a mayor's license, or even a de facto license called a Social Security number or a taxpayer identification number. They can't just shove it onto you. And even after they give it to you, it's state property. And as long as you don't use it in connection with anything, it doesn't bind you to do anything. You have to use it in connection with a specific transaction for you to be treated as if you're a public officer in the context of that transaction. So, for instance, if you're a contractor and you have a contractor's license and you do work for somebody, but they aren't relying on the fact that you're a contractor in the context of their relationships, then in effect what you're doing is you're contracting the state out of the relationship and refusing to act as a public officer by doing business with this person. And it's perfectly within your right to contract this government out of the relationship. And if you don't have that right, then you have no right to contract, because the purpose of all governments is to protect your right to contract and not contract. And that right begins with your right to not contract with the government and to not be a party to their social compact or their civil statutory laws or their franchises. Because that's what the property right is. It's the right to exclude. If you own yourself and you own all your property, you have a right to exclude the state from benefiting from the use of that property. So you have the right to deny the state the benefit of associating you with a status that conveys rights or privileges to them. Period. State officials cannot consent to the enlargement of federal jurisdiction beyond the clear boundaries of the U.S. Constitution. The fundamental federalism principles from Executive Order 12612 are identified as follows. Federalism is rooted in the knowledge that our political liberties are best assured by limiting the size and scope of the national government. The people of the states created the national government when they delegated to it those enumerated governmental powers relating to matters beyond the competence of the individual states. All other sovereign powers, save those expressly prohibited the states by the Constitution, are reserved to the states or to the people. The constitutional relationship among sovereign governments, state and national, is formalized in and protected by the 10th Amendment to the Constitution. The people of the states are free, subject only to the restrictions in the Constitution itself or in constitutionally authorized acts of Congress, to define the moral, political, and legal character of their lives. And by the way, that legal character includes your status. You are the only one who can determine your status and who can refuse to acquire a status offered by a franchise. You have the right to not be a driver, or not be a spouse under the Family Code franchise, or not be a citizen under the Domicile Protection franchise, or not be a resident under the Domicile Protection franchise, or not be a taxpayer under the Internal Revenue Code trade or business franchise. And that is a fundamental component of the right to contract and not contract, and the right to associate and not associate. You have a right to determine what you want to protect you. And none of those statuses protect you. They only protect the government. They don't give a shit about you in most cases. So why would you want to acquire any of those statuses? And you may not realize this, but walk into a federal courtroom and watch how they treat people who don't want to be franchisees. Because what they're doing is they're only protecting their own gravy train, and they don't give a crap about you. And that's what protection rackets do. That's what organized crime does. Is they protect you from them, but they don't protect you from anybody else. In most areas of governmental concern, the states uniquely possess the constitutional authority, the resources, and the competence to discern the sentiments of the people and to govern accordingly. In Thomas Jefferson's words, the states are the most competent administrators for our domestic concerns and the surest bulwarks against the anti-republican tendencies. And by anti-republican tendencies, they really mean anti-individual right tendencies. Anybody who wants to go after your individual rights, because that's what federalism does, it protects your individual rights through the separation of powers. Anybody that's exercising anti-republican tendencies indirectly is engaging in a conspiracy to steal your constitutional rights guaranteed under the Bill of Rights. And if those rights are unalienable, there's no way they can steal them, because you're not allowed to give them up. And so what they do is they create all these word games, and they try to kidnap your identity and move it to the federal zone with all these franchises and statuses and license numbers, so they can create the appearance that you consented to their fraud, their protection racket. But at every point, you should vociferously argue against that consent. Everything you hand them, every form you ever fill out should always have an attachment defining every word on that form and specifically stating that this submission does not constitute an act of consent, does not constitute consent to acquire any status under any federal law, and that the applicant continues to be and is a private human not subject to any civil regulation or taxation. Moving on, the nature of our constitutional system encourages a healthy diversity in the public policies adopted by the people of the several states according to their own conditions, needs, and desires in the search for, and what they're describing here is self-government. In the search for enlightened public policy, individual states and communities are free to experiment with a variety of approaches to public issues. Acts of the national government, whether legislative, executive, or judicial in nature, that exceed the enumerated powers of that government under the Constitution violate the principles of federalism established by the framers. The policies of the national government should recognize the responsibility of and should encourage opportunities for individuals, families, neighborhoods, local governments, and private associations to achieve their personal, social, economic objectives through cooperative effort. In the absence of clear constitutional or statutory authority, the presumption of sovereignty should rest with the individual states. Uncertainties regarding the legitimate authority of the national government should be resolved against regulation at the national level. And when they say the presumption of sovereignty residing with the individual states, what they really mean here is that the states are equal to the federal government in every respect, and they should be presumed to be equal, which means they cannot be governed by the national government. And they can only be governed in areas they want to be governed in, and those areas require express consent in some form. Okay? And as we said, you should never consent to anything any government ever does. So you can never enter into that situation if you're a Christian. Further reference, Cooperative Federalism, Form 05.034, available on our forums page. In tandem with federalism is the subject of sovereign immunity. And here's the legal definition of sovereign immunity. And the place you're going to see this primarily is in courts, federal courts. Here's the definition from Black's Law Dictionary, 5th edition, page 1252. Sovereign immunity. Doctrine precludes litigant from asserting an otherwise meritorious cause of action against a sovereign or a party with sovereign attributes unless the sovereign consents to suit. Historically, the federal and state governments and derivatively cities and towns were immune from tort liability resulting from activities which were governmental in nature. Most jurisdictions, however, have abandoned this doctrine in favor of permitting tort actions with certain limitations and restrictions. See Federal Tort Claims Act, Government Immunity, and Tort Claims Act. The implications of sovereign immunity are that states enjoy immunity from suit in federal courts, and the federal government enjoys immunity from suit in state courts, and a sovereign cannot be sued in its own courts without its express statutory consent, and private parties wishing to sue a government must produce an express waiver of sovereign immunity somewhere in an enactment of the legislature in order to prevail in court. Now, when we say sue the government here, we mean under the civil statutory laws. And the only people who can invoke the benefits, privileges, and protections of those laws are who? People who are domiciled on federal territory. If you're not domiciled on federal territory, and you're in a foreign jurisdiction, then you're a co-equal with every other sovereign, including state governments and federal governments that are outside your state. Okay, so at that point when you're equal, then you have not waived your sovereign immunity, and therefore they cannot assert it. Okay, and you're equal to them. And if you're not equal, then they're lying to you if they say that they're a government of delegated powers, because they can't have it both ways. Either they got their power from you and you have it, or they don't have it and you don't have it. And if they want to assert that they have it and you don't have it, then indirectly they're creating a religion, because now they're asserting superior or supernatural powers above you, who are the natural, and they're creating a religion. And they're forcing you to worship them and pay tribute to them and obey all their void for vagueness codes, and participate and sign up for absolutely everything they offer. That's the ideal, quote, taxpayer, is somebody who's their whore at every department. They're a statutory driver, they're a statutory taxpayer, they're a statutory spouse, they're a statutory everything. And they worship zillions of false gods. Because every case where you walk in there they walk in there to try to enforce everything is always chaired by some franchise administrator, who falsely calls himself a judge, whether it's tax court or traffic court. They call it a court, but it's not really a court because he's not even in the judicial branch. He's in the executive branch, and he's just an administrator. And he is sitting there as the sole judge of everything. And the Supreme Court said in Yicko versus Hopkins that to put your property in the hands of a single human and subject it to the mere will of another is the essence of slavery itself. So you walk in front of any of these franchise judges and you're a slave, because he can do whatever he wants. He'll claim he has unlimited jurisdiction. And why does he have it? Because you signed up for the employment position and he's your supervisor, and he can tell you whatever the hell he wants you to tell you. And you're a fool if you accept the position. And that position is called citizen, resident, taxpayer, driver, spouse, or any other status that they want to assign to you. And you're an idiot if you go in there and fill out an application to become any of those things. Because you can't contract with the government. The beast. That's what the Bible says. Internationally, sovereign immunity is internationally recognized method for foreign sovereigns to waive sovereign immunity, and those provisions for waiving sovereign immunity are described in the Foreign Sovereign Immunities Act, 28 U.S.C. Part 4, Chapter 97. And explicit waivers of federal sovereign immunity include the following: the Federal Tort Claims Act, 28 U.S.C. 2671 through 2680, which waives sovereign immunity in the case of acts or omissions of government employees; 26 U.S.C. 7426A1, which waives sovereign immunity for the federal government in the case of a wrongful levy; 28 U.S.C. 1491, the Tucker Act, which waives sovereign immunity in the case of any express or implied contract with the United States; United States versus Mitchell, 463 U.S. 206, and the Religious Freedom Restoration Act, 42 U.S.C. 2000 BB-1 C, waives sovereign immunity in the case of violations of religious freedom. And by the way, we keep saying here that they're creating a religion if they have more rights than you. They're creating a title of nobility, which is also unconstitutional, if they have more rights than you. Okay? Any attempt to create inequality is a title of nobility and the establishment of religion. And usually that religion is based on a presumption, and that presumption serves as the equivalent of religious faith. So the Religious Freedom Restoration Act is a wonderful way to challenge that religion. It is the only method available to challenge that religion other than the First Amendment itself. And the First Amendment itself is self-executing and does not require any other statute. And we already said that the statutes only pertain to public officers in the government. And so you may just want to invoke the First Amendment. 28 U.S.C. 2680 contains exceptions to the waiver of sovereign immunity under the Federal Tort Claims Act, 28 U.S.C. 2671 through 2680. And here are the waivers, the exceptions to the waivers. 28 U.S.C. 2680C, tax assessments exempted from the waiver of sovereign immunity. So, in other words, they do not and cannot waive statutorily waive sovereign immunity for tax assessments. And obviously, a tax assessment is not a tax assessment if it's against a non-taxpayer. So, by definition, that situation where they assessed a tax against a non-resident, non-taxpayer, non-person would not fall in this exception, and they would still be liable. And 28 U.S.C. 2680K, offenses in a foreign country excepted from the waiver of sovereign immunity. So they are not. So an offense occurring in a foreign country, which by the way would not be protected by the Constitution, are accepted from the waiver of sovereign immunity. So in other words, they retain their sovereign immunity for those offenses. And an example of that would be, if they go down to Panama and they pick somebody up that they don't like and they kidnap them, that's a crime. And even if that crime was directed and orchestrated from the District of Criminals, it's not a basis to sue the government because it happened outside of the territory of the United States and in a foreign country, and that foreign country was not protected by the Constitution, and therefore there was no constitutional rights violation, and therefore there was no tort. So in other words, they can engage in any kind of criminal activity they want as long as it's outside the country, and when that happens, the laws of the foreign country are the only thing that can protect you. For further information on sovereign immunity, see Alden versus Maine, 526 U.S. 706, which is a recent Supreme Court case about sovereign immunity of the states. It also describes the history of sovereign immunity. And you can also look at Sovereignty and Freedom topic, Family Guardian Fellowship website, which is not our website. So when do governments not have sovereign immunity? When governments enter the commercial marketplace to offer goods and services, they implicitly waive sovereign immunity and are treated in equity like every other similar business that offers the same service. And by equity, what we mean is under the common law, because that is the foundation of the common law, is equity. Equity of all. Equity between you and the government. Equity between you and every other private human. Okay? And we covered some of these earlier. We covered all of these actually earlier, so I'll just let you go and read them again. Okay? But basically, if they're doing business in the commercial marketplace, then they have to obey the same rules as every other business. And if they don't, They have an unequal playing field, and they are exercising what could eventually become a monopoly. And they could use their legislative power to destroy all the businesses. And if they're created to protect those businesses, then they're defeating the very purpose they were established. So they have to obey the same rules, whether they want to or not. And we would add that their consent is not required. If they're engaging in commercial activity that's traditionally done by another business, and then they are subject to all the same rules as everybody else, whether they want to be or not. And we would argue that Social Security and every other form of social insurance and Medicare and Medicaid and everything else falls in the same category because it's not even authorized by the statutes to be exercised in a constitutional state. So it's outside the jurisdiction, and therefore it's private. It's only public if it's within their territory. And they cannot enforce their statutory laws in a state. And they're conducting a commercial invasion to even be there, in violation of Article 4, Section 4. And once they're there, they have implicitly waived sovereign immunity, and they can be and should be sued as a private party at that point, if they violate the rights of other businesses in that region. And we added one more thing to that list, a couple more things at the end here. Jones, 1 Court of Claims at page 85, wherever the public and private acts of the government seem to commingle, a citizen or corporate body must be, by supposition, be substituted in its place. And that corporation is a private corporation at that point. So the public corporation called the United States becomes a private corporation for the purposes of deciding jurisdiction if they're entering the commercial private marketplace. And it says, and then the question be determined whether the action will lie against the supposed defendant, the private corporation. So that's how they do it. And O'Neill versus United States in the Court of Claims, 231 U.S. Court of Claims 823 in 1982 says the following: the Sovereign Acts doctrine applies where the contracts exclusively between private parties, the party hurt by such governing action could not claim compensation from the other party for the governing action. The dissent ignores these statements, including the statement from Jones, from which the case Horowitz drew its reasoning, when it says that the Sovereign Acts cases do not emphasize the need to treat the government as contractor, the same as a private party. So, examples of implied waivers of sovereign immunity of the federal government. If it operates outside its own exclusive territory to offer or enforce commercial franchises such as Social Security, Medicare, Medicaid, Obamacare, etc., and it offers those services to non-residents. By non-residents, we mean people without a domicile on federal territory, who are, for instance, domiciled in a constitutional state, because their civil laws cannot reach outside of their own exclusive jurisdiction. Another example of a waiver. Waive the domicile prerequisite in enforcing the civil law by fiat and usually in violation of the law. This causes federal civil law to be enforced extraterritorially. In that capacity, can only operate extraterritorially as contract law that only applies to those who expressly and individually consent. An example of that: if you apply on an SS5 form to receive a Social Security card, notice we didn't say apply for benefits, because you're not applying for benefits. You're applying to receive custody of government property and to be a custodian over that property and to be a borrower of that property. So if you apply for that property using an SS4, then or an SS5 form, then there's a box on there for your citizenship. And the regulations under 20 CFR 4.22.103 and 104 specifically identify who is eligible to apply. And none of the people in there who are in a constitutional state are eligible. None of them. Okay? So if you walk in there and you apply for that card to receive that Social Security card, and they issue it to you, they're violating those two regulations, 20 CFR 422.103 and 104, and they have just waived the domicile prerequisite to participate in their franchise, because they cannot offer it for non-residents. They're not allowed to. You have to be resident. Okay? And otherwise, they're reaching extraterritorially, and they're engaging in a commercial invasion of a foreign country or a foreign state, a legislatively foreign state, in this case, the State of the Union. And when they do that, They are kidnapping the legal identity of that non-resident by forcing a franchise status upon them without their consent, such as taxpayer, driver, spouse, under commercial or franchise agreements. This is an act of international terrorism, like we just said, and it constitutes an invasion within the meaning of Article 4, Section 4 of the United States Constitution. Another way that they waive sovereign immunity is that they interfere with or sanction attempts to correct false or fraudulent reports connecting non-residents to its commercial franchises, and thus effect theft and kidnapping of that non-resident. If you're not eligible for Social Security and you're not a citizen or resident of the United States, where United States means federal territory, and you're not domiciled within a territory of the United States on federal territory, then you're not eligible for Social Security. And if they impute the status of a person or of a benefit recipient under the Social Security Act to you, they have kidnapped your identity. And they have committed identity theft. They're not allowed to do that. And Federal Rule of Civil Procedure 17 says they can't do that. They cannot quote, they cannot use, they cannot enforce any of their civil laws against you, including franchises, because you cannot consent to give away an unalienable right, can you? And that right is unalienable as long as you're domiciled in a constitutional state. And that is why the definitions in the Social Security Act never include the constitutional states, because they know they can't do it. And your legal ignorance is what allows them and protects them in conducting this kidnapping. Okay? If you like being kidnapped, go in there and fill out all these forms and not reserve your rights and everything else. And you're an idiot if you do. And we explain how this this kidnapping, in this case, we're talking about false reports. Okay? So an example of a false report is a information return, such as a 1099 or a W-2 or a 1098 or a 1042-S or something like that. Okay, if somebody files those against you and you're domiciled outside of the federal zone, then they are conducting an identity theft and a kidnapping. They have kidnapped your effective domicile and moved it to the District of Criminals. And as we said before, they're filing a false return because information returns are returns within the meaning of the criminal provisions or the penal provisions of the Internal Revenue Code. And if you don't say anything, then you're engaging in the Stockholm Syndrome. You are sympathizing with your kidnappers, and you should never do that. And you can't consent to elect yourself unilaterally into a public office, as we said before. And therefore, you cannot tolerate any attempt to connect you to an office, including through a false report, because then you're committing a crime, and if you don't report it, if you don't prosecute it, then you're an accessory after the fact to the crime. Okay? So you have to report it. And if those reports were accepted, and if they were properly prosecuted by the Department of Justice, instead of being treated as a bribe to treat you as a public officer, then all this income tax crap enforcement, this illegal enforcement within states of the Union would stop immediately if they made an example of just out of a handful of people who are doing this. And there are millions of them, we might add. So as we said before, you have sovereign immunity. Why? Because the government has it, and they're a government of delegated power, and it was delegated from the collective to them, and the individual delegated to the collective. So you have it too. You can't delegate what you don't have. Now can you? So you must have it. The collective can't have it if you don't have it, and the government can't have it unless the collective has it. There's a chain of authority there, and it has to be unbroken. And the purpose of that chain is to maintain the equality between you and the government. Any government attempting to enforce a civil liability, statutory liability, in a civil court of law has the burden of proving with evidence that you consented to the obligation being enforced, and that you that the consent took the form that you and not anyone in the government defined or determined. That form should preferably be in writing. Okay, you shouldn't allow them to presume that it exists. You shouldn't tolerate any presumptions about that it exists. You ought to challenge every assertion that it exists. You should force them to prove it as the moving party, because they're the one doing the enforcement. And as long as they're in that position, as long as they're that uncomfortable, as long as they actually have to do work to steal from you, then they're more likely to leave you alone. If the government cannot satisfy the same burden of proof of an express intentional waiver of your sovereign immunity in any civil proceeding against you, then the judge has the same obligation to dismiss the suit that he or she would have towards the government if you sued it. Why? Because we're all equal. That's what Obama said in his inauguration speech. All are equal. And anybody who wants to argue with us on this point is challenged with the following question. What part of all do you not understand? Okay, all means everyone is equal. That means everyone in the country is equal, and the people in the country are equal to the government in any civil litigation. And the only way you can become unequal is with your consent. And as we said before, that consent has to be manifested on federal territory where there aren't any rights to alienate. Otherwise, they're stealing from you. No one can enforce any civil statutory obligation against you, a sovereign, without your consent. And that consent can come in two forms, either written or invoking a status to which rights of the government attach. Okay, so don't ever use their statuses, don't use their cards, don't use their numbers, don't ever consent to anything they want to do to you, and insist on equality at all times, and insist that your rights are unalienable and therefore you can't even give them up lawfully. And tell them that they're trying to steal from you if they try to make a business out of alienating or reducing those rights or eliminating your equality. And that is a violation of their fiduciary duty as a public officer, because they only have one job, and that is to protect private rights and private property if they claim to be a public officer. And if they won't do that job, you shouldn't pay them to do any other job. And if they don't enforce your sovereign immunity, then they can't enforce sovereign immunity toward the government either. And all you have to do is argue that we're all equal. Okay, if they don't have it, you don't have it. And if they have it and you don't have it, then they're superior and supernatural, and you're doing a religion, and the courtroom is just a church, and the judge is just a priest, and the code is just the Bible. That's all that's going on. And the attorneys are just the deacons of the church at that point, if they're unequal in relation to you. Exceptions to sovereign immunity. Sovereign immunity does not apply to criminal enforcement. You do not have to consent to the criminal law to be subject to it. You need only be present on the physical territory of the lawmaker and commit the act that is a crime. And it does not apply to constitutional violations by government actors. They cannot assert sovereign immunity if they violate your constitutional rights, because those rights are unalienable. And it does not apply to common law actions against either you or the government. The common law can be enforced in equity against you or the government only if there is a demonstrated injury. Okay, if there's an injury, then every man has a natural inherent right of self-defense. And the common law is the method to invoke that defense. And that defense does not require the consent of the party who injured you. All it requires is the proving an injury and recouping compensation or reparations for the injury. Okay? So once again, the civil statutory law requires consent. The common law and the criminal law don't. Next, we're going to cover citizenship. There is a lot of confusion over citizenship within the freedom community. It is important to understand distinctions. A constitutional citizen is defined simply as a member of a political community. Minor versus Happersett, 88 U.S. 162. The U.S. Supreme Court said the following: there cannot be a nation without a people. The very idea of a political community, such as a nation, implies an association of persons, and by association they mean a voluntary, consensual association of persons for the promotion of their general welfare. Each one of the persons associated becomes a member of the nation formed by the association. And that association, by the way, is your First Amendment right of association. That's what it is. That's what they're talking about here. So it's a First Amendment right to associate, but with every right, you have the opposite right. If you have a right to associate, you also have a right to not associate. And if you don't join the club, then the civil rules don't apply. The civil statutory rules. That's how it works. He owes it allegiance and is entitled to its protection. Allegiance and protection are, in this connection, reciprocal obligations. The one is a compensation for the other. Allegiance for protection and protection for allegiance. Now, why did they state it that way? Because they're describing a contract. And it's not a valid contract or compact or social compact unless it contains mutual consideration and mutual obligation. You give them allegiance and support. In return, they give you protection. If either one of you fails to deliver your consideration, then the contract is unenforceable and it's been violated. Okay? And if you're accountable and if you can be thrown in jail for not providing your part of the bargain, and they can't, then the contract is unenforceable either, because at that point, it doesn't contain mutual consideration. And furthermore, if it eliminates the equality between the two of you, it makes you into a subject just in order to enforce it, then it also is not really a valid contract because it destroys the equality of the parties under the law. And that's the foundation of our system of law, is equality of rights and equality of treatment. Membership in a political community simply means the ability to vote, the ability to serve on jury duty, and that we can defend our fellow citizens but are not necessarily subject to all the laws of or the legislative jurisdiction of the community. There are exceptions to the above, but they are rare. Some states have additional voter and jury qualifications beyond simply being a citizen, such as age restrictions. A national is therefore simply someone who owes allegiance to a state, see 8 USC 1101A21, which means the people rather than the government who serves them. But what citizenship is not is important. Your nationality is not the source of your private or constitutional rights. Rights come from God. They're created by God. And rights are recognized but not created by the Bill of Rights and the Constitution. And rights attach to land and not your citizenship status, because the Constitution attaches to the land. See Downs versus Bidwell, 182 U.S. 244. And the more laws that government passes, the fewer rights that citizens have. Laws take away, not expand rights. The fewer laws we have, the more rights we have. Your ability to demand the protection of a government and the law for your rights does not come from your nationality status. Even aliens have civil rights that are equal to those of citizens. The very essence, and here's what the Supreme Court said on this subject, Marbury versus Madison, 5 U.S. 137, the very essence of civil liberty certainly consists in the right of every individual, and notice they said individual rather than citizen, okay, to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. Now, we already said that the civil statutory codes are not technically laws. So the only laws they can be referring to here are the common laws. That's it, because those are the only laws, real laws, that don't require your consent. Okay? Just like we just said. So they're not talking about the civil statutory laws. And the invocation of those laws is not a privilege, and it's not revocable. If you're on that land, you can invoke it. And when you invoke it, the government technically is not a beneficiary of that invocation, because you don't have to pay them any penalties. And this is strictly a matter between you and the other party. And the government can't penalize you or tax the relationship, because if they do, they're interfering with your right to contract. And the whole idea of invoking the common law is to contract the government out of the relationship so they don't interfere with it. And the parties who even decide the case is the jury and not the judge. That's what is intended to work. So at that point, you have contracted the government out of the relationship. You have removed yourself from the social compact. You're not the subject to the civil statutory laws. And nobody who is subject to the civil statutory laws can invoke any of those laws against you. They have to invoke equity in the common law, and that's it. What citizenship is not. Your ability to exercise your political rights to vote and serve on jury duty in a state of the Union does not come from your status as a statutory U.S. citizen, pursuant to 8 U.S.C. 1401, but rather from your status as a constitutional citizen, which is also called a national in federal statutes. Allegiance is the only thing you need to vote or serve on jury duty, And allegiance is a product of your nationality and not your statutory U.S. citizen status. See 8 U.S.C. 1101A21. And allegiance derives from being a national under 8 U.S.C. 1101A21 and not a U.S. citizen status under 8 U.S.C. 1401. If you would like to learn more about the above concepts, see Great IRS Hoax, Form number 11.302, Section 4.2.4 on the Family Guardian Sister site. And also see Why You Are a National, State National, and Constitutional but Not Statutory Citizen, Form number 05.006 on our Forms page. The types of citizenship jurisdiction. There are two types of jurisdiction. Political jurisdiction, which is based on allegiance and nationality and being a national, under 8 U.S.C. 1101A21 and or 8 U.S.C. 1101A22. And then legislative jurisdiction, which is based upon domicile and only domicile, and being a statutory citizen under the civil statutory laws. Now this is very important because this goes along with the concept of constitutional versus statutory contexts. Okay? The political jurisdiction is the constitutional context. The legislative jurisdiction is the statutory context. And the two, as we said, are mutually exclusive and non-overlapping. One can be subject to the political jurisdiction without being subject to the legislative jurisdiction. An example would be an American national domiciled in a state of the Union on land within the exclusive jurisdiction of that state that is not federal territory. That person would be subject to the political jurisdiction of the United States by virtue of possessing both of the following characteristics: being born or naturalized anywhere in the country United States, star, meaning the country rather than federal territory or the states of the Union, and having allegiance to the United States, star. That United States, meaning the country, implies the people who are the state in our form of government. It would not be to any government, ruler, or civil servant. So a person who has allegiance to the country United States has allegiance to the state, quote unquote, and that state, as we said earlier, is defined in Black's Law Dictionary as the people and not the government who serves them. So your allegiance is not to the government, it is to the people. Because they are the sovereigns and not the government that serves them, in the states at least. Types of citizenship jurisdiction. A state-domiciled American national does not have a domicile on federal territory and therefore is not a statutory civil person or individual under federal statutory law, is therefore not subject to the exclusive federal civil legislative jurisdiction under Article 1, Section 8, Clause 17 of the United States Constitution, and would be subject to federal criminal law within Title 18 of the U.S. Code only by setting foot temporarily on federal territory and committing a crime while there. All law attaches to territory of the sovereign, and the states of the Union are not territory of the national government, but rather sovereign nations in many particulars, but not all particulars. A state-domiciled American national would only become a statutory person and an individual under federal franchises by being lawfully elected or appointed to public office in the United States government and serving in only the District of Columbia as required by 4 U.S.C. Section 72. And a state-domiciled American national cannot lawfully elect themselves into public office by filling out or submitting any government franchise form. If they do, they are committing the crime of impersonating a public officer under 18 U.S.C. 912, as we have said before. For further details on these subjects, you can read excruciating detail in our form entitled Political Jurisdiction, Form 05.004, which discusses political jurisdiction on our forms page, and Federal Jurisdiction, Form 05.018, which discusses legislative or statutory jurisdiction. Okay, so political jurisdiction implies constitutional context. The legislative jurisdiction implies statutory context, and they do not overlap. They are mutually exclusive. You can be one without being the other. Okay, you can be a constitutional citizen without being a statutory citizen. You can be a statutory citizen without being a constitutional citizen, because there are two separate legislative jurisdictions that Congress legislates for, and they are separate under the separation of powers doctrine. And the Supreme Court talked about those separate jurisdictions in the early case of Cohens versus Virginia, which we highly recommend. So here is a jurisdiction chart of the various citizenship jurisdictions. Okay, there are 4 in our chart. Okay, so what we do is we define phrases that you will commonly find in various contexts, and we identify the context here, and we identify the type of jurisdiction that it implies. Okay, and we also define how that jurisdiction was created and the extent of the jurisdiction. So when somebody uses the phrase subject to the jurisdiction, which is found in the 14th Amendment, Section 1, then it implies the political jurisdiction and not the civil legislative jurisdiction. And that jurisdiction is created by an oath of allegiance to the United States, including a birth or naturalization in the United States, the country. And the extent of that jurisdiction is states of the Union, federal territories, and federal possessions. But it is a political jurisdiction, not a legislative jurisdiction. The second type of jurisdiction is invokes the phrase subject to its jurisdiction. And you commonly find that phrase in federal statutory law, and including the Treasury regulations, 26 CFR 1.1-1. And notice it's the only difference between the first one and the second one is the third word. Okay, the first one says the jurisdiction, and the second one says its jurisdiction. And so the word the implies political, and the word its implies legislative. That's how it works. And it applies to legislative jurisdiction, and the way that this specific type of jurisdiction is created is with domicile on federal territory only. If you're not domiciled on the territory, then the civil statutory laws don't apply there under Rule 17. And that jurisdiction only applies in federal territories and federal possessions. The third type of jurisdiction is yet another word for the third word, which is there instead of its or the. Okay, and you find this in the 13th Amendment. It uses that phrase, subject to their jurisdiction. And by there, they mean a multiplicity of things, a multiplicity of states, a multiplicity of constitutional states. Okay, and the 13th Amendment, you may recall, outlawed slavery in states, but it also outlawed it in federal territory, according to the Supreme Court. And the type of jurisdiction that this implies is political jurisdiction. Okay, so, and this jurisdiction is created out of an oath of allegiance to a state of the Union. Becoming a citizen under state law is one way. And it applies only within states of the Union. That's why they use the word there, because there are multiple states. Okay, and the fourth type of jurisdiction uses the phrase within its jurisdiction. And this is found in the 14th Amendment, Section 1. And this is a political type of jurisdiction. And it is created by an oath of allegiance to a state of the Union and becoming a citizen under state law. And it applies only within states of the Union. So now let's examine, now that we know the two types of context, statutory and constitutional, let's examine the two classes and 4 distinct types of citizens. Okay? There are state citizens and federal citizens. Those are the two classes. And the types of citizens underneath those classes are the following. We have state citizens born in a state of the Union, which are not described directly in federal citizenship statuses. Why? Because they're born outside the territory of the national government. And hence they are not subject to the legislative jurisdiction of the government, and hence they cannot have a status under the laws of the federal government. That's why they aren't mentioned in those statutes. The other class is federal citizens, and within federal citizens we have constitutional citizens of the United States. And these constitutional citizens are described in the 14th Amendment, Section 1. They're born anywhere within the Union of States called the United States of America in the Articles of Confederation, and they are described in 8 U.S.C. 1101A21, and they are called simply nationals or state nationals, but not, quote, citizens, unquote, under all acts of Congress. And The other type of federal citizen is statutory nationals and citizens of the United States, star star. And we said earlier that 2 stars implies federal territory in the federal zone. And these people are born in the District of Columbia and the territories of the United States, and they are described in 8 U.S.C. 1401. And this is what we call a statutory citizen. And statutory nationals but not citizens of the United States, star star, at birth. And these people are born in American Samoa and Swains Island. They are described in 8 U.S.C. 1408. And they are called U.S. nationals by the federal courts. According to the U.S. Supreme Court, in Boyd versus State of Nebraska, 143 U.S. 135, all, quote, state citizens, unquote, are ipso facto a, quote, citizen of the United States. Star, 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 meaning they are citizens of the states. Now, the important thing here is that this phrase, citizen of the United States, is used in many different contexts and has many different meanings. In the statutory context, it looks exactly the same. It's called a citizen of the United States, but it's not a state citizen. And it's not a state citizen because the term United States itself, as we said, has 4 different meanings. It has 3 geographical meanings, and it has 1 legal meaning as United States the person. So, and star, star, star implies the constitutional context and not the statutory context, and it applies states of the Union and not federal territory. So that is the citizen of the United States they're talking about. And in many cases, courts will try to confuse a statutory citizen with a constitutional citizen. And they will do this on purpose to usurp jurisdiction over people they have no jurisdiction over. These people are aliens for the purposes of statutory jurisdiction if they were born in or naturalized within a constitutional state. They are aliens under federal law, but only if they're on physical territory or doing business in federal territory. Otherwise, they're simply non-residents. Okay? And the courts don't want to expose this implication of the separation of powers because it would remove most of their power in just about every subject. So they refuse to talk about it. But it is, in fact, the truth. And we've written a whole document about it entitled Why You're a National, a State National, and a Constitutional Citizen. And it explains in excruciating detail how they effect this switcheroo, this confusion of context so they can steal from you and steal jurisdiction they don't have. And that confusion is the source of all of the arguments, all of the confrontations about what it means to be a citizen and whether you're a 14th Amendment citizen or whatever, okay? Everybody claims they're not a U.S. citizen, but they don't know what U.S. citizen they're talking about because they don't even know what the various types of United States there are, and they need to study that before they even open their noggin or open their mouth on the subject, because they're embarrassing and discrediting everybody in the freedom community by not doing their homework and not getting educated. Ignorance is the enemy here. It's not the government, because ignorance is what protects and facilitates all the fraud, all the identity theft, all the theft that's going on in federal courtrooms across the country. And there is more of that kind of crime going on than any other kind of crime in the country right now. Most confusion over citizenship results from differences in the meaning of the term United States between the Constitution versus United States and the statutory codes. In the Constitution, the United States means the collective states of the Union, as identified by the Supreme Court, whereas in federal statutes, such as Title VIII and the Internal Revenue Code, United States means the District of Columbia and the territories, which include Puerto Rico, Guam, and the Virgin Islands, and exclude states of the Union, which are foreign, and by foreign we mean legislatively foreign, not constitutionally foreign, states. But it's very important to remember and realize that statutory citizens of the United States, star, meaning people domiciled on federal territory and born there, under 8 U.S.C. 1401, and constitutional citizens of the United States with 3 stars, under the 14th Amendment, are mutually exclusive groups of people. You can be one or the other, but you can't be both. Why? Because you can only have a domicile in one place at a time. And you have to have a domicile before you can be that kind of citizen. Hello? And another way of saying that is you cannot serve two masters. You cannot serve two governments. You cannot have primary allegiance to two governments at the same time. It must be to only one government, and that allegiance is either to the state or to the national government, but it can't be both. Okay? If you're a state citizen, your primary allegiance is to the state, and that state is an agent of the federal government, and therefore indirectly you do have allegiance to the national government by virtue of your allegiance to the state. That's how it works. And remember, according to the Supreme Court in Minor versus Happersett, a citizen is simply a member of a political community. And we have two, not one, political communities in our country, which we said was identified by the Supreme Court in Cohens versus Virginia. And those two communities are the federal zone, consisting of the District of Columbia and the territories and possessions of the United States, and the states of the Union united under the Constitution. This separation of communities is a consequence of the separation of powers. And the Supreme Court described this separation and the purpose of this separation in U.S. versus Lopez, 514 U.S. 549. We start with the first principles. The Constitution creates a federal government of enumerated powers, U.S. Constitution, Article 1, Section 8. As James Madison wrote, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. Federalist number 45, pages 292 through 293. This constitutionally mandated division of authority was adopted by the framers to ensure the protection of fundamental, personal, private rights and liberties. Gregory versus Ashcroft. Just as the separation and independence of court and branches of the government, federal government serves to prevent the accumulation of excessive power in any one branch, a healthy balance between the states and the federal government will reduce the risk of tyranny and abuse from either front. Anyone who tries to confuse the two types of citizens above is trying to destroy the separation of powers and prejudice your God-given rights. And they're not only trying to prejudice those rights, they're trying to steal those rights. And the legal definition of property includes rights. So they're stealing property from you. And the great irony is that governments are created to protect your right to property, because the property right is the essence of your happiness. That's what they've said. Okay, the right, the pursuit of happiness, as we said, is defined, legally defined as the right to own property. And by own, we mean exclusively own, meaning that you don't have to share it with anybody. You don't have to share it with any government. You own it, and you can deprive everybody else from using or benefiting from the use of it. And if you don't have that right, you don't own anything. Okay? The separation of powers doctrine is described on the Family Guardian Sister site in the article indicated there at the link. And the government conspiracy to destroy the separation of powers, Form 05.023 on the SCDM Forms page, that analysis describes how the separation of powers works, why everybody in the government wants to destroy it, because all they want to do is steal from you. That's what politicians do. They lie and steal. That's all they do. All they do is protect their little gravy train of plunder and lie to you to get elected. And once they're in there, they do whatever the hell they want. Pardon our language. Flawed arguments about citizenship. Citizenship is widely misunderstood by the American public. That misunderstanding has been created and perpetuated by a corrupt government and legal profession. And the most important subject you can learn about is citizenship. It regulates every aspect of how the government interacts with those it is charged with protecting. And there are two components of citizenship. There is your nationality and there is your domicile. And those two things together determine your citizenship. They can never be separated. They have to be considered together. Okay, and if they are avoided, if the court won't talk about those two components of citizenship and its effect on your status, your civil status, if they try to confuse those two or create the appearance that they're the same, then the judge and the prosecutor are trying to steal from you. And you should vociferously argue about it. The most frequent misunderstandings about citizenship relate to the 14th Amendment. And until these misunderstandings are eliminated through education, there is no hope of ever reforming a corrupted government. And we've written, and the Family Guardian Sister site has written, several documents that discuss this confusion and this misinformation by public servants about citizenship. If you think the 14th Amendment is a threat to your freedom, then you have been deceived, and you should read our document entitled Why the 14th Amendment is Not a Threat to Your Freedom, Form 08.015. We go into excruciating detail about why that is the case. Just about, I would say, a vast majority of freedom lovers mistakenly and incorrectly state that the 14th Amendment is a fraud, that it makes you surety for the debts of the government, that it makes you into a citizen that's subject to the jurisdiction of the government, and all this other crap. And that's totally untrue. And we prove why it's untrue. And you should read that, because we've got to stop this idiocy on the part of people about citizenship. And this idiocy, this ignorance, this perpetual ignorance is just really damages the credibility of the freedom community and fragments it. And it's completely unnecessary. If you are from the government and you think people in states of the Union are statutory U.S. citizens under 8 U.S.C. 1401, then please read Flawed Tax Arguments to Avoid, Form 08.004, Section 6.1 on the Forms page. And for other flawed citizenship arguments, please see Why You're a National, State National, and Constitutional but Not Statutory Citizen, Form 05.006, Section 17. And so these are all the main arguments you're going to see, and a rebuttal of all of them. This is already too long of a presentation, so we can't get into them now, but I think you know why, the basic answers to why you're not a statutory citizen if you are domiciled in a state of the Union. The next thing we need to talk about is stateless persons. A stateless person is a person who has no domicile within the country whose courts he seeks to litigate. So you can be, if you were born in, let's say, the Philippines, and you come to the United States and you don't select a domicile in the United States, then in relation to the United States and every jurisdiction within the United States, you are a stateless person. But if you went back to the Philippines and you had a domicile in the Philippines, you would not be a stateless person there. So, and we said earlier that Christians cannot select a domicile within a country because they cannot worship a false god called government and be inferior or subject to that government. Then you could say that Christians would be stateless persons within the meaning of the local laws of the United States if they followed the Bible as it indicates and did everything God wants them to do. They would be stateless everywhere in the United States. Okay, that's not to say that they wouldn't be protected. It's not to say that they couldn't invoke the protections of the common law while they're there. It just means they couldn't invoke the statutory law. But why would you want to invoke that anyway? Because it presumes the government is a parens patriae and that it can steal or take whatever it wants. Why would you want that kind of a relationship with anybody? Okay, why would you want to nominate a parens patriae? Why would you want any government or any civil ruler to be above you? The Bible says they have to be below or equal to you. That's what Jesus said. And anybody that does anything else is a fool, according to God. A person is statutorily stateless if he does not maintain a domicile in one of the federal states listed in 28 U.S.C. 1332, which are all federal territories. And there are two ways to become a statutory stateless person. The first way is abandoning one's nationality in all countries on earth, which is called expatriation. Okay? And that would make you a stateless person everywhere on the planet. Okay? Another way is abandoning domicile in the place you just happen to be at, and thereby disassociating with that government, and you're disassociating civilly, not criminally, while retaining your nationality by birth or naturalization. And that's described in Why Domicile and Becoming a Taxpayer Require Your Consent, Form 05.002 on our Forms page. A person may simultaneously be a statutory national or constitutional citizen under the 14th Amendment, but not a statutory, quote, citizen of the United States, and we mean * here, under 8 U.S.C. 1401. A statutorily stateless person, and A person may also be a statutorily stateless person if he abandons domicile in the federal zone, but he can also be not be constitutionally stateless under Article 3 of the Constitution because he maintains a civil domicile within a constitutional state of the Union. Okay, so if you're not domiciled on federal territory, then you're stateless for the purposes of the federal government. Okay, but you're not stateless for the purposes of the state government. Okay, so it's all relative to being stateless as a term is all relative to a specific government and only that government. Okay, you can be stateless in relation to the national government while at the same time not being stateless in relation to the federal government, or I'm sorry, to the state government. Federal Rule of Civil Procedure 17b says that the choice of law in any federal case is determined by the domicile of the parties. Okay? It says the capacity to sue or be sued shall be determined by the law of the party's domicile. So if you don't have a domicile in a place, then you can't be sued under the laws of that, the civil laws of that place, the civil statutory laws. You can be sued under the common law, and you don't even need to consent to a domicile there to be sued under the common law, but you cannot be sued under the statutory civil law. The downside of being a stateless person is that it is more difficult to defend your rights in federal court because standing to sue civilly is determined by one's legal domicile, Federal Rule 17b. And that means you have to research all the case law on a subject instead of the statutes to find your remedies, and that can be time consuming. And that's why the Supreme Court refers to the common law instead with the phrase, the rigors of the common law, quote unquote. A stateless person is a non-taxpayer not subject to the Internal Revenue Code in relation to the national government. He may not invoke statutory diversity of citizenship as described in 28 U.S.C. 1332 A2 and A3. See Newman Green versus Alfonso Lorraine, 490 U.S. 826. And he must therefore invoke constitutional diversity of citizenship pursuant to Article 3, Section 2 of the Constitution. And he or she must litigate as a foreign sovereign under the Foreign Sovereign Immunities Act and satisfying the requirements of the minimum contacts doctrine described in International Shoe Company versus Washington, 326 U.S. 310, 1945. So how do you protect your rights in courts of a legislatively but not constitutionally foreign state as a stateless person? And the answer is to sue under equity and invoke the common law and thereby repudiate all civil statutory laws of the corrupted state. And you must cite the laws of the Bible as a foreign law under Federal Civil Rule of Procedure 44.1 and insist that the court apply only this as law in your case. And you should form your own state that protects its own members. This would be like an ecclesiastical court or a common law court in your area or your community. Or you can form your own church or group or family that protects its own members. Civilly, that is. What the U.S. Supreme Court says about being a stateless person. Here's what they say in Kennedy versus Mendoza-Martinez, 372 U.S. 144. An expatriate who, like Court, had no nationality becomes a stateless person. A person who, and by no nationality, they mean no nationality in the United States. They don't mean no nationality anywhere. It says, a person who not only has no rights as an American citizen, but no membership in any national entity whatsoever. Such individuals as do not possess any nationality enjoy in general no protection whatever. That's not quite true because they enjoy the protections of the Constitution. All they have to be is on the land to enjoy those protections. And if they are aggrieved by a state, they have no means of redress since there is no state which is competent to take up their case. That couldn't be true because the Constitution attaches to the land. They may not have a civil remedy, okay, and the state may not be able to invoke a civil statutory remedy, but they still have the Constitution, and that law is law for government. So that's not true. As far as the law of nations is concerned, there is, apart from restraints of morality or obligations expressly laid down by treaty, no restriction whatever to cause a state to abstain from maltreating to any extent such stateless individuals. Okay, what they're talking about here is somebody with no nationality in a specific country and no presence there, okay? Once you're there, once you're standing on the land, now you're protected by the Constitution. But if you weren't physically on that land, you wouldn't be. The calamity is not the loss of specific rights, then, but the loss of a community willing and able to guarantee any rights whatsoever. The origins of totalitarianism, page 294. The stateless person may end up shunted from nation to nation, there being no one obliged or willing to receive him, or, as in Court's case, may receive the dubious sanctuary of a communist regime lacking the essential liberties precious to American citizenship. Well, those liberties they're talking about are only the Constitution. Okay, all the civil statutory remedies, you don't need them. We therefore think it is a bad idea to expatriate. Your constitutional citizenship is one of the most valuable things you can have. However, we also think that having an earthly domicile in a pagan godless state instead of a church group violates the Bible. Consequently, the Christian who is following the Bible must be a national but not a citizen with no earthly domicile. And we prove this in Why Domicile and Becoming a Taxpayer Require Your Consent, Form 05.002 on our forms page. A person domiciled in a state of the Union who has not expatriated and is a non-taxpayer cannot lawfully suffer the ill fate of court above. And he would be statutorily stateless pursuant to 28 U.S.C. 1332, but not constitutionally stateless. And he may invoke Article 3 jurisdiction in federal court to defend his rights because he's physically present on land protected by the Constitution, but he may not cite any portion of the Internal Revenue Code in his defense because he's not subject to it. And he still has standing to sue under the Foreign Sovereign Immunities Act, and he may still invoke 42 U.S.C. 1983 suits for the violation of constitutional rights, because that executes the protections of the 14th Amendment, which does apply to whether you're a domiciliary or not. And he may still defend his rights with a constitutional tort action in federal court. And here's proof that the Israelites and all sovereign people are stateless. And by stateless, we mean stateless in relation to a specific government, but not all governments. Okay? Those people who are not governed by God and his laws will be ruled by tyrants. That was William Penn, after which Pennsylvania was named. And the Bible, in Esther 3:8-9, then Haman said to King Ahasuerus, there is a certain people, we talked about this earlier, the Jews, who today are the equivalent of Christians, scattered and dispersed among the people in all the provinces of your kingdom. Their laws are different from all the other peoples, and they do not keep the king's unjust laws. Therefore, it is not fitting for the king to let them remain. If it pleases the king, let a decree be written that they be destroyed, and I will pay 10,000 talents of silver into the hands of those who do the work to bring it into the king's treasuries. And Thomas Jefferson writes of British America, 1774, he said, a free people claim their rights as derived from the laws of nature, that is God and his laws, and not as a gift of their chief magistrate, and we might add, or any other government statutory law. Citizenship and taxation. Corporations are also either statutory citizens or statutory residents within the jurisdictions they are domiciled. A corporation is a citizen, resident, or inhabitant of the state or country by or under the laws of which it was created and of that state or country only. And that's found in volume 19 of the Corpus Juris Secundum Legal Encyclopedia under Corporations, sections 886. The federal income tax is imposed on statutory but not constitutional citizens and residents in 26 U.S.C. Section 1, by which is meant mainly federal corporations incorporated in the District of Columbia. And corporations incorporated under state law are not statutory citizens or residents within the meaning of the Internal Revenue Code. Because we said there are two types of jurisdictions and therefore two types of corporations. State corporations and federal corporations. You cannot be one. You cannot be both types at the same time. Christians cannot have an earthly domicile and therefore are not allowed to be statutory citizens. They can only be constitutional citizens and statutory nationals, but not citizens under federal and state law pursuant to 8 U.S.C. 1101-821. And we find this in Philippians 3:20. We talked about this earlier. For our citizenship is in heaven, for which we also eagerly wait for the Savior. And Ephesians 2:19, now therefore you are no longer strangers and foreigners, but fellow citizens with the saints and members of the household of God. And if you're members of God's household, you can't be members of Caesar's household, because you can only have a domicile in one place at a time. And Hebrews 11:13, these all died in faith, not having received their promises, but having seen them afar off, were assured of them, embraced them, and confessed that they were strangers and pilgrims on the earth. And 1 Peter 2:11, beloved, I beg you as sojourners and pilgrims, abstain from fleshly lusts, which war against the soul. Your government doesn't want you to know the truth about citizenship and lots of other things, folks. Definition of United States in federal law. This is really important. 8 USC 1101 for the purposes of citizenship. 1101A38. The term United States, except as otherwise specifically provided herein, when used in a geographical sense, means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, and the Virgin Islands of the United States. And the definition of continental United States, for the purposes of that thing above, is found in 8 CFR section 215.1. The term continental United States means the District of Columbia and the several states except Alaska and Hawaii. And if we then go to 8 USC 1101A36, at the definition of state, we find no state of the Union listed there. So by several states, they can only mean the territories of the United States and not the states of the Union. The term state includes District of Columbia, Puerto Rico, Guam, and the Virgin Islands of the United States. Substituting states definition in red into 8 CFR 215.1, we find the following. The term continental United States means the District of Columbia and the District of Columbia, Puerto Rico, Guam, and the Virgin Islands except Alaska and Hawaii. And removing the redundancy, we see that 8 CFR 215.1 definitions is the term continental United States means the District of Columbia, Puerto Rico, and Guam, and the Virgin Islands except Alaska and Hawaii. Subtuning the definition of continental United States above from 8 CFR 215.1 into 8 USC 1101A36, we see that the term United States, except as otherwise specifically herein provided, when used in a geographical sense, means the District of Columbia, Alaska, Hawaii, Puerto Rico, Guam, and the Virgin Islands of the United States. The reason Alaska and Hawaii appear above is because the statute refers to them only when they were federal territories under the E Justem Generis rule. And this rule is found in Black's Law Dictionary, 6th edition, page 517. E Justem Generis, of the same kind, class, or nature. In the construction of laws, wills, and other instruments, the E Justem Generis rule is that where general words follow an enumeration of persons or things by words of a particular and specific meaning, such general words are not to be construed in their widest extent, but are to be held as applying only to persons or things of the same general kind or class as those specifically mentioned. And the class that's mentioned is federal territory, or the federal zone. So what they're referring to is Alaska and Hawaii before they became constitutional states. The rule, however, does not necessarily require that the general provision be limited in its scope to the identical things specifically named, nor does it apply when the context manifests a contrary intention. Under E Justem Generis canon of statutory construction, where general words follow the enumeration of particular classes of things, the general words will be construed as applying only to the things of the same general class as those enumerated. Campbell versus Board of Dental Examiners. Alaska and Hawaii appear in 8 U.S.C. 1101A38 under the definition of United States because it refers to them when they were territories only. Because the Immigration and Nationality Act was enacted in 1940 and Alaska and Hawaii did not become states, constitutional states, until after that time. Hawaii became a state in 1959, as a matter of fact. So the E Justem Generis rule of statutory construction requires that all things of a similar kind be grouped together, and Alaska and Hawaii are listed with other territories of the United States. The end of the grouping says of the United States, meaning belonging to the United States as a territory. Alaska and Hawaii are not presently territories of the United States, and they do not belong to the federal United States government, since they were admitted as states in 1959. So the conclusions from this exercise are that the term Continental United States adds nothing to the statutory definition of United States and is redundant, and that the only reasonable purpose of adding Continental United States to the definition of United States is to deceive the reader into concluding that he is a statutory citizen of the United States instead of a constitutional but not statutory citizen, thereby unlawfully expanding the jurisdiction of the federal government to include persons in states of the Union and destroying this separation of powers. The federal government and the legal profession want to deceive constitutional citizens into falsely declaring themselves to also be statutory citizens in order to unlawfully and unconstitutionally enlarge their power, prestige, income, and importance, and jurisdiction. Important facts about citizenship. If you were born in a state of the Union, you shouldn't be looking in federal statutes to determine your citizenship status, because the Constitution only grants Congress the authority to establish uniform rules of naturalization under Article 1, Section 8, Clause 4. The Constitution does not grant Congress the authority to define the citizenship status of persons born in states of the Union, which are outside of their subject matter or territorial jurisdiction. And the states of the Union are foreign from the federal government for the purposes of legislative jurisdiction, as we have already said. And the laws of the federal government, therefore, do not apply inside states of the Union. And here's a confirmation from the U.S. Supreme Court in 1936, Carter versus Carter Coal Company, 298 U.S. 238. It is no longer open to question that the general government, unlike the states, Hammer versus Dagenhart, possesses no inherent power in respect to the internal affairs of the states, and emphatically not with regard to legislation. So their legislation does not apply inside of a state. Never has. Civil or criminal. Except possibly those things enumerated in Article 1, Section 8, which would be treason, for instance. That's about it. The term citizen of the United States or U.S. citizen are equivalent, but together they have two different meanings that depend on the context. In the Constitution, they both mean a 14th Amendment citizen who is born in a state of the Union. This is equivalent to a national described in 8 U.S.C. 1101-821, and in 8 U.S.C. 1401 in all federal statutes, that term, citizen of the United States, means a person born in the District of Columbia, which Mark Twain calls the District of Criminals, or territory of the United States. The above two distinctions are a result of the fact that we have two political communities in our country which have their own unique citizens, states of the Union and the federal government and its territories. The term national is also recognized in passports. And here is a photocopy of the inside cover of a USA passport. And notice the language they use to describe the holder of this passport. It says, the Secretary of State of the United States of America, meaning the states of the Union, hereby requests all whom it may concern to permit the citizen/national of the United States named herein to pass without delay or hindrance, and in case of need to give all lawful aid and protection. Now, this is confusing because most people don't know what a slash means in a legal context. If you look it up in the legal dictionary, you will find out that the slash means or. So what they're suggesting here is that you can have two statuses and still get issued a passport. You can be a citizen or you can be a national of the United States. Now keep in mind the context here. This passport is a political document. It is authored by the Secretary of State of the United States of America, not the United States, and therefore it pertains only to foreign affairs. And in the context of foreign affairs, we're talking a political and not a legislative context. This document is directed at a foreign country, usually. Those are the ones who look at these passports. And that is a political matter when they're dealing with foreign countries, not a legislative matter, because the laws of the United States legislatively do not apply outside its own territory, as we found out earlier. So this United States that they're talking about in the phrase citizen/national of the United States is a political United States. So it technically it means United States star, meaning the country. Why? Because this document is used in relations between countries to permit entry of a member of United States, the country, into another country. Okay? So this context here is very important to realize is a political context. Okay? So when they say citizen/national, they mean citizen or national. So you can be a national or a citizen, either one, if you want to be one. Okay? And so that's why we say, and the term national, as we use it in the context of 8 U.S.C. 1101 821, is a political status. It is not a legislative status. And it is political because no rights, no civil privileges, no obligations attached to that status anywhere that we have found in any code. And therefore, it is not a legislative status. It is not a civil status. It is a political status, which means it is only used in the constitutional context and not the statutory context. Moving on. So now we are going to cover the relationship between your domicile and nationality on the one hand, which we've been covering so far, and your tax or filing status with the national government on the other hand. So we prepared a table that deals with all the various possibilities that you can run into based on your domicile and your nationality, and it shows you what forms to file. So we've organized it as a table, and we said that earlier that domicile was the origin of your tax liability. We said that it was a civil liability and hence is implemented with the civil statutory law. And we said that you cannot have a civil status under the laws of a specific jurisdiction without a domicile in that jurisdiction. And that is per Federal Rule of Civil Procedure 17. So what we have in front of us is the three unique and different domicile conditions on the top that we can be in relation to any given specific government. So the first condition would be if we are domiciled within the territory of that government and physically located there. The second one, or the second column to the left, is if we're domiciled within that government and we're temporarily physically located outside the territory of that government. And then the third condition is if we're domiciled outside that government and physically located outside that government. Most people would call that condition non-resident on the rightmost column. And then on the left, we have various conditions that are affected by each of those domicile conditions across the top. So for instance, location of domicile. The first column, you're domiciled on federal territory and they're physically located there. So in that condition, you are domiciled in the statutory United States, quote unquote, which is described in 26 U.S.C. 7701 A9 and A10 and 7701 A39 and 7408D. Same thing if you're still domiciled in federal territory, but you are physically located outside that territory, you're still domiciled in the statutory United States. And then if you move outside the United States and change your domicile, then you're domiciled without the statutory United States. The next row, we have your physical location. So if you're domiciled in the federal zone, we call it the federal zone across here, and by that we mean the territories of the United States government. So your physical location, if you're domiciled and physically within the federal zone, would be federal territories, possessions, and the District of Columbia. If you're domiciled within the federal territories, but you are physically located outside of them, this particular column deals with the situation where you're located abroad in a foreign country only. It doesn't deal with any other location, because that's the only condition in which you can continue to have a liability if your physical location is outside the federal zone. And otherwise, the state jurisdiction takes over, states of the Union. So in this case, you're domiciled in foreign nations only and not states of the Union. And then if you are without the federal zone and you're domiciled without the federal zone, then you could be in a foreign nation, in a state of the union, or in a federal possession. Your tax status, if you're domiciled within the federal zone, is that you are a statutory U.S. person, and that's described in 26 U.S.C. 7701, and that's true for both cases where you're domiciled in the federal zone. You're a U.S. person. If you change your domicile to be outside the federal zone, then you become a non-resident, and the only non-resident status in the Internal Revenue Code is that of a non-resident alien, and it's described in 26 U.S.C. 7701B1B. The tax forms you file while you're domiciled in the federal zone in these leftmost two columns is the 1040, and the only difference when you go abroad in the center column here is you also file the 2555. Now notice that this center column does not include states of the union, because if you're in a state of the union, you'd basically be in the same condition as a non-resident. And by in a state of the union, we mean domiciled in the state of the union and located in the state of the union. So the national government cannot conduct an income tax upon those who are nationals of the United States within states of the union. They're not allowed to. They can only do it when they're abroad. And that's why the only provision that even mentions a citizen in the Internal Revenue Code is 26 U.S.C. 911. So if you're domiciled outside of the federal zone and physically located outside the federal zone, then you would do one of two things. If you were a human being, you would file the 1040 NR, and you would be a non-resident alien individual if you were public, meaning if you're engaged in the trader business franchise, which we call the public office franchise. If you were not a public officer, meaning if you were private, then you wouldn't be an individual or a person, and therefore you wouldn't be subject to the Internal Revenue Code, because the franchise only pertains to those lawfully engaged in the office. And the office is called person and individual, and those who consent to act in the capacity of persons and individuals, all of whom are offices, then become subject to the code and through no other means. And if they are not engaged in the office, they would have no filing requirement at all, and they would be a non-resident non-person. And at the bottom two rows here, we show the statutory status of people in each condition. So if you, in the first row here, is the status if you're a national of the United States, star, per 8 U.S.C. 1101-822. And a national of the United States star is someone who owes allegiance to the country United States. So that term, allegiance, is equivalent and is defined as, quote, national, unquote, in Title 8 of the U.S. Code. That's what a national is someone who owes allegiance, and that's defined in 8 U.S.C. 1101-821. So on the first column, if you were born anywhere in the country or naturalized anywhere in the country, and you are domiciled in the federal zone, you would be a national and citizen of the United States at birth, per 8 U.S.C. 1401 if you're born in a federal territory. And if you were not born in a federal territory, but you were born somewhere in the country and you were domiciled on federal territory, you would be called a citizen of the United States, star, meaning a citizen of the federal territory. That's what we would also call a statutory citizen, and that's described in 8 U.S.C. 1101-A22B if you're born in a state of the Union. And neither one of these statuses requires that you file if you're physically present in the United States. You have to be abroad in the second column here in order to have a filing requirement. And likewise, if you then physically move abroad but retain your domicile in the federal zone, then you'd be called a citizen abroad, and you would be described in 26 U.S.C. 911 of the Internal Revenue Code. And if you then change your domicile to be outside of federal territory or the federal zone, and you physically move outside of federal territory and the federal zone, then you could be one of two things over here on the right. You could be a non-citizen national, as described in 8 USC 1101A22B, if you're born in the State of the Union, or if you're born in a possession, you would be called uh, a non-citizen national of the United States, ***, and that's described in 8 USC 1408 and 8 USC 1452. Likewise, if you are a foreign national born in a foreign country, you are described in 8 USC 1101A21, and that statute describes a person owing allegiance to a state, and which is foreign because it's lowercase. So if you were a foreign national and you're born in a foreign country and you're domiciled in the federal zone, you would be called a resident alien. And these people would have green cards, for instance, and they would be called permanent residents, and they're described in 26 USC 7701B1A. If they then change their physical location to abroad but retain their domicile in the federal zone, they would be called a resident alien abroad, and they're described in 26 USC 911 just like the citizen abroad would be. And then if they change their domicile and their physical location to be outside the federal zone, they would be called, their civil status would be a non-resident alien individual if they're a public officer in the U.S. government, and they're described in 26 CFR 1.1441-1C3II. And if they are not a public officer in the government, they would be called a non-resident non-person, because as we said, person and individual and citizen and resident and taxpayer are all franchises within the Internal Revenue Code, and all franchises at least create the appearance that those participating are public officers in the government. And the reason is because a public officer is defined in Black's Law Dictionary as somebody in charge of the property of the public, and every franchise, it constitutes a loan of state property to you for your temporary use. And so you become a borrower, and the borrower is always servant to the lender. And once again, the Supreme Court has declared that the ability to regulate private conduct and private rights is repugnant to the Constitution. So the only way they can reach you is for you to transition from being private to public. And that status that you would acquire when you transition to public would be a public officer. Moving on. We also have a list of notes that pertain to that chart. You probably want to read these carefully. They talk about the definitions. They talk about the statutory United States as defined as the District of Columbia and no part of any state of the Union within 26 USC 7701A9 and A10, 7701A39, and 7408D. And the District of Columbia itself, within that definition, is then defined as basically a federal corporation and not a physical place or a body politic or a de jure government, and the District of Columbia Act. And nationals of the United States of America who are domiciled outside the federal jurisdiction, either in a state of the Union or in a foreign country, are nationals but not citizens under federal law. And that's proven in our pamphlet, Why You're a National, State National, and Constitutional but Not Statutory Citizen, Form 05.006. Temporary domicile in the middle column on the right must meet the requirements of the presence test documented in IRS publications. They're also documented in 26 USC 7701B4. And the federal zone equals the District of Columbia and the territories of the United States. And all nationals but not citizens above in the right column are also classified as non-residents. They are also non-resident non-persons under the Internal Revenue Code. And we also emphasize that the term individual, as used in IRS Form 1040, means a statutory alien engaged in a trade or business, meaning a public office. All statutory taxpayers are aliens engaged in a trade or business. This is conferred by 26 CFR 1.1441-1C3, 26 CFR 1.1-1A2II, and 5 USC 552A, paragraph A2. Statutory citizens, as defined in 8 USC 1401, are not individuals unless temporarily abroad pursuant to 26 USC 911 and subject to an income tax treaty with a foreign country. In that capacity, statutory U.S. citizens interface to the IRC as aliens rather than U.S. citizens through the tax treaty. So next, we're going to show you a chart that compares your citizenship status in Title 8 on the left with your status under the Internal Revenue Code, Title 26. So there are 4 different unique statuses you can have under the Internal Revenue Code on the right here. So we have 4 columns. And then on the left is all the Title 8 conditions that go with that status. And this first page covers all the various statuses you can have if you're born in federal territory. So item 1 here would be what is classically called a statutory citizen. And the code describes this person in 8 U.S.C. 1401 as a national and citizen of the United States, ***, meaning federal territory, at birth. We also call this a U.S. citizen or a statutory U.S. citizen. And the United States, for the purposes of U.S. in that term, is described in these statutes. And this particular chart also deals with not only your place you're born and your status, but also where you're domiciled, because your domicile has an effect on your status. Remember, we cannot have a status in a place without a domicile there, a civil status. So you have to take into account the domicile of the party so you can show how it affects the status on the left here. So, and then this other column is whether you're accepting treaty benefits in that place. And the treaty benefits are only available if you're in a foreign country, that is a country other than the United States of America. So this particular person is born on federal territory in a District of Columbia or Puerto Rico or Guam or the Virgin Islands. They're described in 8 U.S.C. 1401. And for the purposes of the Internal Revenue Code, they would be classified as a citizen. And they're described in the Treasury regulations in 26 CFR 1.1-1. And the other condition you can have if you're born in somewhere in the federal zone would be a non-citizen national of the United States, *** at birth. And ** meaning federal territory. And these people are domiciled right now. We show them domiciled in American Samoa, Swains Island, or abroad to U.S. national parents under 8 U.S.C. 1408. So because they're in the federal zone, then they're not accepting a treaty benefit because treaties don't apply in the federal zone to people who are from the federal zone. So they're described in 8 U.S.C. 1408 and 8 U.S.C. 1101A22B and 8 U.S.C. 1452. And these people would be classified as non-resident alien individuals. And you can actually look at the 1040 NR form itself, and it specifically mentions these people as being non-resident aliens. So the next group of people are people born in the states. And you can see their place of birth is states right here in this column, place of birth. And they have various domiciles they can have after they're born. So we have to account for all those. And these people are called statutory non-citizen nationals, or USA *** national, or state national, or constitutional but not statutory citizen. So these people are described in 8 U.S.C. 1101A21 and 8 U.S.C. 1101A22B and the 14th Amendment. And these people are classified as non-resident, non-persons, meaning they're not public officers in the government, because persons and individuals are public officers in the national government under the public officer franchise found in Title 26 of the U.S. Code. So next, if they started out in a state of the union domiciled there and then they changed their domicile to a foreign country, they would still have the same definition for that status in Title 8, but they would transition to, and by the way, they're accepting a treaty benefit, so they would transition from being a non-resident non-person up here to a non-resident alien individual. And the reason they would acquire the individual status under Title 26 is because they're accepting a benefit. A treaty is a franchise, and therefore it is a benefit, and therefore they are public officers accepting the benefit, and therefore they would be subject to the code. Whereas the line below would be the condition when they're not accepting the benefit, and then they go right back to non-resident non-persons again. So do not accept any franchises or benefits from the government, because it affects your status and the enforceability of the government's laws. If you don't accept any favors from them and you don't have a domicile in their territory, then you don't have any contracts or implied contracts or agreements with them. So the last condition of a state citizen, a person born in a constitutional state here, would be if they are domiciled on federal territory. And in that scenario, they would be citizens under the Internal Revenue Code. And only in that condition would they also be called statutory citizens. And that statutory citizen is mentioned in 8 U.S.C. 1101A22A. Now, and it's described as a citizen of the United States, **, meaning federal territory. Now, keep in mind that they would not be an 8 U.S.C. 1401 citizen, because that is a citizen, a national and citizen of the United States at birth. They were not born on federal territory, so they would not fit that classification. So this is the only classification they can fit, which is 8 U.S.C. 1101A22A. And in that scenario, they would be a citizen under the Internal Revenue Code, and only that scenario. And so they would file a 1040 under that scenario, and they wouldn't file anything under any other scenario unless maybe they accepted a treaty benefit while they were abroad outside the country, and then they would be a non-resident alien individual, and they'd file the 1040 NR. So the last group of people we have to deal with are foreign nationals, people born in a foreign country. And they're called aliens under Title 8, or foreign nationals. And they can be domiciled in a lot of different places within the country. They can be domiciled in Puerto Rico, and when they are, they're called aliens, 8 U.S.C. 1101A3. They're also called nationals, 8 U.S.C. 1101A21. And if they are domiciled on federal territory, they would be called resident aliens here. And here are the statutes if you want to find out where the definitions are for that status. If they then change their domicile from a federal territory to a state of the Union, and they accept a treaty benefit here in this column, then they're accepting a franchise, so they're a public officer, and therefore they are non-resident alien individuals because the states are outside of federal jurisdiction. They're foreign and alien for the purposes of legislative but not constitutional jurisdiction, and so they would be non-resident alien individuals because they're accepting a treaty benefit, a franchise, as a foreign national, and therefore they're public officers. If they then abandon the treaty benefits here in the next row, but they retain their domicile in the state of the Union, they become non-resident non-persons, so they're non-privileged, so they're not individuals or persons. And if they then change their domicile to a foreign country and they accept the treaty benefit there, then they would be non-resident alien individuals for any business that they do within the country, United States, or within the federal zone actually. And then if they then change their domicile to a foreign country and they're born in a foreign country and they abandon the treaty benefits, then they would be a non-resident non-person, just like a state citizen would be, for the purposes of the federal zone tax liability. So next, we're going to cover with a diagram to make it crystal clear all these relationships, the relationships between domicile and no domicile in the federal zone. So the bottom we have people domiciled in the federal zone. On the top we have people domiciled outside the federal zone, either in states of the Union or in foreign countries. And as we said before, domicile is the origin of your tax liability, and if you're domiciled outside of the federal zone, then you couldn't have a tax liability. And of course, there is one exception to that, and that is you represent an office that's domiciled in the federal zone, such as a public office, which is covered in Title 26 of the U.S. Code, Trade or Business Public Officer Franchise. So there are two groups of people in the top and the bottom. There are people who are members of the country, and these people are called nationals of that country. And then there are people who are not members of our country, and these are foreign nationals. And likewise, we have the national types here, and the foreign nationals here. So if you start out as a foreign national, and you change your your domicile outside the federal zone, and you change your domicile to within the federal zone by filing a declaration of domicile, then you become a statutory resident alien, 26 USC 7701B1A, and you also become an alien, 8 USC 1101A3. Now, keep in mind, you cannot be an alien under federal law unless you're physically on federal territory. If you're not on federal territory, then you're not anything because you don't have a domicile there. And civil status is conveyed only through the domicile mechanism. So, and this same foreign national can naturalize himself or herself, and they would join the group of nationals, members of the country, and those members include constitutional citizens or nationals and statutory non-citizen nationals of the U.S. ** at birth, which would be born in possession. So you could, once you're naturalized, you could, since you're not born in the country, you really wouldn't fit either one of these two, but unless you're naturalized in those specific places. So if you were naturalized in a constitutional state, you would be equal to all the other constitutional citizens in that state. So you would probably fit in this scenario. Likewise, this group of members of the country can expatriate through the authority of 8 U.S.C. 1481 to restore their condition as foreign nationals, which we also call constitutional and statutory aliens. And likewise, if you are a constitutional citizen / national of the U.S. ***, meaning states of the Union, you're described in 8 U.S.C. 1101A21 in the 14th Amendment. And if you could theoretically change your domicile, and if you did, this little arrow down here shows how you'd do it. You'd file the Form 1040 in the W-4, and then you would join the group of members of the country down here on the bottom who are domiciled in the federal zone. And all of those members have the condition described in 8 U.S.C. 1101A22A, which is described as a citizen of the United States ***, meaning a federal zone domiciled human. And so these people are also called statutory citizens of the United States ** here. So this whole group of people is this, and a subset of those people is statutory national and citizen of the United States ** at birth. So if you're born in a federal territory, then you would be an 8 U.S.C. 1401 citizen, but you could still be a citizen of the United States without being an 8 U.S.C. 1401 citizen. And that would pertain to people who were born in a constitutional state, or people who were born in a possession over here and who changed their domicile to the federal zone. And because they weren't born in the federal zone, but they changed their domicile there, then they wouldn't be 1401 citizens. They would simply be citizens of the United States under 8 U.S.C. 1101A22A. And likewise, if they then change their domicile back to the state they were from, then they will go right back here. Okay, and they do that by filing a Form 1040-R and a W-8 to go back. Okay. Likewise, a person from a possession, born in a possession, who changes their domicile to the federal zone operates exactly the same as a person from a state. They would simply become statutory citizens of the United States ***, and when they change their domicile back to the possession, same thing. Now we also show here that if you're born in a federal territory, statutory, national, and citizen of the United States at birth, then and you change your domicile to be outside the federal zone, then you would basically go inside this box. Notice where the arrow points. It points to the entire box, because which specific locality that you would change to would be up to you, and it still wouldn't make you one of these or one of these necessarily. So we point to the box as a whole, meaning you're still a member of the country, but you have a foreign domicile. So, and you do that with the change domicile to without the United States by filing a 1040 and R to W-8. And likewise, if you move to the, let's say, a constitutional state here, then and then you changed it back to the federal zone as somebody born in the federal zone, territories, that is, then you would file a 1040 and a W-8. So, and likewise, people born in the federal zone, federal territory to be precise, as a group here, or resident therein, could expatriate, same as they can up here, to become statutory resident aliens. And if they started out as statutory resident aliens, then they could naturalize under 8 U.S.C. 1421 to go back to being a national of the country, or a national of the United States star, meaning the country, not the federal zone. And collectively, all these people domiciled on federal territory, whether they're foreign nationals on the right or domestic nationals on the left, domestic meaning United States star, would be called U.S. persons in the Internal Revenue Code, 26 U.S.C. 7701A30. And all of these people are described in 26 U.S.C. 911D3, tax home, for federal, and their tax home for federal officers, federal employees, and federal elected officials serving within the government. And we also recommend that you read the case of Cook versus Tate so you understand how all this works. Moving on. Now we're going to show you one more type of diagram that will make all of these relationships even clearer. And we'll start the diagram with a quote from the Supreme Court, Hooven and Allison versus Evatt, 324 U.S. 652, which was the last case where they described the three types of United States. And we will quote these conditions or statuses of United States in the diagram. So what they said was the term United States may be used in any one of several senses. It may be merely the name of the sovereign occupying the position analogous to that of other sovereigns in the family of nations, meaning the country, United States, or it may designate the territory over which sovereignty United States extends. That's federal territory. We call that United States star star, and or United States 2. And then 3, it may be the collective name of the states which are united and under the Constitution. And so we call that United States star 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 or United States 3. And so we actually have labels here for those. The options for above are US 1, context used in matters describing our sovereign country within the family of nations. US 2, context used to designate the territory over which the federal government is sovereign. United States 3, context used regarding the sovereign states of the Union, united by and under the Constitution. Now let's put the various federal statutory citizenship statuses into a diagram and make their relationship crystal clear starting on the next page. So here are the three United States up here, 1, 2, and 3, and we drew a Venn diagram because some people are visual learners to help you cement these things. And within each circle is a specific status or condition and or territory. So US 1 is the country. That's the big circle. And then US 2 is the federal zone, or US star star is what we call it. And then US 3 is the states of the Union on the bottom. So on the top, we have all the federal zone people with a domicile on federal territory and or who were born on federal territory. And within each circle, we describe all of the statutes and statuses that relate to these people. So a statutory national and citizen at birth, which we said was an 8 U.S.C. 1401 citizen, would be domiciled in the District of Columbia or territories belonging to the U.S. here. A statutory national but not citizen at birth would be described in 8 U.S.C. 1408 and 8 U.S.C. 1452, and they're domiciled in American Samoa and Swains Island. And then a constitutional citizen would be /national would be 8 U.S.C. 1101A21 in Title 8. They're described in the 14th Amendment and in the Law of Nations, and they're domiciled in the constitutional but not statutory states of the Union. And there's some overlap among all these. So you can see they all overlap with the status of 3, and that condition down here is identified as 8 U.S.C. 1101A22, National of the United States 1. And so what that means is they owe allegiance to the country, United States, because a national is somebody owing allegiance, and United States 1 means the country, the nation, United States. So everybody owes allegiance to the country who was born anywhere in a state of the union or on federal territory or in a possession or elsewhere within the nation, United States. So they're all nationals of the United States under item 3 here. United States 1, that is. Okay. So, but the statutory national but not citizen at birth overlaps with constitutional citizens with Circle 5. So if we come down here, that would be called an 8 U.S.C. 1101 A22B, non-citizen national of the United States, star. And it's star because it includes people from United States 2 as well as United States 3, because US 1 includes 2 and 3. Okay, so we can also see that a constitutional citizen is described with Circle 1, which is a national, because they owe allegiance to a state, and that state is lowercase in that statute. So it's a foreign state, legislatively foreign with respect to the national government. And we can see that statutory national and citizen at birth is described in with 4 and 2 circles. So 2 would be 8 U.S.C. 1401, national and citizen of the United States 2 at birth. So this is the federal zone person born in the federal zone territory. And then 4, which is 8 U.S.C. 1101 A22A, which is a citizen of the United States 2, star star. So that would be a territorial citizen, domiciled on federal territory. So, and then if outside, we have people, Americans domiciled abroad. So in other words, they're outside the geographical US 1. So they're domiciled abroad, and they could either be a national, Circle 1, or they could be Circle 5, which is a non-citizen national of the United States. So if you go abroad, then you're a non-citizen national of the United States 1, meaning the country, United States. And that simply means that as a national, you have allegiance, but you're not a citizen because you're not domiciled there, and therefore you can't have a civil statutory status. The other thing we want to emphasize here is that Circle 3 here, which is national of the United States 1, that is a political status. It's not a civil status. So it's political because it involves allegiance. National means allegiance, and allegiance is political. So it's a political status. It's not a civil. It's not a civil status, and by that we mean it doesn't carry with it any civil obligations or privileges or public rights. It's simply a status that doesn't attach to any obligations. Okay, for instance, the requirement to file a tax return when you're abroad attaches not to a national of the United States. It attaches to a citizen of the United States. And the citizen status is a civil status, whereas the national status is not. So it's very important to distinguish what you're talking about as far as whether it's a civil status or a political status. Civil statuses can carry obligations and privileges. Political statuses cannot, in and of and only of themselves. So, how do I become a national or state national? If you were born in a state of the union or outside the country to parents at least one of whom was a state national or national, and you didn't expatriate your citizenship then you already are a national or a state national. And even if you were born in the federal zone and started out as a statutory citizen, if you change your domicile to be outside the federal zone in the state of the union, you become a national or state national and lose your statutory citizen status. 8 U.S.C. 1401 has a prerequisite for statutory citizenship, which means subject to the legislative and not political jurisdiction. What they really meant was subject to its jurisdiction, which means the exclusive legislative jurisdiction of the United States government. This language is similar to that of the 14th Amendment, Section 1, but has a different meaning. In the 14th Amendment, subject to the jurisdiction means the political and not legislative jurisdiction. And the Supreme Court helped to clarify this in U.S. versus Wong Kim Ark, 169 U.S. 649. This section, that is Section 1 of the 14th Amendment, contemplates two sources of citizenship and two sources only, birth and naturalization. The persons declared to be citizens are all persons born or naturalized in the United States, and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, meaning federal territory, but completely subject to their, that is, multiple states, political and not legislative jurisdiction, owing them, that is, the states of the Union and not the federal government, direct and immediate allegiance. And the words relate to the time of birth in the one case as they do to the time of naturalization in the other. Persons not thus subject to the jurisdiction of the United States at the time of birth cannot become so afterwards except by being naturalized either individually as by proceedings under the Naturalization Acts or collectively as by force of a treaty by which foreign territory is acquired. To be completely subject to the political jurisdiction of the United States is to be in no respect or degree subject to the political jurisdiction of any other government. And what they mean here is that you don't have divided allegiance. You only owe allegiance to one government. And this was U.S. versus Wong Kim Ark, 169 U.S. 649. You must have a civil domicile in a place to be subject to the civil laws of that place. Therefore, you cannot be subject to the legislative statutory jurisdiction of the federal United States unless you have a civil domicile on federal territory. And that is proven in Why Domicile and Becoming a Taxpayer Require Your Consent, Form 05.002 on our Forms page. How can you inform the government that you have this status and get proof of it? Apply for a U.S. passport as a national and do a Freedom of Information Act request for the DS-11 passport application and ask to have it certified. Keep that in a safe place as evidence. And register to vote as a national and have the registration form notarized and keep this as evidence. We have a sample application on the Federal Family Guardian website. And you can also serve on jury duty as a national by filling out the jury summons indicating that you are a national and a constitutional citizen under the 14th Amendment, but not a statutory citizen of the United States under 8 U.S.C. 1401. You can also petition your state government for a declaratory judgment to declare you as a national of blank, where the underline is the name of your state. For further information on correcting government records to reflect your true status as a national, see Developing Evidence of Citizenship and Sovereignty, Form 12.002 on our Forms page, Legal Notice of Change in Citizenship and Domicile Records and Divorce from the United States, Form 10.001, and Sovereignty Forms and Instructions Online, Form 10.004, Instruction 3.13, and Sovereignty Forms and Instructions Manual, Form 10.005, Section 2.5.3.13 on our Forms page. And finally, why you are a national, state national, and constitutional but not statutory citizen, form on our Forms page. State nationals and federal taxes. Nationals or state nationals are non-residents. If nationals are present in the United States whether physically or legally, then they are also non-resident aliens under 26 U.S.C. B1B. Nationals or state nationals file Form 1040 NR. It says U.S. national on the 1040 form, but nationals have the same rights as U.S. nationals, and even though they are not exactly the same. Nationals and state nationals pay taxes as follows. Gross income, which is effectively connected with a trade or business in the federal United States, meaning the federal zone, under 26 U.S.C. 871B. This is a graduated rate of income tax. Trade or business equals public office. And gross income from within the federal United States not connected with a trade or business at a flat rate of 30% under 26 U.S.C. 871A. This would include mainly Social Security and other federal entitlements. But one cannot earn gross income until they first earn income, and the U.S. Supreme Court has never defined income to mean anything other than corporate profit because the income tax is an indirect excise tax on corporate privileges, associated with foreign commerce and defined in 26 U.S.C. 7001. 26 U.S.C. 872A says only earnings from the United States, which is the District of Columbia, and possibly federal territory, are subject to tax. And 26 CFR 1.872-2F says that non-resident aliens with no trade or business earnings earn no reportable gross income. So if you're not engaged in a public office, then you don't have any earnings that can be taxed. And that's consistent with the reporting requirements for information returns themselves, as we said in 26 U.S.C. 6041A. State nationals who have no earnings from the United States government or connected to an excise taxable activity called a trade or business under 26 U.S.C. 871. These people are non-taxpayers not subject to the Internal Revenue Code or the jurisdiction of any federal court in the context of their earnings, and they cannot use the IRS Form W-4 without committing perjury under penalty of perjury, which is a crime, and they are not liable to deduct kickbacks on their earnings or withhold, and they are not required to file the Form 1040-NR, and they need not withhold. 31, and that's found in 26 CFR 31.341A6-1, remuneration for services of non-resident alien individuals. Remuneration for services performed outside the United States, and this United States is United States star, or United States, which is the federal territory or the United States government. Remuneration paid to a non-resident alien individual other than the resident of Puerto Rico for services performed outside the United States is accepted from wages and hence is not subject to withholding. So if you're outside the United States, and if United States here means the government in a legal person sense, then if you're not inside the government as a public officer, then you're not subject to withholding. So the only people who can do withholding on a W-4 or W-2 is the government. And that makes perfect sense because if you look at the levy statutes in 26 U.S.C. 6331, it says levy may be made upon any agency or instrumentality or employee of the government. The United States government. They cannot levy private compensation. And a private human domiciled outside the federal zone is not even a person under the statutory laws of Congress if they're not engaged in a trade or business. Reasons for correcting government citizenship records. The main reason to correct government records containing false information about our citizenship are the following. We want to restore our sovereignty. Under the Foreign Sovereign Immunities Act, 28 U.S.C. 1603B, and under 28 U.S.C. 1332 C and D, a legal person cannot be classified as an agency or instrumentality of a foreign state if they are a citizen of a federal state of the United States, meaning a person born in a federal territory, possession, or District of Columbia as defined in 4 U.S.C. 110D. This conclusion is also confirmed by the Department of State website. So in other words, you cannot assert sovereignty or sovereign immunity if you're domiciled on federal territory. You are a subject, just like any British subject in Great Britain. Because the Supreme Court said in Downs versus Bidwell that federal territories are run more like a British crown colony than a Republican state of America, because Congress owns federal territory and everybody who stands on federal territory is not protected by the Constitution, and everything that happens on federal territory is a privilege and not a right. And they can regulate privileges all they want. Another reason to correct your citizenship records is to remove yourself from some aspect of federal legislative jurisdiction. A citizen under federal law is defined as a person subject to federal jurisdiction. This is covered in Great Irish Hoax Form 11.302, Section 4.11.2, for instance. Another reason is to make sure that a person's domicile cannot be involuntarily moved to the District of Columbia. Both 26 U.S.C. 7701A39 and 7408D allow that a person who is a citizen or resident under the Internal Revenue Code, meaning a statutory citizen, should be treated as having a domicile in the District of Columbia for the purposes of the federal jurisdiction. Since kidnapping is illegal under 18 U.S.C. 1201, then a person who is not a citizen or resident under federal law needs to take extraordinary efforts to ensure that their citizenship is not misunderstood or misconstrued by the federal government by going back and making sure that all federal forms which indicate one's citizenship status are truthful and unambiguous. The process of correcting government forms relating to citizenship is described in Section 3.5.3.13 of the Tax Fraud Prevention Manual. Warning on citizenship. Citizenship is not the major factor determining tax liability. The major factors are domicile. And we showed that earlier in Why Domicile and Becoming a Taxpayer Require Your Consent, Form 05.002 on our forms page. And the excise taxable activities and franchises one voluntarily chooses to engage in determine your tax liability. So first, you must have a domicile in the place where the taxes apply. And second, after you have the domicile, you must engage in an activity subject to taxation within the geography covered by that domicile. And these two are inseparable. You cannot have one without the other. You cannot engage in an activity without having a domicile. But you can have a domicile without engaging in the activity. You can be domiciled on federal territory and not be in a public office. And if you are, then you're not a taxpayer. And we cover this in the Trade or Business Scam, Form 05.001 on the forms page. And the Great IRS Hoax, Form 11.302, Sections 5.1 through 5.1.11 also covers this subject on the forms page. More warnings, important warnings about citizenship. How we describe our statutory citizenship is affected by our choice of domicile, but domicile and not constitutional citizenship is the origin of our tax liability. A person born in a place who has a domicile there is called a citizen. If that place is a federal zone and no part of a state of the union, he or she is a statutory U.S. citizen pursuant to USC 1401, but not a constitutional citizen mentioned in the 14th Amendment. A person born in a place who does not have a domicile there is a national but not a citizen pursuant to 8 USC 1101A21. Therefore, anyone who promises to eliminate your tax liability by changing or correcting your citizenship status is simply mistaken, and you should not listen to them. So what we're trying to say here is your citizenship status is a product of your domicile, but domicile is the origin of the liability, not the citizenship status. Don't confuse those two. So get free and sovereign. If you want to apply what you have learned here today to your specific situation to become free and sovereign, then we recommend the Path to Freedom, Form 09.015 on our forms page, and the SEDM Liberty University, which is a complete free curricula on freedom and sovereignty on our website at this link. And you can click any of these blue links throughout our presentation. So let's talk about us as a ministry. The Sovereignty Education and Defense Ministry was founded in 2003. It is a nonprofit Christian religious ministry. The mission statement is found on our About Us page. And the Articles of Mission, Form 01.004, is available on our forms page that describes in detail what we do and why we do it. We are managed by a board of ordained ministers. Ministry offerings are completely consistent with the materials found on the Family Guardian website, and educational course materials are only available to members who must be non-residents and non-taxpayers not engaged in the trade or business franchise and who believe in God. And all educational materials are obtained online only. We do not ship physical product, typically, with very few exceptions. A signed member agreement, Form 01.001, is required to join or obtain any ministry offerings, and we are based out of, but not domiciled within Canada and outside the jurisdiction of the United States government. We focus exclusively on human beings and not civil statutory persons or businesses. And see our About Us page for further details on our ministry. And see our Frequently Asked Questions page, FAQs, which answers most questions to or about us. And we want to emphasize that we do not interact directly with the IRS on your behalf. We do not offer asset protection, trusts, or corporation souls. We do not represent anyone using IRS Form 2848 Power of Attorney forms because we don't want to represent somebody who's a public office, and you can only use IRS forms for taxpayers, and we don't deal with taxpayers. We do not prepare or advise in the preparation of tax returns for anyone. We do not offer educational materials or services to taxpayers, U.S. persons, U.S. residents, or any instrumentality of the federal government, including especially public officers. And by educational materials here, we mean tax-related educational materials. If you're not dealing with the tax issue, we don't care, about which educational materials you use. We're only concerned about it in the context of taxes, because we don't want to interfere with the lawful administration of any revenue law or code. We do not provide legal advice or representations, but do provide assistance of counsel. See our memorandum on unlicensed practice of law, Form 05.029. We do not connect ourselves with a trade or business in the United States, where United States means the government and not a geographical place. We do not offer any kind of investment or tax shelter or engage in any kind of commerce. We do not engage in factual or actionable speech. All of our offerings constitute religious beliefs and opinions that are not admissible as evidence pursuant to Federal Rule of Evidence 610. Only you can make them admissible as evidence by signing them under penalty of perjury as part of an affidavit. And at that point, it's only factual for you and whoever signed, and not us. And we do not advocate or endorse any of the flawed tax arguments identified by the courts in the following document on our website, Flawed Tax Arguments to Avoid, Form 08.004. So how do you get connected? You can connect to us through Family Guardian website, because they have a lot of links to us. You can go, which is a sister site. We are not responsible for that Family Guardian website. If you have questions about them, or if you need help about their materials, please post in their forums and not ours. You can also visit us on the web at http://setm.org. If you want to get engaged in a more political sense, then you can go to We the People Foundation for Constitutional Education at http://givemeliberty.org. You can also visit other freedom websites. There are many. These are a very small subset. We didn't want this list to be too large. USA the Republic at this link. Show Me the Law at this link. The National Organization to Stop Socialism Now, nossn.com. And you can also learn how to read and research the law by going to the following links on either our site or the sister site. Legal research sources on this link. The Legal Research DVD contains thousands of pages of U.S. codes and constitutions and franchise documents and so on. The Cornell University Legal Information Institute, LII, website. You can also visit the ECFR, Electronic Code of Federal Regulations, if you want to learn about federal regulations. You can visit the Versus Law to do your case research. It's fee-based. It's very inexpensive, and it's a great resource for people who don't study and read the law all the time, and they're available at versuslaw.com. And finally, you can visit FindLaw at findlaw.com, and they have constitutions, statutes, lawyer contacts, and so on for a lot of different subjects. But we warn you that they have less law on their site than we have on our site, which is kind of ironic. So this concludes our presentation. We're sorry if it was a bit long, but this is a very complicated subject. We're sorry if it's repetitive, but repetition is the way many people like to learn. And these are very important subjects, which is why we repeated them, so you'll remember them. And if you don't remember this presentation, then you can go back and reread it and rewatch it. You can download the slides and watch it again, because you may need additional repetition for all of the concepts to sink in. Thank you very much for watching this presentation. We wish you the best of luck in your efforts to defend your own freedom, liberty, and sovereignty. And God bless you all.